Okay. Good morning, everyone. It's great to have you here. My name is Maciej Bernat. I am a professor at the University of Warsaw and the head of the Center for Antitrust and Regulatory Studies. And I had a pleasure to co-organize this conference with Wiśniewski Foundation and Polish Academy of Sciences. Yesterday, I think it was really a great discussion that basically shed a lot of light on the challenges we are facing today as a democratic society. And one of the key questions I think we will try to answer today during this conference is really to consider what role can be played by economic laws, broadly defined. Because the original idea, if you think about competition law, was that its main role is basically to correct markets. But can they play, or maybe should they play any role vis-a-vis democracy? So the conference today consists of keynote, and I will introduce the President van der Woude briefly, and then we will have 3 panels, and the idea is to walk you through kind of more general aspects and older regimes. So we will start with competition law and a broader perspective. Then kind of narrowing down the perspective to newer legal regimes and the challenges that are posed by how markets operate, by how digital markets operate. And the third, so the second panel will be particularly focused on gatekeepers, discussing also aspects concerning media markets, and the panel 3 will be dedicated to AI specifically. So let me now welcome President Mark van der Woude, President of the General Court of the European Union. We are honored to have you with us. Many thanks for accepting our invitation. President van der Woude has amazing career. He graduated in law from Groningen University in 1993, and then from College of Europe in 1994. And if you look, if I can say so, at his career path, it's amazing how you can see both the experience as a practitioner and an academic working together. So President van der Woude taught and researched in College of Europe at the University of Leiden. And then he became the professor at the Erasmus University Rotterdam. He also practiced law in the Commission, in the DG competition, and in the Commission legal service. He also served as a referendar in the Court of Justice. From 1995, he joined the Brussels Bar and practiced competition law. And Judge van der Woude was appointed in General Court in 2010. Became the president of the chamber in 2013, vice president in 2016, and is a president since 2019. And I don't think that this audience requires any introduction why General Court is a key player for the topic we are discussing. So, President, we would like to welcome you, and the keynote is entitled "The Dilemma of Liberal Democracy in the History of the Market: A Tribute to Giuliano Amato." Please, the floor is yours.
Thank you, Professor Bernhard. Ladies and gentlemen, first I would like to thank the University of Warsaw, the Polish Academy of Sciences, and the Wisniewski Foundation for inviting me at this conference. It's really an honor and a pleasure to be here in the presence of so many distinguished guests and speakers. But it's also a challenge, speaking about a very important topic. Regulation of markets in defense of democratic principles is not an easy task. There is another element which makes this meeting, I think for me, very important, which is the involvement of the Wisniewski Foundation. I missed yesterday's event and the speech by Commissioner Jourová, the comments by Eleanor Sharpston, the prizes and the address by Professor Kur in honor of Irena Wisniewska-Bieleszka. But I would like, before speaking, compliment a bit what was said, well, might have been said yesterday. I had the pleasure to work with Irena Wisniewska for 6 years as a colleague, and I think I have a few comments which are relevant for the conference today. First, Irena had a very original and outspoken personality. She was a truly independent character in defense of the freedom of the individual. I don't think that artificial intelligence can ever copy a personality like that, and I don't think AI will ever be close to the ethical standard she defended. By contrast, AI is a very dangerous instrument for those who want to control those type of individuals which incarnate freedom. Second, Irena was perspicacious. She was the opposite of a naive person. She was interested in the drivers of human and commercial conduct. She looked through the veil of words and rules to identify the motives of commercial action, which, as one may expect, are not necessarily philanthropic or humanitarian in nature. And this leads me to the topic, the dilemma of liberal democracy in the history of the market. I did not invent this title, to be sure. I don't claim any copyright. It's Professor Giuliano Amato who used it as a subtitle to a short but very important book which he published in 1997 and which is called Antitrust and the Bounds of Power. Well, I think finding the bounds of market power seems to be at the heart of today's conference. Before explaining what type of dilemma Amato was referring to, it might be useful first to recall who Amato is and why he wrote the book in 1997. Now, Professor Amato can be described as an all-round lawyer with a breathtaking career. He was born in 1938. He studied in Italy and in the US at Columbia University. And then he started a career as a politician. Senator, minister, prime minister, judge, including in the Constitutional Court. He also participated alongside Valéry Giscard d'Estaing in the Convention on the Future of Europe. And I presume he is still an academic. Last but not least, Giuliano Amato was also the president of the Italian Competition Authority from 1994 to 1997, the year in which he published the book. So why did he write that little book, The Bounds of Power? I think it's a story about the forest and the trees. Many of those who study or practice antitrust law and economic regulation today are specialists. They know everything about a number of things, but they may be tempted to forget that law and regulation serve a wider societal purpose. Let me quote what Professor Amato says about the reasons for his book. So I'm now quoting Professor Amato, which makes it easy when you have to make a speech, you just read something. So I quote, "I'm writing these candid pages for young people embarking on an immersion in antitrust law so that, as they become specialists, they will still remain aware of the general issues they ought always to bear in mind. But I'm also writing them to remind the experts of the genetic origins of antitrust law, and especially to bring them to a recognition of the traces of their DNA in the complex technical arguments they make choices among in order to resolve dilemmas facing them. For the choices they make do not involve those arguments alone, but continue to find their roots in the great political and philosophical options with which antitrust law still remains bound up. You will understand that Professor Amato, if he knows about this conference, will be very pleased about it, especially in an era as we're experiencing today, an era marked by rapid technological change, in particular in the field of AI, by strong market concentration, and last but not least, by increasing convergence between economic and political power. In many respects, this era is reminiscent of the period in which our antitrust rules first saw the light. Obviously, we would immediately think of the United States and the birth of the Sherman Act in 1890, a period marked by trusts in the cartel and oil business, and of course, as you all know, the dismantlement of Standard Oil in 1911, and a bit later on AT&T in the early 80s. But more important, I think, for us today are the origins of EU competition law. I submit that they are German in origin. They go back to a large extent to the Freiburger Schule, a school of economic thought founded in the 1930s by scholars like Walter Eucken, Franz Böhm, Hans Grossmann-Dort. They reflected on the role of governments in ensuring fair competition on the market, and their concept of ordoliberalism shaped post-war German economic policy. Their ordoliberal thoughts were greatly influenced by the need to avoid a recurrence of the collusion between economic cartels and the Nazi regime. Competition should remain a free process in which companies should do their best to compete as individual efforts, but should abstain from obstructing others. Today, we would say that competition on the merits is welcomed, but not practices that unduly impede other market participants. These thoughts resonate, for example, in the Google shopping case, in which Google not only privileged its own rankings, but also degraded the listings of others. Unlike other economic schools, such as the Chicago School, for example, the Freiburger Schule saw the competitive process as an end in itself. It should remain a free and open process, even if that applies a loss of efficiency. We'll come back to that a bit later. Eucken expressed a similar idea as follows, and I quote Eucken: "To an increasing extent, for example, freedom of contract is used to abolish competition by means of cartel agreements. Freedom of contract is often used to alter the form of the market and build up concentrations of economic power. As a result, it reduces economic freedoms of consumers. Moreover, such concentration of economic power can exercise strong lobbying and rent-seeking activities, threatening the normal functioning of democracy and thus the effective political liberties of citizens." I think we have a very relevant citation here today. Having a look at the past may provide us insight which are still relevant today and which are reflected in the legislation. So let me now look at Amato's dilemma. Competition is a strange process. It relies on the freedom to start a business, to compete, to innovate, to do your utmost to sell the best possible product at the lowest possible price. Here again, I would say this is competition on the merits. Nothing can be wrong with that. However, it can also be a self-destructive process, especially in markets in which networks and economies of scale play an important role. Markets tend to concentrate, either organically or through mergers and acquisitions. The degree of concentration can hamper market access and hence the possibility of newcomers to contest the incumbents. The competitive process therefore needs to be regulated. One could say that it has to be protected against itself. This protection calls for the intervention of public authority. But to what extent? And on the basis of which criteria? This balance between, on the one hand, the need to intervene against private power of some in order to safeguard the economic freedom of others, and the adequate dosage of public intervention to correct market deficiencies, on the other hand, is the dilemma to which Professor Amato refers. He summarizes it in two questions, and again I quote, first, how can private power be prevented from becoming a threat to the freedom of others? Second, but at the same time he says, how can power conferred on institutions for this purpose be prevented from enlarging itself to the point of destroying the very freedom it ought to protect? The dilemma is at the core of, I think, the debate you will have today. What is the adequate level of public intervention to ensure that the digital markets remain free and contestable, and to prevent that the private power yielded by some will have spillover effects in the political sphere? I will not give a conclusive answer to that question. But what I will do is give you perhaps a list of factors which may be relevant when discussing this dilemma. The first factor, in my view, is the nature of public intervention. I submit, for the sake of simplicity, that there are two broad categories of intervention. The first set of rules is the competition rules. They are general in nature. They rely on abstract terms, abstract notions such as cartels, abuses of dominant position, concentrations. You know it. You also know that the burden of proof to show that these general rules apply in a particular case rests upon the authority, and that the decision can be challenged before courts, like the courts in Luxembourg. That takes time. The Intel case is a typical example of the time it can take. Of course, it's a bit of an extreme example, but it shows you the length of what antitrust proceedings can imply. The second category of rules is more prescriptive and concrete in nature. It explicitly imposes or prohibits certain types of defined commercial conduct, regardless of the market structure. Hard and fast rules have as their advantage that they offer the market participants clarity and clear benchmarks, and that they are more easily enforceable by the authorities. A typical example, I would say, is consumer protection. Now, the question arises, where do we put the DMA and DSA in those two categories? Do they belong to antitrust rules, or do they belong to the more intrusive type of rules? DMA, I would submit, but that's a question for debate, is more akin to the competition rules, even if it is based also on Article 114 of the Functioning Treaty. Whereas the DSA is more akin, I would say, to consumer protection law. It intervenes directly by prescribing certain types of conduct. That's the first element. Which box do you use, antitrust or more sector specific? And of course that's a spectrum, and where do you put the cursor? The second factor relates to, of course, the choice of policy instrument as a means of public intervention to avoid spillover effects of private economic power in the political sphere. And that relates to the degree of confidence which you have in public authorities. As we have seen in some states, if private market operators and public authorities collude to foster certain economic interests, public intervention can have perverse effects. In order to prevent corruption or conflicts of interests, the market authorities entrusted with the application of the rules must be independent and impartial, as required, for example, by the ECN Plus Directive and the DSA. I would like briefly to mention one case where this issue arose, which is the SPEDPRO case. I will not dwell upon it, but it's a typical example where you have another authority in a contextual setting where you have doubts as to the independence of that authority dealing with a complaint involving a public undertaking. Is this a sound setting? This needs to be investigated. That's the core of the Spetpro case. Eucken and Boym in the 1930s anticipated cases like the Spetpro case. They insisted that antitrust enforcement should be in the hands of an independent agency. For example, even today, the Bundeskartellamt is in Bonn, the government is in Berlin, and before the unification, it was just the way around, the Bundeskartellamt in Berlin and the government in Bonn. Now, to come back to Professor Amato's dilemma, when regulating markets, it's not only the private power we should be concerned about, but also, of course, the public power. Now, after having set the category of rules, the authorities intervening, what are the criteria? What is the legitimacy of the action of the public actors to make sure that the bounds of power are being respected? This brings us to the objectives of public action. Why are we doing this? Now, this implies that we must define the objectives of the rules. Now, let me start with competition rules. It's, I would say, a woolly affair, and it's not by defining the objectives alone that you would have legitimate action. But public action cannot be legitimate if it doesn't pursue a legitimate objective. Now, as regards EU antitrust law, the definition of the objectives is complex. If you refer to Protocol 27, in which defines the objectives, it says, the internal market, as set out in Article 3 of the Treaty on the European Union, includes a system of undistorted competition. Okay, what does that mean? Over time, the Court of Justice sought to give this concept a more specific meaning. I don't know whether these attempts have been successful, but let me go to one of these attempts in the Italian electricity case of 2 years ago. It concerned access to the consumer base of the old vertically integrated monopoly of Enel in the context of market liberalization. Now, the court says the function of the competition rules is to prevent competition from being distorted to the detriment of the public interest, individual undertakings, and consumers, which ensure well-being in the European Union. Now, nobody can be against that. But what does it exactly mean, and what does it imply for the individual action? Now, then it turns to Article 102, and it says Article 102 seeks to sanction not only practices likely to cause direct harm to consumers, but also those which cause them harm indirectly by undermining an effective structure of competition. By undermining an effective structure of competition, I think it resonates the citation of Walter Eucken, which I just made. It seems to allude to a process. Of course, is this useful? What does it help us? I think it is useful. It shows that it is a broad and open definition, and that it cannot be the issue that an economic theory at a given moment in time dictates the way in which competition rules applies. This doesn't mean that economic theory doesn't have a role to play. On the contrary, economics will help us make better informed decisions, but a specific economic school of thought cannot become a dogma. Or to put it differently, the theory of the day, even if it's considered mainstream, cannot monopolize competition law. I would like to mention in this respect that some economic schools, sometimes funded by large companies, promote an application of the competition rules geared towards welfare and efficiency theories, which are so sophisticated that the rules will never apply. I note in this respect that in the recent case law, the Court of Justice has been backpedaling, for example, on the use of the as efficient competitor test in the assessment of exclusionary practices. Law cannot become unapplicable. Professor Amato therefore taught us to go back to the basics. Competition law and policy is not the realm of specialists applying complex theories. It serves a broader societal purpose. However, in some markets, the application of the classic competition rules doesn't suffice to ensure proper functioning of the markets. The combination of sophisticated theories of harm and complex proceedings hampers an adequate and timely enforcement of the competition rules. Antitrust enforcement, which is ex post in nature, cannot keep pace with the rapid development of new markets, such as the digital markets. Now, this brings us to the objectives pursued by the EU legislator in terms of the adoption of the DSA and the DMA. I will focus on the DMA. According to Article 1, the purpose of the regulation is to contribute to the proper functioning of the internal market by laying down harmonized rules, ensuring for all businesses contestable and fair markets in the digital sector. The competitive process, I underline the word process, in the digital world should remain open and not be controlled by a few players, or to put it differently, by an oligopoly. In order to protect that process, the DMA lays down rules for the designation of gatekeepers. By virtue of that designation, the gatekeepers become subject to a set of directly applicable rules. Unlike ex post enforcement, the DMA provides for ex ante enforcement. This ex ante system pivots on a designation process laid down in Article 3. Article 3, paragraph 1 lists qualitative criteria. Paragraph 2 sets quantitative thresholds, which imply that when you meet them, the qualitative criteria of paragraph 1 are supposed to be fulfilled. Companies can rebut that, and then it comes to the arguments which they can put forward to rebut that presumption. I would like to mention in this respect recital 23 of the DMA, which reads as follows. Any justification on economic grounds seeking to enter market definition or to demonstrate efficiencies deriving from a specific type of behavior by the undertaking providing core platform services should be discarded. The purpose of the DMA is to keep the competitive process open. It's an end in itself, just as it was for the Freiburger Schule, and not a means to achieve something else, such as consumer welfare or efficiencies. In the light of the above, I will now turn to a tentative answer of what the answer to Amato's dilemma could be. The competitive process has to be protected by keeping it open and by preventing individual or collective dominance. Second, the second question he poses on the legitimacy of public action. This protection should be ensured by independent bodies whose sole purpose is to guarantee that the competitive process continues to work. So, independent agencies. These possible, I underline possible answers, are not necessarily to everyone's liking. One may assume that the leaders in the digital industry will find it hard to understand that they are constrained in their activities. Since big tech happens to be American, these leaders may be tempted to mobilize the US authorities for their commercial cause by denouncing the intrusive nature of EU legislation. In fact, the US government has already been mobilized, and EU enforcers of the DSA may be personally targeted by US sanctions, as was Mr. Thierry Breton already. Of course, this type of action concerned the DSA and not the competition rules and the DMA. So it falls outside the scope of what I'm supposed to say. Even so, the fact that powerful businessmen can convince public authorities to use public prerogatives to serve private interests is an illustration of the spillover effects which were a cause of concern of the Freiburger Schule in the pre-war years. Nevertheless, whatever we may think of the US government, we should remain open to criticism. The EU is not the ultimate source of universal wisdom. nor does it pretend to be. On the contrary, the EU stands for democracy, which is, as competition itself, a process that should remain open and in which incumbents can be challenged. A lively competitive process goes hand in hand with a lively democratic process, which cannot and should not be blocked by those who happen to be in power at any given moment in time. Criticism and debate are integral part of that process. Now let me conclude, against this backdrop, by criticizing what I just said. First, I agree with Professor Amato that we always have to remind ourselves of the foundations and the rules and the origins of those rules. However, this doesn't dispense us of the need to continue to seek for methods which serve our free societies best. In my view, the competitive process is still key to our collective success. Even so, this doesn't mean that competition is a panacea, but that works in every sector of the economy at any given moment in time. That as regards the first point of Mr. Amato's dilemma. Second, independent agencies are important in terms of market oversight. I will not dispute that. But we have seen a proliferation of such agencies in competition law, sectoral regulation, and data protection, both at national and European level. This fragmentation not only raises questions in terms of the coordination of overall economic policy, but ultimately also in terms of democratic legitimation. At the end of the day, economic policy and the regulation of markets cannot be a matter for technocrats alone. It is for the legislator to set the frame in which they operate and the conditions under which they can be held accountable. To conclude, the questions put by Professor Amato will never receive a final answer. They invite us to ongoing reflection and critical introspection. That is also an ongoing and dynamic process, as we will probably experience today. I thank you very much for your attention.
Thank you very much. Yes, let's see if we still have some time. So I would like to invite some questions. Are there any questions? Okay, we have people coming. Okay, so I don't see questions. So I would like to thank you very much for your presentation. Really eye-opening. Thank you very much. So I would like to right now to invite the speakers of the first panel. Okay, so let's start our first panel that is dedicated to the things that President van der Woude already covered at least to an extent. So what we are aiming for is to discuss what is the role of competition law and other regimes in addressing a harm to democratic process caused by private firms' power, including but not only digital platforms. And based on the lecture we just listened to, we know that if you think about the history of competition law, this connection between democracy and competition law was always there. The question still might be how we want to frame this role. Is it indirect or maybe direct? And it's very interesting then to consider, and that was also addressed to an extent already, how to develop the framework we have vis-a-vis the existing challenges, for example, in terms of theory of harms in competition law or the DMA, or the remedies that are to be imposed by competition authorities. And finally, the question is really about institutional and procedural arrangements within which competition law operates. And this is particularly important in a time when apparently competition authorities face a growing political pressure, and they may face basically challenges in sticking to the rule of law when applying competition law. So we'll try to discuss this, and this is, I think, really a great panel, because we have representatives of various stakeholders. We have with us Judge Krystyna Kowalik-Bańczyk, a president of the third chamber of the General Court. We have with us Eileen Gotz from Wachtell, Lipton, Rosen and Katz, a New York City law firm, so very well-known U.S. antitrust practitioner. We have with us an academic, you know, from already from yesterday. Or congratulations again for winning Irena Wiśniewska Prize. And last but not least, we have with us Mark Dempsey from Article 19, so a representative of NGO. I must say that I am particularly glad that we also have representatives of civil society in this panel. It's, I would say, less common at antitrust conferences. So this is the panel, and the idea is basically to start with opening presentations by each of the speakers. Then we will try to have a bit of discussion in between us, hopefully, and then we will open the floor to your questions. And I really very much invite your questions. So. We were discussing how to prepare this panel, and we thought that we will start from more general issues. We'll start with the EU, then we go to the US, we see things in the US, and then we kind of narrow down a little bit the perspective. We will discuss prioritization in competition law and the role of NGOs. So I would like to give floor first to Krystyna Kowalik-Bańczyk. I guess you will, in a way, you will follow up on what already President van der Voorde has said, but there is a lot to learn from the Court of Justice. From the General Court. I am sorry for this, but I was particularly intrigued by the statement of the General Court it was very far in one of the paragraphs in Google Android, where the General Court said that protection of consumer interest harmed by anti-competitive conduct are not only consistent with competition on the merits, but are also necessary in order to ensure plurality in democratic society. So, Krystyna, please, the floor is yours.
Thank you very much, Maciej. Thank you very much, Professor Bernard. Before I start, let me express my thanks to Wiśniewski Foundation, to the Warsaw University and Institute of Law Studies, so my alma mater, and as well pay tribute to Professor Judge Irena Wiśniewska-Białecka. During last 9 years, I had to live up to her legend, in a sense, and I am very happy to walk in her footsteps, and I am really privileged to be able to be here today as well for this reason. The idea that competitive markets and competition law promote democracy is a sort of a foundational myth of both US and EU competition law. And there have been many quotations today already, but despite the fact that I'm prone to represent the EU side, let me start with the quotation with Senator John Sherman of 1890, who said, "If we will not endure a king as a political power, we should not endure a king over a production, transportation, or sale of any of the necessities of life." So this idea of liberty and lack of domination and freedom of choice is inherent to the competition law, but somehow this initial objective disappeared from the picture. And I am happy that this conference gets us back discussing those very roots of competition law. And Giuliano Amato has been quoted today as well, and he was thinking that there is a nexus between competition law and democracy. And because of this, I am supposed to address 2 points in my short presentation. First, the question of abuse of power by those entities that might prove to be a little bit problematic for the diplomatic process, so huge techno giants. And second, whether the legislative answer in form of DSA might be an answer, so Digital Services Act. And we are facing the situation that some technology undertakings are controlling the information infrastructure, and the European Commission was trying to address it during last, I would say, 15 years, then meeting the answer of the courts, mainly confirming the Commission tries. But this comes with a big question, and I refer to the dilemma raised by Mark van der Woude, that we have this anti-bigness philosophy included in Article 102 of the Treaty on Functioning of European Union, but we have those huge digital players who, in fact, are chosen by the consumers. They are producing, in fact, the best products. So if we look at the objectives of the competition law, and if we agree that at least recently, during the last 20 years, the main objective was consumer welfare, it seems that they are perhaps not doing anything wrong because they are doing things that please consumers. So this is, of course, a little bit of a provocation, what I'm saying, but we are facing, in fact, a big question. Are we concerned only with the consumer welfare, or are we as well prone to protect the structure of the competition and the competitive process on the market? And in fact, now I will try to show you how this dilemma was handled during the last 20 years in the case law of the European courts. because last 20 years were characterized by this approach named more economic approach, illustrated by as efficient competitor test, where we were looking whether on the market there are other players who would be able to address the same consumer needs, or maybe we should leave them alone and let them play. And this can be described as a sort of a laissez-faire approach. And this approach is very visible in some cases of the Court of Justice, where this more economic approach won, I would say. Intel case that was mentioned today, its final result. Qualcomm case, Servizio Elettrico that Mark mentioned already. All those cases sit a little bit uncomfortably with the rise of power of digital platforms, because if the Commission had prioritized consumer welfare approach, this allowed some undertakings to have long-term strategies of building huge empires and establishing gatekeeper position that perhaps were not completely addressed by antitrust instruments. And it is, at least in American doctrine, named Amazon antitrust paradox, that Amazon is so good that you don't react to its actions. But of course, we have other goals than just consumer welfare, and effective competition is still there. And during last years, this issue was as well addressed by at least 3 very bold decisions of the European Commission: Google Shopping, Google Android, Google AdSense, and they all might reflect a reversal back to a more structural approach to the competition law. And of course, without getting into many details, competition law is used there as a tool to regulate a particular industry and to support some policies to liberalize or open some markets, at least to guarantee access to the market, and perhaps pursuing other goals than just economic goals. And this is in particular visible in 2 cases. In Google Shopping, that is, as already mentioned, a case on self-favoritism. It is a case where Google was seen as abusing its dominant position only because it was favoring itself and limiting market access. So no proof of full foreclosure was needed to state that there was an abuse. So there was this stress or focus on allowing access to the market. And the second example that was already mentioned by Maciek is Google Android, where we have certainly in a very, very, I would say, distant recital of the judgment at the very end, this idea, this reflection of an idea that consumers are as well citizens, and that guaranteeing plurality of access to information, access to media services, might be an issue as well addressed by antitrust. So those 2 examples are showing a sort of a shift in this purely consumer welfare approach that was prioritized by the European Commission and as well followed, at least in some of the judgments of the Court of Justice. So we have these parallel developments. On the one side, we have, I would say, purely consumer welfare case law, and on the other side, we have this try, at least a try, to address other issues than just whether consumers are happy. I'm simplifying. But the antitrust instruments turned out not to be completely efficient. I think DMA will be discussed, and in fact it makes an echo to the case law of the Court of Justice as well, as far as Facebook is concerned, and of course the whole Google saga. But a new instrument adopted in 2022, Digital Services Act, is really an instrument that is consumerist in nature, and that is really addressing not diplomatic, but democratic deficiencies as far as huge digital undertakings are concerned, because it really marks a shift from a purely economic approach to digital platforms to a more constitutional one, trying to protect fundamental rights and democratic values. And of course, these are big words, and you might say, okay, but the General Court does already have some cases on DSA, and does this democratic dimension really appears there? And I wouldn't really say it is a case directly, but it is constructing the whole system and confirming certain things, because DSA targets online content. It imposes quite burdensome responsibility on big players who are defined, at least as DSA is concerned, as very large online platforms, depending on the number of active users. And seeking to protect consumers, it somehow as well tried to include some vertical fairness of the markets that are covered by those online platforms, because their greater responsibility is not only economic, they are designated with the responsibility to address the content that might be problematic, and this content might cover different types of systemic risks, including democratic risks. And for the time being, the big players, the so-called VLOPs, they were first contesting in front of our court the very fact of being designated. So this comes with a very technical discussion, how you count the users and how you define the intermediaries in online services. And in particular, Zalando and Amazon, those cases were already addressed by our court, and they are under appeal at the Court of Justice, confirmed that regardless of, at the first sight, market dimension, purely market dimension of those platforms, they are as well prone to address systemic risks, and illegal content can appear as well on such purely market-driven platforms. But of course, neither Zalando nor Amazon are not on the front line as far as democracy issues are concerned. We have at least 6 VLOPs that are really at the first line: Facebook, Instagram, Google, YouTube, TikTok, and X. And all of them appear now in front of the General Court with quite technical issues in the first place, because they are contesting, not really contesting the fact that they are huge and that they are designated as VLOPs, but they are contesting first their obligations to pay for commission surveillance, which on its own is making the life of Commission harder. So it has to invest forces into this litigation that is a little bit, sorry to put it like this, a little bit ridiculous, because it is obvious that they are huge. And on the other hand, we have first cases pending when they are contesting, and in particular X and Elon Musk himself are contesting the first sanctions imposed on those undertakings for not fulfilling the obligations imposed by DSA. So this litigation is ongoing, and of course the handling of systemic risks, it is all very nice that DSA is imposing this obligation on VLOPs, but it should come with a will to address those systemic risks. So coming back to the initial question, I think DSA is an instrument that was introduced because antitrust was not enough, just as well as DMA was introduced for this reason. And antitrust on its own is, of course, addressing consumer welfare, but it has to look at the structure of the market. And we somehow need to look at it in a dynamic way, because we need to join the two together, the structure of the market and the consumer welfare in the longer perspective, because even if consumer of today is happy, it will come with a price if we don't control what the structure of the market is. So I just would like to conclude with this reflection that, of course, antitrust seems to be only concerned with the market, but we are more and more facing the constitutional and citizen issues even in antitrust case law. Thank you.
Thank you very much, Krystyna. And it was great, particularly by showing how different instruments complement one another. And I really like the idea about future consumer as maybe a new concept. So we move to Eileen Gotz, and I welcome your thoughts from the U.S. perspective. We know that everything started in the U.S. when it comes to antitrust. So where was democracy, where were markets, and how this evolved across the years?
Thank you. Good morning, everyone. I really want to also extend my gratitude for being included in this very timely and important discussion. As we've heard so far this morning, the U.S. was really at the forefront of the development of this area of law. And the origins and the common interests in both, I would say, addressing limits on power and protecting democracy is there from the outset, predating even the Sherman Act and the quote we heard about if we won't endure kings. There was in the U.S. in the 1870s and 1880s, two very important movements, the National Grange and the National Farmers Alliance, which were promoting these ideas. These grassroots sentiments were actually part of a presidential debate where President Grover Cleveland and the challenger, Benjamin Harris, both campaigned with antitrust platforms. Shortly thereafter, we had the Sherman Act being introduced by Senator Sherman, and after that, we fast forward, seeing limits on how well the Sherman Act addressed these fundamental concerns. We had the Clayton Act in 1914, where it sought to, and this is a quote from the legislative history, it was to open markets to, quote, scores of men who have been obliged to serve when their abilities entitle them to direct. Again, very much a democratic concern about equality when you look at it. Section 7 of the Clayton Act imposes an incipiency standard where the effect is to substantially lessen competition or to tend to create a monopoly. This standard was to deal with prospective combinations as well as to attack existing monopolies and concentrations. These continued concerns on the effects of concentration on competitors resulted in the passage of the Robinson-Patman Act. Interestingly, when I went to law school in the early 1980s, right at the hiatus of the Chicago School, I had a professor who would not even teach the Robinson-Patman Act, thinking it was anti-competitive and shouldn't be banned. But the Robinson-Pacman Act in 1936 protected small businesses by forbidding there being price discriminations by suppliers in favor of larger competitors. We fast forward to the 1950 amendments to the Clayton Act, and former FTC Chairman Robert Pitofsky indicating that the purpose of this was that there was, at that time, an economic order dominated by a few corporate giants who could, during a time of domestic stress or disorder, as we saw in Nazi Germany, facilitate the overthrow of democratic institutions and the installation of a totalitarian regime. And the 1950 Seller-Kefauver amendments were aimed to address that. The U.S. enforcement paradigm also reflects a strong fear of a strong central government. And in order to address these concerns, when it came to private industry, there is this check and balance throughout the Federalist Papers, which predate our U.S. Constitution. By the 1890s, so predating around the time of the Sherman Act, there had already been developed, based on British common law, very strong state laws that were looking to really address competition problems. And that worked well when most activity happened on a local nature, where competition was localized. But as we got the railroads developing and everything became broader in scope, there was a need for federal legislation to address what the states couldn't do. And the federal legislation was never intended to replace state laws. It was meant to augment state laws. And this structure and having duplicative authorities also is part of our structure in having both the U.S. Department of Justice and the Federal Trade Commission having concurrent jurisdiction on some of these areas. The FTC's blanket mandate is to stop unfair methods of competition, which includes what you find in both the Sherman Act and the Clayton Act. So we kind of look at this, and then we hit this period of time around the time I was going to law school and working on a PhD in economics, the Chicago School of Economics, where all of a sudden there was a focus on consumer welfare, which I'm not going to spend a lot more time on because you did such a great job, I don't need to. But that really impacted what took preference, what took precedence, the priority of when the laws would be enforced, primarily, again, by the federal authorities, not so much by the states. But the states became less active. But I would say to you that the change we have been seeing is not something that is occurring today or in the last 5 years, but really goes back about 15 years. And I want to walk through that for a minute. There's been this return to the limelight, which was the initial principal objectives of antitrust laws, including protecting political equality, small competitors, independent businesses, and workers and farmers. For instance, if you look at inequality concerns, they were the basis of the Occupy movement's protest against Wall Street in 2011. It was the central issue of Elizabeth Warren in her 2012 election campaign for the U.S. Senate. Inequality was a central theme of President Obama's 2015 State of the Union address. Hillary Clinton focused on the issue as part of her first presidential campaign, as did the rest of the Democratic Party. And this is really bipartisan, because the leading Republican presidential contenders in 2016, including President Trump, spoke on the inequality problem in the U.S. as well. And going back to the University of Chicago, it was interesting for me that in 2018, the University of Chicago professor Luigi Zingales wrote in a widely cited article at the time that there was a direct connection between economic power, bigness, and political power, and that this was now a bipartisan issue. We saw, more importantly, when you look at what's been happening, a re-emphasis on labor markets during both the Obama administration and the first Trump administration. Progressives during the Biden administration continued this focus with labor markets, both as in both conduct as well as with anti-poaching cases and with non-competes, as with merger policy. And we also saw significant changes throughout the Biden administration, where there was a heightened concern about smaller competitors and bigness. The Biden leadership expressly wanted to have companies think long and hard before proceeding with deals, with the idea that you should really not, this deal should never have left the boardroom, being a message. I wish it was always so clear what shouldn't leave the boardroom, as they seemed to think when they looked backwards at it. Well, that brings us to the present. On some things, the focus on workers, the need for antitrust enforcement to protect the common citizen remains the same. FTC Commissioner Mark Meader wrote in a recent speech that, and this is a quote, "For decades, millions of Americans have been ignored. They are Americans just as much as any deal makers on the coast. They deserve the opportunity to work hard and forge decent lives for themselves and their families. The politicalization of antitrust, where blind ideology tilts the scales of justice in favor of one side or the other, is a misuse of power that destroys institutional credibility. The rule of law demands due process and equal weights and measures. To give a collective expression to the American understanding that concentrated power, whether political or economic, is fundamentally at odds with the liberty of free men and women. As I see it," that's Mark Meader, our current antitrust movement under President Trump isn't something novel. It's a course correction, a return to the place our laws should have been led us to in the first place. Our mission isn't to rewrite the antitrust laws or to use them for narrow partisan purposes. It's simply to enforce them. At the same time, there has been change. First, the new Trump administration has focused on censorship of conservative voices' concerns. These censorship concerns have even surfaced in merger review context. In June of 2025, the FTC resolved allegations that the proposed merger of Omnicom Group and Interpublic Group, which are two large media buying advertising agencies, would meaningfully increase the risk of coordination in the media buying services market. The consent agreement prohibits Omnicom from entering or attempting to enter into any agreement with any third party that, quote, hinders advertising based on political or ideological viewpoints, end of quote. Second, eliminating diversity, equality, and inclusion programs is another pillar of President Trump's second administration agenda. And he finds, and these speeches all say, that DEI programs are problematic because they purportedly, quote, deny to all Americans the Constitution's promise of equality before the law. They promote invidious discrimination, and they violate federal and natural law, end of quote. Finally, the FTC and the DOJ are reinforcing President's ESG fights against so-called left-wing ideologues. So it's interesting, we're hearing the same sort of rhetoric. There could be some debate on how they're being applied, and I think we will get to that soon, but a lot of this is citing and going back to the origins to become the basis for what is today's policy. With that, I'll turn it over to you.
Thank you, Eileen. That was great. Like, you provided us this picture, starting, with the old history and taking us, to the challenges that competition authorities, but it seems particularly in the U.S. are facing today. So we know the broad picture in the EU and in the US. So now I would like to invite Or to kind of reflect on how this democracy-related interest, how they could be pursued by means of competition law enforcement, and this is somehow coming back to my question whether this role of competition law is direct or indirect, and what tools can be used depending on where you go, and or will focus on prioritization in this context, please.
Yeah, thank you for the invitation to speak in this panel today. And indeed, I think we established the problem yesterday and today, so perhaps moving to possible solutions. So today I will present a paper that soon will be published in legal study that I co-wrote with Kati Cesares, where we advocate using the process of setting the enforcement priorities, of choosing which cases competition authorities should choose and which they should disregard, in order to transform competition law enforcement to more democratic, more responsive, and more inclusive. The process of setting enforcement priorities is inherently one of the most important parts of competition law enforcement, one of the major tasks of competition authorities, and is a reflection of their independence and expertise. Normally, when we think of priority setting, we think of the budget practical concern. We know that competition authorities, and that's true to any competition authority, are constrained by human, technical resources, where studies shows us that they are managed to enforce around 10% of the potential anti-competitive practices that even come to their attention. However, in our studies, Kati and I also point to other important part of priority setting, which is norm concretization, of explaining what competition law should be. Because the competition law provisions are open-ended and somewhat vague on purpose, as we already discussed yesterday, that means that their interpretation, their focus, their understanding of polarization is being done through enforcement practice. So explaining, focusing the enforcement is also actually has a substantive element of what competition law is actually about. Despite that, there's very limited attention, both in academic and practice and legislation, of how should competition authorities focus their enforcement priorities, or what is good practices, what is the good type of enforcement focus. Kati and I show that often, and again, this is a global phenomena, the process of enforcement priorities is in fact reactive, insulated, and consumer welfare centric. So it's reactive because most of the competition law enforcement is a response to leniency applications. We're talking about 80% of anti-competitive agreement as a ballpark, or as a response to complaints. We also know that those types of cases of leniency and response to complaints often come from the bigger companies and could be a reflection of their private business interest rather than pure public policy choice. There's a lot of studies establishing and proving that. So reactive, insulated. The process of setting the enforcement priority is often being done independently and not necessarily in a transparent manner by competition authorities. There's very, very limited room from input from society, from consumers, from civil society, but I will leave that point for Mark. Meaning that the process or the access to competition law is limited and is very difficult for consumers and even sometimes for consumer organizations. The type of information that is required to establish a formal complaint is very difficult, is very technical. Finally, we have the point of consumer welfare centric. In previous research, Kati and I have systematically examined what are the laws or internal policies that guide competition authorities in selecting their enforcement criteria. In Europe, for example, we know that only around half of the national competition authorities have even internal guidelines telling them or explaining how they're going to set their enforcement priorities. But where this exists, we normally see criteria that refers either to procedural questions, do we have enough evidence, do we have capacity, or to consumer welfare standards. And we can see also consumer welfare comes back in the way in impact assessment of prioritization decisions. The problem there that if we look only from a purely mathematical approach, consumer welfare does not distinguish between different types of consumers. That means that if you apply the consumer welfare test, you might decide to choose to take a case which result in 10% reduction for very high-end consumer for luxury products in comparison to 5% reduction in the prices of basic necessities like bread, access to healthcare, or to the construction industry. And indeed, we see that in recent years, we have a lot of cases in Europe by the Commission and by national competition authorities focusing on those high luxury products. And this, again, is true, although we have ample of evidence from economics, from sociology, that the harm of competition law, the harm of anti-competitive practice, disproportionately affect consumers from lower incomes. That's true also in terms of socioeconomic parameters, but also in terms of race, of gender, and we have consistent evidence. But this is not being translated or recognized by consumer welfare, or more generally by competition law enforcement. So what can we do? In the paper, Kati and I argue that actually we do not need a drastic reform. We don't need to change the competition law provisions or even secondary laws explaining how to implement. We just need to pay more attention. We show that in the process of priority setting, there are different stages, which we also, it's a typology we developed in previous studies, but especially when it comes to making the process of priority setting more inclusive, more open, we can focus on different elements. For example, many competition authorities are guided by an agenda. So it's a list of predetermined enforcement focuses. So it could be either certain anti-competitive practices, certain sectors, that either the government, the parliament, or the competition authority itself flag the focus of enforcement for the next year or the next period. Some competition authorities open this agenda to public consultation and to input, again, either from the parliament, from the government, but also for citizens. If we ask citizens, and the EU Barometer survey does ask citizens, where are the competition law problems? Surprise, surprise, they do not talk about Birkin bags or Guess jeans. They actually get it right in terms of that it mirrors what economics tells us. The recent EU Barometer survey pointed healthcare, education, construction industry, access to finance, at the main competition law concerns that comes to EU consumers. Why don't we use those insights also to inform our competition law agendas? This I'm saying carefully, but it also means we need to reflect if focusing most of the enforcement efforts on competition law concerns in digital markets is necessarily the right approach. But I think it's really an invitation to reflection more than a criticism. Agenda is one way. Another way is to change or to focus the substantive criteria that informs the decision of a competition authority whether or not to take a specific case beyond the consumer welfare approach. You can see some insulated cases talking about the need of legal precedent, about the need to help open the markets for certain types of more vulnerable consumer or groups in society. For example, access to finance could be a good example, or the employment cases, which I think is the right move to the right direction. And again, even the formulation of those guidelines, we have room for consultation with civil society. Two last examples of how we can use priority setting. Impact assessment is a very important question. Most competition authorities, and it's really the vast majority, so in the survey that we did in 2021, we found that only 2 out of 28 national competition authorities in the UK, including the UK back then, have any measure of impact assessment about the prioritization decision. So rather than focusing on what was the impact of a specific case, looking more systematically of what kind of cases the competition authority takes and what does that mean. This is a really important aspect. It's a really important way that we can incentivize competition authorities and heads of competition authorities to make sure that they choose a right portfolio of cases that represent the real problems of consumers and citizens in a given society. Another aspect is about the procedure of priority setting. If we look across the EU, we can see the different member states attribute considerably different role and rights to third parties and to consumer organizations. We have certain member states that provide a special right for consumer organizations. The UK is another example with the super complaint mechanism that is being revived. So hopefully we're going to see some input in future years. But also, and again, I will leave to Mark to elaborate on that point, of making the process of submitting a complaint or submitting observations in a competition law case more open and more accessible to civil society organizations. And with discussion with civil society organizations, even though that somehow specialize in consumer protection or competition law, we do get the feedback that even they found the process of engaging with competition authorities to be too difficult, too technical, and is not really open. So again, by just shifting the focus, using the mechanism that already we have in the law, we believe that competition law across Europe, across the world, can be more open, more democratic, and serve its aims and become more legitimate, linking it to the first keynote speech.
Thank you very much, Or. That was great. I was just to add to the picture you are describing. I would maybe argue that if you think about a proper priority setting, it's actually, if you think about the reasons behind, the success of these politicians that actually dismantle democracy, I think the success is driven by certain economic fears among citizens, among consumers. Actually, probably in the areas you described. So in this sense, properly focused enforcement of competition law can have a pro-democratic character in this sense. So I will move to Mark. I think it was a perfect sequence. I think so. You can yes, slides. You can jump in and tell us about the challenges that NGOs maybe.
So, good morning, everyone. I have to admit, I feel slightly like an imposter here in this room as both a non-lawyer, a relative novice to competition, but also such elevated company, both on the panel and in the room. So I'm going to pretend I'm not remotely intimidated. So for those who don't know Article 19, we're a global civil society organization that works for a world where all people everywhere can freely express themselves and actively engage in public life without fear of discrimination. To protect freedom of expression online, we advocate for pro-competitive solutions to dilute corporate power and guarantee diversity, openness and fairness. I lead our EU advocacy in Brussels. So what is the role of enforcement of competition law? Our role in the enforcement of competition law, the Digital Markets Act, why do we matter, what needs to happen to ensure our more active involvement? So if we go to the second slide, please. So I think given the environment we're currently in, it's both a bubble and I think we can all agree slightly ridiculous. I don't need to explain the previous slides. If you maybe just go. You can see what it's saying. I mean, we're in the midst of this AI madness and we're subsumed with stuff that isn't being tested properly yet and we don't know if it works. So this kind of explains the hyper investment cycle that VCs are currently pushing both in Brussels and more broadly globally amongst governments and amongst the public. So to democracy, where do we stand given the nature of this panel? So it's not looking good. The latest report from the University of Gothenburg's VDEM Institute released earlier this week makes for grim reading. US is losing its status as a liberal democracy for the first time in over 50 years. The report authors, quote, the European Union is greatly affected. What they call autocratization in Europe affects 7 EU member states. Of the 10 so-called new autocratizers identified in 2025, 5 are European: Croatia, Italy, Slovakia, Slovenia, and then outside the EU, the UK. I'd question the UK in that regard, but anyway. So arguably the role of civil society has never been more important, and while competition may be a side dish, some of you will get this overused insider reference from Brussels, but it harks back to a former Director General's reference to competition law and its role in broader society. He was at the time under quite some pressure to move beyond the consumer welfare standard and take a more whole of society approach akin to that of Lina Khan at the FTC under Biden at the time, which he just referred to. So, next slide, please. So why more civil society participation in competition law enforcement? So there is a need to shift the discussion surrounding competition rules back to its original function of dispersing economic power and serving as a guarantee for a democratic system instead of being a closed-off discussion among so-called elites. In the last years, there has been a certain opening up of debates on competition law to include civil society organizations, but there is much more to be done to include us more actively. More civil society participation would improve the European Commission's decision-making, we believe, and enforcement processes, as civil society organizations can bring new perspectives, information and evidence, and an agenda not driven by commercial interests. So what role do we play and what initiatives exist today? Within the Brussels bubble, so to speak, there's an anti-monopoly coalition, which signifies the growing capacity of civil society to look at competition. So at the moment, we're about 8 organizations, including the Open Markets Institute, which was instrumental in bringing Lina Khan into power back in the day in the US, and they've now got a European office. There's ourselves and several other organizations, some coming from Germany. We act as a bridge between the academic community and the European Commission, while also submitting responses to consultations, issuing critical statements, and performing a monitoring role on competition enforcement and enforcement of the Digital Markets Act. We also ensure, for example, that independent technologists' voices are given more prominence, particularly in DMA enforcement. There is also an initiative called the Digital Merger Watch, a global initiative run by Dutch NGO SOMO and dedicated to scrutinizing and challenging big tech's efforts to reinforce its dominance through mergers and acquisitions globally. We also have podcasts such as a series recently started by Simonessa Vazazo of University of Trento and my colleague Isa Stasi called Vox Populi, where independent voices and policy discussions on enforcement and deployment of the DMA have a chance to be heard. I really recommend it. It's a completely different take, and you're hearing voices that you normally wouldn't hear from the competition sphere. And lastly, we have appeared before the DMA's high-level group, a mechanism stipulated in the DMA for bringing member states amongst different regulators together to discuss DMA enforcement. So you have DPAs, competition authorities, media regulators, and others. I think our ask from civil society is that we're there in a more structured basis and more regularly to give our input. So what needs to change to ensure more civil society involvement? Firstly, on private enforcement. Identify the right cases, what kind of changes, goals we want to achieve as a group of organizations, and then find effective ways to cooperate. No single player can be a game changer alone. We need to figure out the financing. This is much easier said than done because this is a novel way that funders aren't so aware of. Most funders look at us in a sort of short-term horizon, whereas if you're doing private enforcement litigation, it's much more long-term. And then we need to identify the best legal tools, redress or interim measures, who is the best complainant, etc. And then public enforcement and looking at competition more broadly, we have pushed for changes on the conduct of proceedings and rules and the implementation of competition rules, so Article 81 and 82. So what have we asked for or submitted, which of course is still being considered to some degree. We want to broaden the interpretation of the concept of legitimate interest, extend the concept of sufficient interest, and we ask that the Commission review its priority setting as part of the broader process of which you just discussed, or of allowing stakeholders' participation in the enforcement of competition rules. So, in the fashion of providing quotes, I want to finally leave with a call to arms to get more participation, interest in looking at competition policy beyond the usual circles. I'm reminded of an essay I read in the Atlantic magazine a couple of months ago. The writer was Caroline Friedrichsen, former legal director at Pro-Choice America and a former head of the American Constitution Society, where she helped vet and promote judges, and a former Biden appointee to his presidential commission. Her contention was that by focusing on civil liberties but ignoring economic issues, and I quote her, liberals like me got defeated on both. So permit me the long quote, which you can see up here. In my decade running the American Constitution Society, I never gave much thought to political economic issues, such as antitrust and competition policy. They were just not on our agenda. When we scrutinized the records of Bush and Trump judicial nominees, we probed their views on abortion, voting, and criminal justice, and to a lesser extent on labor. When we pushed the Obama administration on judicial candidates, we focused mostly on democratic diversity, while unsuccessfully pushing for more civil rights lawyers and public defenders. When lawyers with backgrounds in antitrust or labor law made it to the bench, they typically came from the corporate defense side. I'm proud of my work promoting judges and backgrounds that were woefully underrepresented in the judicial branch, but I regret that I mostly ignored where these judges stood on the question of corporate power. Thank you.
Thank you very much, Mark. So I thought that we can have a follow-up discussion before we open the floor to your questions. So we were discussing different issues concerning, I think, substance of competition law, institutional and procedural organization of enforcement, and we also discussed to an extent the division of competences between various actors. So I would like you to invite your thoughts on this. So in terms of substance, one of the question can be what is the role to be played by respective actors? So, for example, if we agree that there are certain gaps, if we look at the competition law with respect to democracy, who should fill in them? Should it be for enforcers, for courts, for legislator? So that's the first question. Then, if you look about institutional and procedural organization, we cover this to an extent. But can we think about the procedural and institutional structure that would be or that would work better for inclusion of democratic interest within competition law? And then finally, and you can pick any of the perspectives. It's really I am alluding to what the President van der Waal already said, that there are so many institutions that today are enforcing competition law and the new acts. So how can we make it that we won't end up in a situation when basically we see divergent approaches on different levels, or maybe the fact that we have domestic, like national competition authorities or state enforcers and federal or like the enforcers in the Brussels is actually helpful and they can complement one another. So this is a first broad set of questions, and I invite your thoughts. We didn't discuss the order, but anyone feels like. Christina, you want to go first?
I gather that we keep the same order, at least for the time being, so that's why I might start. So the role to be played by respective actors may be the first question. Of course, it has already been said that courts are reactive. We are, in a sense, responding to the case in front of us, but I think the beauty of the European Union is that we have preliminary questions, and priorities might be different in different member states, and it comes with different preliminary questions, like Android Auto recently from the Italian judge, where we can address issues despite the set of priorities set by the European Commission at the European level. So we have this possibility to start a process of reflection at the national level, bring it to the European level. So this is a very nice mechanism opening up this this role of courts of being just responsive to what appears in front of us. But not all decisions relating to democracy or even indeed to fundamental rights can be left to the courts, I think. Of course, there is this spillover effect, like indeed with the right to be forgotten with the first Google case. It was a judicial response to a lacuna in the legislation, but then it was filled in by the legislator. So of course, the very first answer might be coming from the case law, but then in order to make it completely efficient and in fact transparent to the citizens, it would be better that the legislator steps in, that I think. And I think it is as well the reason why DMA was adopted, because trying to handle the position of Google or whomever else just by case law turned out to be too little, too slow, and so on. So I think we need legislator. And maybe that's for the role. I think there is another question, but maybe we will make a round first. So.
Should I go next? Following the same order, I like that, actually. You know, I really admire how well our founding fathers came up with the system they did from an institutional design standpoint with checks and balances. And checks and balances are just critical here. When you look at it, we have a consumer welfare standard, going to what Laura was saying, which is broad enough to encompass the evolving political objectives and priorities over time. So it's how it gets implemented. From an institutional design standpoint, I actually think it really, the courts are so critical. I don't underestimate how strong and how important the courts are. They're the safeguards we have with judicial review for when the government overreaches. The courts are, should be the final arbiters, not the regulators. And when I look at it, for instance, what's going on right now, we're seeing Congress also trying to step in, and the states, when it comes to where there may be gaps in federal enforcement today, or perceived gaps. For when we look at DOJ settlements, which is currently a very hot topic, what has happened both in conduct as well as mergers, there is something called the Tunney Act. And the Tunney Act provides the courts the ability to decide whether the settlement is in the public interest. In practice, courts have rarely been active in such a review, but that is changing. We have right now, in a merger matter that I was involved in, the Hewlett-Packard Juniper case, the court is having a Tunney Act proceeding, and state, mostly, I think they're all Democratic state attorneys general, have stepped in and intervened and are submitting comments. Interestingly, just last week, talking about the need for maybe legislation, I'm not saying for sure there's a need, but let's just assume it for a second, Senator Amy Klobuchar introduced legislation aimed to increase judicial scrutiny of antitrust settlements. The bill would expand the role of courts in reviewing settlements by granting judges additional time, requiring disclosure from federal regulators of additional information, and allowing state attorneys general to participate by fact, not by right, I should say, not by discretion of the court in the judicial review process. The legislation would also expand the Tunney Act to include FTC settlements. And that to me is something, the FTC settlements is really very important that we have to have this divergence between the FTC and DOJ, especially if increasingly mergers are going to be decided in the courts. Seems like a huge gap. And then we speak of the 8 attorneys general. You might remember in the beginning I talked about how we are duplicative and overlapping, not meant to preempt states. If you look at what's happening right now, the state attorneys general are very, especially the Democratic state attorneys general, are very vocal and have been taking, not only speaking, it's not just rhetoric, but actually taking steps. And again, just looking at the last week, earlier this week, and so I kept on having to rethink what I was going to say, new things developed. On Friday of last week, the Department of Justice announced that they had reached a settlement in a conduct case involving Live Nation. and it had in it behavioral restrictions. That case had been brought during the Biden administration along with 20-plus attorneys general. Well, the 20-plus attorneys general, this was on the eve of trial, basically said, not so fast, we're not settling. And they're continuing with the case. And that trial is going on as we speak. Then just last night, when I was sitting here listening to the comments, there was announced that the Nexstar deal had been approved by the Federal Communications Commission with the divestiture of 6 TV stations. Turns out a couple hours before, at least 8 attorneys general and maybe more may join the case have said they're going to challenge on a national basis the legality of that merger. The merger did close, I understand, just before the press release went out, but it will now be subject to judicial review in that way. So I think we have a really good system, and it's just, it must be preserved. We must protect the integrity of the courts, and Congress actually acting responsibly in filling wherever there are gaps. But with those sort of tweaks, we have the infrastructure to be able to have effective competition policy.
This is great, and it also alludes to my further question. But let's stick for the moment to the questions I asked. Or
I think to pick up on the question about decentralization and divergence. So I think that actually the decentralized enforcement system of the EU, we have some optimistic examples of how it could be a very powerful mechanism to make sure that competition law is remaining more democratic. And I think we have some examples. So if we think of the current EU approach to sustainability agreements, to employment, the somewhat rejection or refinement of the consumer welfare standards, we can find evidence that all of those started actually at the national level, that the Commission pushed for limiting the role of sustainability agreements. If we look at the horizontal guidelines of 2004, the Commission tried to advocate quite strongly the adoption of a very narrowly defined consumer welfare standards. The courts were very cautious and reactive, perhaps understandably, but we can see pushes against those development or approaches at the national level. So we can see in the Netherlands, the Scandinavians who started bringing up the role of sustainability. We can see that also in their interventions when reviewing the block exemption regulation and guidelines. In the recent round of 2022-2023, we see a push from many member states asking for block exemption regulations about sustainability, not only guidelines. And the same is true about the recent employment cases. So we have the famous Delivery Global in the EU level, but we have many more informal opinions, guidelines at the national levels that push and challenge the Commission approach. I do think that block exemption regulation could be somewhat a compromise because of their process of adoption. So they can begin from a national case or concrete example, even from a consumer organization bringing it forward. They can often codify the approach of the court in respective cases, but also they involve the consultation of all of the member states. And perhaps one of the best benefits, they are capped in time. So even if we get the balance wrong, or we have lobbying influence, after 5 or 10 years they expire and we need to re-adopt them. So that could be a good mechanism for that.
I think there's much to take away from what's been said. I think there's always going to be a challenge for civil society to be properly involved in the enforcement process, and much of that is to do with the lack of sharing of information when you look at the procedural issues. But I think what's probably of concern to us as an organisation when it comes to media pluralism is how our regulatory authorities going to work together to make sure that there's proper implementation of the European Media Freedom Act, for example. I mean, it's a directly applicable regulation, but already you can see that it's fragmented in how it's been applied, but also there just isn't capacity, or there's huge differences in capacity at different member state level. And I think that's already becoming a concern. And when especially when you look at the Hungarian elections coming up and whatnot. I mean, an acquisition happened very recently, and we're trying to implore the Board of Media Services to at least issue an opinion, and that in itself can act as a deterrent for other member states. But I think the institutional setup and how they coordinate is going to be super important. And if you look at the DMA high-level group, we were at the last one. We were invited in a sort of novel way for civil society to present. But I have to say I was taken aback at the lack of substantive discussion between all the different authorities in the room. And it just made me wonder afterwards, what is the point of it? Even though it's obviously, the case is made for it within the law, but there was very little of substance, there was very little structure. So I think that's something that needs to be addressed.
Thank you. What I guess we are discussing, and that was raised both by Eileen and also by Or, is the role of actors that are acting on national level. Let's put it that way, that they can fill in and come up in the times of problems as well. So I think what you are saying, and I would like to move to basically to the topic of politicization of competition law enforcement, because there may be a tension between and actually, when I look at this is the questions I get and I have to defend. So now I will ask you this question, so I will be better prepared for the future. But if you think about, if one would like to open up a little bit competition law to this non-purely economic aspects, then the counter argument you get, so competition authorities will become more easy. It will be more easier to have them politicized. Whereas if you have a single narrow goal, it's easier. But when you look at the U.S., I'm trying to look a little bit at the U.S. Is it actually true? It seems that the way in which today FTC or DOJ acts it's not really about what the goals of competition and antitrust law is. It's about a different idea of using the law in a more instrumental way. And then you are saying, okay, so we have this other actors that may step in, but overall the question might be about where we are today with competition authorities and also their independence, because I think our keynote perfectly put the independence not just something that is purely technical, but something that is at the very core of the whole construct, where you have this dilemma, and then whether the agencies are independent is key to strike this balance properly.
I'm delighted you're asking the question, because I have some issues personally with what we have going on in one respect. Federal Trade Commission, which I'm a very faithful alumni. I feel a lot of pride as having started my career there, was created by Congress to be a bipartisan, independent agency. It was intentionally set up so there'd be 5 members, no more of which could be 3 from the same party. The chair, of course, was picked by the president, served at the president's discretion, and therefore would set the agenda. But I can tell you from having been there at times when there has been divergence, there was a very vocal voice of commissioners that were from the opposition party, so at least there was a dialogue. During President Roosevelt, Franklin Roosevelt, I should make clear, time, there was a case called Humphrey's Executor, where the president tried to remove a commissioner for something other than cause, for something other than misconduct. And the U.S. Supreme Court at that time said, no, that's not something you can do. I've never seen anything quite what we see now. During the Biden administration, yes, we had centralized more whole of government approach, executive order, but we had still separateness, as far as I'm concerned, with having at least the ability for there to be different voices. Fast forward to early in Trump 2 administration, President Trump fired the 2 Democratic commissioners, basically saying because they didn't agree with his policy. And this case has now is going up to the Supreme Court. There's already been arguments about it. And to have basically the chair of the FTC has indicated that he thinks there's enough divergence because he has debates with Mark Meador, who's another Republican commissioner, that you don't need to have it be bipartisan for it to work. And he says, you know, constitutionally, it only makes sense that he's constitutionally obligated to follow lawful presidential directives because he was not elected, but the president was elected. And so, of course, he should be following the policy of the president. And to me, this really is the ultimate of politicalization by eliminating potential expression of divergent voices that is worrisome. However, and I am glad that the U.S. Supreme Court actually will have a role in this, but I do worry that the U.S. Supreme Court is going to reverse Humphrey's executor and that we will have this change in initiative and a more unitary executive here, which to me is worrisome. So I think we really need to continue to focus at the end of the day, if this is going to happen, the politicalization of even the FTC. I'm not naive to think there hasn't been some political role forever. It really goes down, again, to my faith in a judicial voice, an opportunity for ultimately matters to go before a court of law. And I have the utmost respect for these general court, these judges who serve in general court, and their ability to actually deal with facts, to actually look at what is going on, not being stuck in a kind of economic debates, but really understanding the dynamics. As long as we have that, I can sleep at night. Once we get into a situation where we don't have a judiciary that is independent, a judiciary that is objective, then I think, I hope I'll be retired by then, because I won't want to be part of the process.
Yeah, so welcome to Poland. But that's actually one of the questions I think we can be asking. Are we looking just at the competition agencies, or actually we might be observing a broader change that
As
involves
Poland was mentioned, I think I might take on the politicization of competition law enforcement with some broader perspective, of course, and perhaps 3 points. First, from the point of view of enforcement at the European level, we cannot really pretend that Commission is not a political animal. Commission is political and has its agenda, has its priorities, and it is setting this agenda quite openly by its guidelines, or sometimes less openly by its decisions, but we can witness it. But the second point is the scrutiny that is given by the judges, and let's hope it is more or less independent, or fully independent, of course, but it should not be driven by a complete, I would say, blindness, that I don't see what is happening in the world, I don't see what the reality is. It is more driven by going back to the roots and to the principles of EU law and trying to say, Okay, I understand the political goals, I understand the political context, I understand the need to perhaps prioritize different economic results and avoidance of some harm, but still it should be driven by effectiveness of European competition law and what do we want to achieve on the market, at least as long as competition law is concerned. But this comes as well, of course, with the more general question, leaving the realm of competition law, of independence. And this, I would say, spillover of the discussion is visible in many, many domains. SPEDPRO was mentioned today as a case where a national authority was supposed not to be very reactive to some complaints because perhaps of political agenda of the and perhaps of the antitrust authority, and it came with sort of test whether you could apply the LM judgment and say, do we have a systemic problem with independence of authorities, be it enforcement authorities or judicial authorities in Poland? And this case was, I would say, a case on the risk assessment. And the General Court stated, okay, there is a risk, so maybe we'll invite the Commission to handle it just in case this risk is there. But it was not a pure statement, there is a problem with independence. It was more, okay, there is this doubt, maybe somebody who is outside of the whole setting, of the whole political setting and economic setting should look at it anew with fresh pair of eyes. This said, we have a new SPEDPRO case now pending on the merits again, so we'll see. So there is a problem of independence, but coming back to the politicization, it has two sides. If we broaden the goals, both enforcement authorities and the courts can ask themselves, are we still competent to assess it? Do we know enough to assess the harm? And this is a very open problem. But on the other hand, if we don't broaden the goals, it means that certain things are simply not seen. So we either extend our powers by broadening the objectives, or we leave it just drift with no control. So this is a very open question, and I have no answer to this.
Thank you, Christian. So another dilemma, I guess. Or you wanted to jump?
Yeah, so my suggestion is that actually this critique is misguided. I don't think it's really about politicization. I think it's about instrumentalization of competition law. So competition law is inherently political, and that's okay. Of course, if we decide what cases to enforce, how to enforce, whether we adopt the consumer welfare is political, even in the sense that it will have impact on economic and social choices and distribution across the society. So I don't think we have a problem that competition law is political. We have the problem when competition law is used to achieve other goals beyond competition law, however you construct it, as narrow or broader. And this is where, and I think Elina and Christina alluded to it, where we need institutions and standards. But not to defend politicization, but to affect using competition law for the wrong purposes. So if we have somewhat more clear standards of how the law should be applied, but even more so, if we have processes in terms of independence of competition authority, independence of panels, I will add diversity of panels, that we have the right people sitting on the table and making the choices. And I think we can see some examples that we didn't have when we look at certain products in certain markets, that the right voices were not there, where we have strong and independent courts. This should be the focus.
Great. Mark, you want to? Okay, So thank you for this part. So I think it's time to open the floor to questions from you. I see Kathy. I just say that I just explained that the panel is very diverse. So our audience is also very diverse. So we have, for those of you who have from outside Poland, we have here academics, representatives of Polish Competition Authority, judges, practitioners, PhD students, so really. But I see Kati Trzeres from University of Amsterdam, please.
Yes, thank you very much. This is a very unique conference because it doesn't occur to us that two judges from the Court of Justice are here. So I take a little bit the opportunity, I address it to you, but I can address to others also. In my presentation, I will go more into it, but it comes back here as well. What is the role of competition authorities in liberal democracies, independence? The SPETPRO case was just mentioned, which I also see an opening by the court, bringing competition authorities and looking at their work closer to courts. I wrote a paper about it. There are many things we can discuss about it, but what we discuss here is that they are similar to courts. They are there to protect fundamental rights, right? We are talking about markets, economic rights. My question is, when these institutions don't work well in certain countries, and we see that they are fundamental parts of this whole system and protecting not just consumer rights, but also, once again, fundamental human rights, and you mentioned also the Commission, shouldn't there be some kind of mechanism also under the umbrella of the rule of law, protecting democracy, that when this dysfunctions, that there should be avenues, like in the SPETPRO case, that if such an administrative authority doesn't function at the national level, then at the EU level this could be taken up. And I have been involved in other cases where I felt that the procedures, I will not contest them what they are because they are excellent and constitutionally long-standing on the Commission, but shouldn't the Commission sometimes also be pressed to take rule of law backsliding into account and rethink its own role and its own procedures when complainants go to them and they just cannot make their case because they do not get the relevant information, etc., etc. So I'm just thinking about it. What do you think as the highest level of interpretation? Whether, this is not just at a level of, as you also discussed, these technical issues, but how do we make this system work? Because we are reliant on these competition authorities who come very close. Once again, we talk about quasi-judicial powers, but they are not courts. If you talk about preliminary decisions, they cannot ask questions, right? Maybe they could be asking questions so that there's also some kind of judicial dialogue on these very important questions. I know these are big questions, but once again, the occasion is very unique. Thank you.
Anyone?
The two judges were mentioned, but allow me to be the first. Perhaps Mark will want to join in. Well, the question of independence is, of course, a transversal one, and it is very difficult to comment on this in a conclusive way because being Polish and observing since, I think, 2016, the political situation where different bodies seem to be captured, are accused of being captured. There are judgments both from the Strasbourg Court and Court of Justice stating the lack of independence, and still the situation is not completely improved. Allow me to say this. We see the limits of judicial reaction, that we can state the problem, we can identify the lack of independence using different instruments, but then it goes down to political powers to improve the situation or change the situation, and if the situation is blocked for political reasons, we are remaining in a sort of a limbo. So I don't have a complete answer to this. But this said, it is a question of awareness raising as to the standard of independence. It has been broadly discussed, and now I think we really have a set of standards to say who is independent, who is not independent. So in a sense, the judicial assessment is really easier now. We know what we are looking for, we know how to assess it. And then I would say it goes back to enforcing it. So how and when and who should enforce it. And this slips away from the hands of judges. I don't want to sound weak on this, but you need the whole system somehow to cooperate to as well execute what the judges are saying. Yes, so that's, I think we are all aware of this. I'm sorry because it's very broad as an answer. I gather that you would want to know more about independence of competition authorities, be it at the national level or even at the European level. We have this ECN Plus directive that insists on financial independence, on structural independence, on constitutional independence. I would say the instruments are there. Again, the standards are set, but it has to be implemented. And I would say as well, it has to be believed in a little bit. It has to be executed in good faith, because we have a repetitive scenario that all the standards seem to be fulfilled, but we end up with perhaps a solution that is not fully satisfactory to what we perceive as full independence. So. Or maybe the achievement of full independence in terms of enforcement authorities is too much to ask.
Thank you. Any other questions? Okay, so I see 3 questions. Can we maybe collect these 3 questions? I think we'll make it. So.
Thank you very much. My name is Eva Gromnicka. I'm with the legal service of the EFTA Surveillance Authority, and I just wanted to make a comment about the SPETPRO case, because I think I completely agree with what Krystyna has said, that we cannot forget that the Commission is actually a political body, and the Commission has been involved in all the discussions concerning the rule of law in Poland and the developments and, you know, conducting dialogue with the member states. But in the SPETPRO case, I actually see this very positively as the court coming in and rapping on the Commission's fingers. You cannot just, move the case to the decentralized level, say like this is the good way to do this, without you actually conducting the check whether the authorities are independent. It should be your prerogative. You're telling the judges in other member states it's your job to check whether your colleagues in other member states comply with the conditions of independence. You, as an administrative body, as the guardian of the treaty, should be actually doing the same thing. And the other thing that I mainly deal with more with data protection than competition law cases, and I see there are like certain parallels about how the notions of decentralizations and the importance of enforcement on the lower level, how they work and what is important. Also from the point of view that in data protection, we're talking about fundamental rights, how important they are. You will have, and we already have had situations where you have competition authorities stepping in and saying, well, there are breaches of data protection. How do we deal with it? Can we take it into consideration? Does it go anywhere else? So this is more like, throwing this out for further thought and discussion. Thank you.
Thank you. So there were 2 more questions up there. One here. And one here. Okay. Yeah, but I think there were...
Thank you very much. Ioanna Badoglu from the UK Competition and Markets Authority. I have a question in relation to digital markets. So some of the comments around the consumer welfare standard and the sort of factoring of consumers as citizens. When you look at digital markets in practice, how do you make that assessment without being at risk of being pulled towards different value statements from different stakeholders and retaining an objective assessment of the evidence so that, different parties feel heard, but you still have an objective framework to analyze the different views from the stakeholders?
Monica was first. Monica first. Yeah, go.
I already have a microphone. Thank you very much, Monika Wojniak-Ciechota, University of Warsaw. I have a question actually regarding broadening of goals of EU competition law, especially, but also US law and consumer welfare standard. We have numerous studies, empirical research regarding various goals of competition law that are present in the case law. However, I have a question about interpreting the consumer welfare standard. If consumer welfare itself is a good tool to protect values protected presumably more obviously by other goals added to competition law recently even. However, if the consumer welfare standard is still can be a valid tool, and we have such cases related to data protection. I think that 10 years ago nobody would notice data protection as a value related to consumer welfare standard, probably academia only, early academia. So I have a question about using such a consumer welfare standard. Still valid.
Okay, so Dr. Walulik, and we'll try to answer, and then we'll...
Thank you, Jan Walulik. I have a question. Can we afford effective and pro-democratic and consumer welfare-oriented competition policy and free international trade at the same time, especially if this trade involves actors from jurisdictions that do not follow the same principles and promote national champions at the cost of other stakeholders?
Thank you. Thank you very much. So we have 3 questions. Yes. So we might make another round. So I would like to invite you to comment on this question.
So really excellent question. I'll try to answer them briefly. So starting with the UK CMA, I think the recent the Green Agreement Guidelines informal opinions that the CMA issued in the past 4 years is an excellent example of how you can apply in Section 9, so the equivalent of Article 101(3) criteria in a way that takes into account various non-competition interests, so sustainability, climate, reduction of emissions in the global level. You have examples about the combination therapies, so how to apply competition law to healthcare, all very difficult, highly regulated markets. You have example in the financial markets, in the recent deprioritization decision that was issued January, I want to say. So I think we have the tools, we can see how it works. As a member of the CMA, my point will be, don't do it in informal opinions, be brave. Do it in a binding decision that we can use as precedent, that could be subject to judicial review, and that we can use for it. And I think this also links to the question about broadening the goals, but also entering industrial policy. There are a lot of examples, and I think the notion of consumer welfare is problematic. Mario Monti, which introduced the notion to the EU, probably, I think that's not contentious. It was his work, openly acknowledged that it was a PR exercise, because who can say that consumer welfare is a bad thing? We all want to be better for consumers. But it's not, in my opinion, a prescriptive tool, in the sense that if you apply the standard, it's not that it helps you to direct you to one way or another. On the other hand, we do have tools. So we have Article 101(3). We have the ancillary restraints, although I think it's maybe more vague. We have Article 106.2, which is not used much in the EU, but it's a perfect way to balance between state or national legislative and competition law. We just need to use that. When it comes to the national champion questions, wouldn't you say that actually if you broaden competition law, then you can better take into account questions of champion? Do you see it the other way around?
I meant that in international trade we have actors
Uh-huh.
who have comparative advantage, that they come from regimes which promote export, promote national champions at the expense of the consumer, at the expense of
Yeah.
other stakeholders. I don't mean only subsidies.
Yeah.
I mean the general policy.
Yeah, and you don't think anti-dumping is the right policy?
Not only the anti-dumping, I mean their general policy and their involvement in international trade. And
So where would the competition law concerns? So why do you see competition law as the right tool?
I mean, can we afford consumer welfare-oriented competition policy locally and free international trade, which involves these kind of actors at the same time?
So you're thinking of exemptions for export cartels or something even broader?
No, broader. I mean the general policy of jurisdictions that do not follow our principles that we're discussing here, and their actors are involved in the international trade.
Yeah,
And- And can we afford effective competition policy that is oriented towards the consumer welfare if these actors are present in our market? Is this possible at the same time?
So it's a complex question, and probably there's a lot of sub-questions or sub-scenarios that we need to examine, and I might have different answers. I think...
And we just have 5 minutes.
Yeah, no, I mean, I wasn't planning to answer, but I think the way that the jurisdictional interpretation of competition law to extraterritoriality cases could capture some of those instances.
No,
but
not,
the rest
not really.
But okay, let's discuss it after. I think Maciek will kick it out. I'm curious to hear more about that.
I'm limiting Jan's freedom to speak. Sorry. Do you want to take these questions? And I think we'll have to wrap up as well. So if you want to say anything on top of what we discussed, answering the questions.
Maybe just one point, because it reoccurred in at least 2 observations. I completely agree with Eva on SPEDPRO and decentralization. But there were questions on data protection and this new, I would say, extension of consumer protection issue. And I imagine you refer to this Facebook preliminary question from the I think Bundeskartell and not Bundeskartell, but the cartel court, the German cartel court. Of course, it is an interesting example when we say, okay, protecting consumers implies as well protecting his or her data. And it is as well a very nice example of handling a plethora of different authorities that deal with this question and saying they should see each other and they should take into account their decisions and try not to adjudicate in different ways. But I would say this is not such a striking extension of the goals. I think if you look at the whole discussion on sustainability and future consumers and future generations and protecting the environment being the protection of consumers, this is much broader. And there I might understand that the Commission is a little bit afraid to completely broaden this to this point. But this comes as well with the question of consumer as a citizen. Are we really still protecting the antitrust by this? And yeah, I was trying to signal to you that I think the European legislator understood that addressing the democracy issues for the big players would be better handled under the internal market instrument, DSA, and not via through the door of antitrust. This doesn't mean that it might come as an additional argument to protect consumers, because they remain citizens as well, of course, yes. But this was under the head of plurality of media, plurality of access to information, which you can discuss it, but it remains a market issue. So it was a little bit, it was an extension, but it was a controlled extension, I would say, of goals of protecting consumer welfare.
Eileen, Mark, any
One
thoughts?
quick question to answer to yours. I actually think the consumer welfare standard is broad enough to really deal with whatever you need. We had a debate about 5 years ago in Congress whether the consumer welfare standard had to be changed in light of to address high tech, big tech, or digital sort of things. And I wrote an article at the time I'd be happy to share with you saying, no, it's flexible enough that it could address it if that's what the objectives should be of the government. I didn't get into whether that should be the objectives, but that it was broad enough.
I think maybe slightly tangential. I mean, I think it'll be very interesting to see how Ireland handles the Council presidency, because they're going to come under quite a lot of pressure when it comes to data protection specifically.
I know that there were more questions, but I think we need to close this session right now. So we discussed substance, procedure, institutional, politics, lots of things, but I hope you enjoy it. I would like to invite you to thank the panel for their presentation. And we have a long break. This is with Rory. We thought that it's for this conference it's good to have a relatively long break. So we have 35 minutes break. So we have time to continue the discussion, and then we will have a second panel.
long break full of conversation and nice meetings. My name is Agata Jurkowska-Gomułka. I'm from University of Information Technology and Management in Rzeszów, but I'm also a permanent collaborator, permanent objector, something like that, connected to Center for Antitrust and Regulatory Studies at the Faculty of Management, University of Warsaw. And I have a pleasure to conduct and to moderate the second panel of the conference. Our task within this panel is to talk about shaping digital commons. What digital commons are about? They are considered to be digital resources of various kinds. Digital commons the concept covers software, knowledge, data, educational resources. Digital commons are produced and governed by a community, and they are intended for a common use, for a public use. I'm pretty sure that my colleagues will develop this very simplistic definition. Digital commons nowadays, they play a vital role in education, in research, in public governance, but of course, and in economy. But in order to be provided, they need an access to infrastructure. This is one side of the story. And the second is that they need an access to the audience, and the audience needs an access to digital commons. So our panel will greatly focus on a sort of tension between private and public. Private power, public power, private governance, public governance, private digital infrastructure, public digital infrastructure. We will talk quite a lot about various manifestations of gatekeeper powers, but we will also try to look ahead. And we would like to propose you a discussion on effective and efficient regulatory and societal responses to existing gatekeeper powers. I would like to introduce the panelists. Claudia Mayher. You know her, our award winner, postdoc fellow with the Competition Law Hub and research fellow at the Robert Schuman Center for Advanced Study at the European University Institute in Florence. Małgorzata Kozak, currently a researcher at the Institute for Legal Studies, Polish Academy of Science. Małgorzata also worked as assistant professor in European Union law and competition law at the Utrecht University School of Law. Kati Czeres. Sorry, Kati. Yeah, that's always a bit challenging. Kati is an associate professor of law at the Amsterdam Center for European Law and Governance. She's also the head of the EU law section at the Department of International and European Law at the University of Amsterdam. And the list of institutions and organizations Kati is collaborating with is very, very It's very long. If you are interested, well, I can offer it on demand, let's say. Antoni Napieralski, PhD in law, assistant professor at the Department of European Economic Law, Faculty of Management, University of Warsaw. And Laura Zaboli, a lecturer at the Faculty of Law of IE University in Madrid. Laura is also the academic secretary of the Center for Antitrust and Regulatory Studies at University of Warsaw. And currently, Laura serves as a deputy editor-in-chief for Yearbook of Antitrust and Regulatory Study. And Laura will open this panel.
Thanks a lot, Agata. I think the introduction shows that I truly feel home at the University of Warsaw, so I'm very happy to be here. I want to thank the organizer for this opportunity. I have been asked to open this panel, which is not an easy task because, of course, Agata kindly asked me to give some definition and some common categories we will then comment on. And of course, this pushed me in making some general comments on what do we mean with digital commons, what do we mean with market power in an area of digital commons, and generally speaking, if the legal categories are running at the same pace of the economic phenomena. And I want to borrow from our keynote of this morning. Of course, we cannot have competition law as the panacea, as the legal category that should solve every, potential democratic deficiency of digital market, but it's interesting to understand better if and how it should be kind of rethought. And this is where I want to start with a very, very basic point, which is that, of course, when we discuss about digital commons, we used to discuss about something that is collectively indispensable. So the definition of digital commons is in a sense of considering this asset as something that should be available for the collectivity. And this is where we can find the first tension I want to discuss, which is that as per now, we do have many categories that fall under this idea of essential infrastructure that, of course, are not public. They are privately controlled. So the question is, should we redefine digital commons as space that welcome everyone, but that might be governed by a limited number of actors, right? So in this sense, gatekeepers, of course, are not just dominant firms, but are controller of essential infrastructure. And this is, of course, something that already result in the mandate of the EU Commission in the Digital Markets Act. And of course, when we discuss about digital commons in the digital realm, we think about stakeholders that may dominate the relevant market. Google, Saga, of course, we may argue that the market was well defined, but this is the case in many other cases, including the recent open investigation against toward Meta and WhatsApp. So generally speaking, we can define the relevant market, and this is where competition law should start. But the real question is, does it, the market is truly what we are talking about? Generally speaking, the premise of competition law is, of course, we define the relevant market and we assess the market power in the relevant market, but we're in front of stakeholders that have structural control over the access, visibility, and interaction, much beyond, I would say, traditional dominance test. So at the end of the day, we may argue that they do have control over access to user, over visibility of content, over interaction between their services and alternative services. So the question is, do they operate in a market or do they provide an infrastructure? Of course, this can be pushed to the point of defining digital commons as something that is collectively indispensable but partially controlled by private stakeholders. So my point is, of course, in the sense of trying to reinforce what I'm saying by showing how also the recent investigation started by the European Commission point in the direction of considering these big techs, these digital dominant player, as players that are going far beyond the traditional concept of dominance. And this is happening, in my opinion, through something that we can relabel as architectural control. And I will make few examples just to support a little bit this very generic statement. I think we can reconduct these to three main patterns that are actually happening in the digital commons realm. The first one is the so-called architectural embedding. This is where we have a recent investigation started by the Commission in February 2026 against Meta and WhatsApp, and the focus of the investigation is truly the small circle we all have on WhatsApp, right? Right now, when you open your WhatsApp interface, you will find a small circle that is redirecting to Meta AI. And the problem there is much more advanced than tying, in my opinion, because of course it can be labeled as a simple case of tying, meaning that WhatsApp is pushing us to opt for Meta AI. But in my opinion, this is going much farther because it's embedding architecturally the AI within the digital common. In other words, this architectural embedding is going in the direction of excluding other players, other stakeholders, not just with contractual exclusion, but through interface design. It's nothing new under the sun, I know, but it's pushing this in a dimension that is much advanced than traditional Google Android and other lookalike case. The second way in which, in my opinion, we are pushing toward a new definition of power that can be linked to this idea of architectural control is, of course, through this idea of controlling the interface design. And this is where we do have already a regulatory response, particularly in Article 25 of the DSA. So the idea of not just doing simple cell preferences, but controlling the overall design of the interface in a way that is exclusionary by definition. And last but not least, we have the third pillar, which is the so-called infrastructural dependency, which results, in my opinion, from something that is much less detectable, including strategic partnership. To make a long story short, we may expect AI to reduce the market power of big techs. The opposite is happening, right? Because with strategic partnership, the main stakeholders are actually managing to establish some sort of oligopoly, starting from the infrastructure, moving to the overall, let's say, digital markets. And this is also where we have a case, an investigation started in December 2025, so it's still a statement of objection by the Commission against Google, because Google was actually introducing in its own infrastructure, as you may have noticed, an AI system giving us an overview of the result. What is the different complexity here is that, of course, the point was that Google was actually exploiting the investment made by other stakeholders by providing the user with the result in the platform itself. So with some sort of, let's say, mediated offer. So in my opinion, the elephant in the room, what we need to discuss is that we are moving toward definition of control that is, of course, not just market dependent, and that, of course, can be addressed by many tools, which are also regulatory instruments ex ante. This is where I think the combination of the tool is making the EU moving in the right direction. We do have the Google Shopping Sega in this direction. We have two recent investigations that I mentioned started by the Commission. Both the DMA and the DSA consider this architectural power, consider in one case the need for ex-ante obligation in the DMA that, of course, push in direction of not considering the power market by market, and the DSA and the Data Acts, what I mean with the Data Acts is, of course, Data Act, Data Governance Act, do consider the need of interface transparency and risk assessment, not depending from market power as well. My point here is that we need maybe to reconsider the definition of control, because of course it operates through what I define as a layered architecture. So it's of course the power on the specific defined market, but it's the control of the infrastructure, the control of access of users, access to data, design of the infrastructure, which at the end of the day kind of take distances with traditional competition law categories that are linked to product market paradigms. So I'm not suggesting to ask too much to competition law, so competition law as an ex post tool should remain anchored to market definition, but I guess we need to make it more clear what are the definition we want to tackle, what are the issues we want to tackle. So the question is, if we may argue that digital infrastructure mediate market access, not in a specific relevant market, but generally speaking, then maybe we can push this to the point to say that private actors are actually controlling infrastructure in a way that is architectural and not market defined. So to make a single conclusive statement, I think that digital commons open, the discussion under digital commons opens the key question, which is how can we define the relevant market in which the providers of digital commerce are operating, and if so, if regulation ex ante should go the way to go and competition should remain its original mandate. Thank you very much.
Thank you very much, Laura, for sharing your views and your ideas about how to tackle the problem of an insufficient access to infrastructure and to data as such. I suppose that one of your conclusion, but at the same time, the starting point for discussion is a redefinition of a concept of control within the antitrust trust law. You mentioned Article 102, but I think that that's the same story with merger control. Also in this area of antitrust, we do need to think the definition of control once again. Thank you very much, Laura, once again. Could you leave our hot chair here? And I would like to invite Claudia Mayher, who's going to tell us who shapes what we know.
So good afternoon, everyone. And first of all, many thanks to the organizers for putting together such a timely event. It's a real pleasure to be here. So I'm going to zoom out a little bit more as compared to Laura's presentation, and I'm going to talk in this initial intervention about platform power within the information knowledge regimes. So this is something that obviously has strong interconnections to the kind of idea of digital commons. We know that since quite a few years we've been grappling with the so-called epistemic crisis, so the crisis of the knowledge regime, especially in the online context, and that the rise of online platforms has contributed quite substantially to that crisis. And just a couple of phenomena. So we have currently the phenomenon of dislocation of news retrieval and consumption. And that means that we no longer go to our traditional sources to obtain news, to obtain information, but we use online sources, social networks, etc. And that graph on the top shows the decade of sources of news in Poland, actually. So 77% of citizens right now go to online sources, 54% to social media. And we use a variety of networks, but the networks that are currently on the rise are those that are featuring kind of video news formats. Also, AI chatbots are here kind of a newcomer. So we know that platforms have become a very important information infrastructure. And that, of course, as such, is not a problem. But we also know that there are a lot of harmful phenomena occurring in the online sphere. So disinformation, misinformation, deepfakes, echo chambers, we all know about them, and the AI kind of aggravates this phenomena. And this is just a very recent example of a harmful thing happening right now. So there was this widespread deepfake Polexit campaign on TikTok that happened just a couple of weeks ago. The European Commission is currently looking into it from the perspective of the DSA. So obviously these harmful phenomena have a very serious impact on our democratic discourse. Now, AI tools have also been or are being used by online platforms in a way that may harm news publishers, quality media companies. So AI tools, so just a few examples. Algorithms are used for the purpose of content moderation, and that may result in a prioritization of content that is sensationalist, divisive, and that may obviously impact quality news publishers. Platforms also train AI on publishers' data, which may lead to exploitation. There are also new tools, and I think we've all experienced those, AI overviews, AI mode on Google. And such tools basically answer users' queries directly without kind of reducing organic traffic to news web pages. And when I was preparing this presentation, I just Googled AI mode Google News Publishers, and this is the response that I got. So Google's AI-driven search features, including AI overviews, AI mode, have fundamentally shifted how users interact with news publishers. As of early 2026, these features have caused a significant decline in traffic to news web pages, with some reports suggesting a 27 to 89% drop in click-through rates. So obviously something that is affecting financial kind of viability of quality news media. What is also affecting the financial viability of news companies is this competition for ad revenues that has been going on for many years and that is still ongoing, so competition between platforms and news publishers, and that's obviously the competition that platforms are winning thanks to their huge data advantage. And currently we have the situation of oligopoly, or rather triopoly, where the majority of ad spending goes outside of China, goes to Meta, Alphabet, and Amazon. So that's obviously not great news for publishers. And this is all happening not in a political vacuum, right? So this is all happening in the context where we have a couple of very powerful tech executives who are, weaponizing the government and kind of cozying up to policymakers to exert kind of outsized influence over policy and politics. And this is obviously, we all know this picture, I think. This is from the inauguration of President Trump. But what is happening right now, this weaponization of the government through corporations, obviously has grave impacts on our ability to govern in Europe too. That's something we've heard a lot about in the recent weeks. So that shift from publisher control to platform control information ecosystem impacts not only markets, but also the digital public sphere, human rights, democratic values. So something should be done about it. Now, over the past years, commentators, academics have come up with different terms and definitions in order to capture, in a way, the various facets of platform power. So we have concepts such as data power, information power, ecosystem power, intermediation power, opinion power, and that last concept is something that Gosia and the colleagues from Utrecht have been working extensively on. In my article on which I based this presentation, I used the concept of epistemic power, which I define as power over certain segments of the online information space and the actors operating within it, so media companies, users, and power to influence knowledge production, distribution, and validation. And just to be more kind of specific, so I've identified in a way 6 facets or 6 sources of such power. So the first is infrastructure dependence. So we know that users, publishers, other media companies depend on the infrastructure built by platforms. And platforms have become, in fact, an important, in a way, passage point to access audiences. And that high dependency obviously has or creates the risk of exploitation, free riding on publishers' content, etc. Then data advantage, that's something I've spoke about already. value chain capture and economic extraction. What I mean by that is that platforms dominate entire value chains. So I think about Google and the ad tech value chain, but also kind of more recently, platforms have become dominant across different layers of the AI value chain. The fourth aspect is automation and AI integration. That's something I've mentioned already. The fifth aspect is protocol control and private ordering. And what I mean by that is something similar to what Laura has said about architectural control. So basically platforms shape the information infrastructure, architecture, they set the rules of the game, and everybody else has to basically adapt. And the last point is epistemic asymmetry, so basically non-transparency, opacity. So these are the sources of power. Now, what should be done with this type of power? So one tool to go to is competition law, Article 102. Now, Article 102 obviously does not prohibit power. It prohibits abuses of power by dominant firms. And I do not have the time to now go into this, but I've argued in my paper that competition law has the potential to, in a way, address practices falling into those different categories. So free riding, exploitation of data, self-preferencing of AI tools, etc. Perhaps one exception here is epistemic asymmetry. I think transparency is a rather kind of concern for regulation. So competition law can exert different kind of pressures, but obviously the in a way interventions that are most valuable here or would be more effective are those that can create deeper, in a way, structural changes rather than only behavioral modifications. And this is a matter of selecting an enforcement kind of or prioritization of enforcement in certain areas, or the use of remedies. Obviously, for competition law to be an effective tool here, we need stricter competition enforcement, and that also kind of what's important here is the integration of non-economic goals into competition law. That's something I think the panel before us talked about, and I think Kati and Gosia may speak about this as well. And I think that the embedding of competition law within the broader kind of constitution of the EU justifies, in a way, looking into also non-economic concerns here. And that would require treating individuals not only as economistic consumers, but also as citizens with different types of interests, values, and preferences. And already in my PhD, I argued for kind of having a closer look also of closer look at our epistemic well-being as citizens under competition law, instead of only looking at our consumer welfare. And I think that now, with the arrival of AI, this is somehow, I think, more important than ever. The second set of tools to go to can be obviously regulation, and the DMA. I wanted to say a couple of words about the DMA and the DSA. Competition law is obviously an ex post tool, is a reactive tool, and in order to kind of more effectively prevent this type of power, or create some deeper structural changes, we need ex ante tools. So the DMA, in my view, can or has the potential to prevent such epistemic power from arising. It has provisions on data exploitation, on advertising, on interoperability. So I think if enforced properly, and that is currently in the current geopolitical context also in a way a little bit of a question mark, then the DMA as an ex post tool in combination with the competition law as an ex ante tool, as an ex post tool, has the potential to, in a way, insert some deeper or kind of trigger some deeper structural changes. Now, when it comes to the DSA, even though the DSA is an important platform governance mechanism, I ordered in my paper that it may not be as effective, probably in this respect, although it should be. And why? And just a couple of examples here. So transparency is under the DSA a central regulatory tool. So we have a lot of provisions on transparency of content moderation. But transparency, at least as I see it, or non-transparency, is just one aspect of that epistemic platform power. And basically, in a way, placing an excessive focus on transparency, on these procedural issues, in a way, may fail to address kind of more deeper structural substantive problems. The second new kind of regulatory mechanism under the DSA are systemic risk assessments. So we know that platforms right now are obliged to analyze how their services impact fundamental rights, such as media pluralism, right to information, etc., and implement mitigating measures. But I think tasking platforms with this type of issue or exercise may actually strengthen their power or interpretation of fundamental rights, which is can be quite subjective, risks in a way giving them more power rather than limiting it. So my, in a way, conclusion here was that the DMA in combination with competition law may actually be more effective. And just final remarks. So how to achieve genuine epistemic welfare? And obviously I don't have an answer, but just a couple of remarks. So competition law and digital regulation embrace predominantly market logics, right? So we have this, right now in our discussions, in our discourse, we have this marketized conception of relationships between citizens, media, platforms, democracies. And this is in a kind of partially justified because, as other authors have said, the irony is that the layer that produces the most identifiably public goods is also the layer most dependent upon private companies currently. So I think the solutions have to, in a way, be grounded in decoupling digitalization and marketization in how we shape information spheres. And what it means is building more public alternatives, public digital infrastructure, removing the dependencies on big tech. In particular, or kind of as a starting point, we should think about removing these dependencies within the area of public services, so the provision of government services, education, healthcare. And this is just one example that I've came across when I was preparing this presentation. So the Commission has just now registered European Citizens Initiative, calling for a European social media platform. And how this is defined, so this is a public social media platform at the European level that would form an alternative to the current platforms, work as a service for the society, be funded by the society, and be under its oversight. And it could stay impartial and independent from political pressures while also guaranteeing rights of the people without distinction. And this is obviously a kind of an ideal scenario here, and the devil is in the details, but I think if we talk about digital commons as something beyond the market, even beyond the state, we need such alternatives really to create, in a way, counterpower to restore the democratic control over our digital public sphere. Thank you so much.
Thank you very much, Claudia. For me, epistemic well-being and epistemic welfare is going to be a phrase of the weekend for sure, because I have to think of this type of well-being as a probably desired goal in my private and probably professional life as well. Claudia presented the epistemic power and its sources. The question that arises here is, could be probably if there are similarities or maybe full identification between epistemic power and old-fashioned economic power or dominant power on the market. I suppose that epistemic power nowadays is quite difficult to capture because, as we could see from Claudia's presentation, the sources of epistemic power are much more scattered and much more diverse than the sources of traditional or classical economic power. But as I understood, Claudia proposes, well, enforcement of competition law, of regulation, but also the escape to totally new areas, such building the public infrastructure, digital infrastructure that could allow to overcome somehow the epistemic power of gatekeepers. We're going to continue the considerations on private regulatory power, private market power. Antoni, the floor is yours.
Thank you very much. Thank you for having me. After these two excellent presentations, I will now zoom in a little bit and focus on what can we say about competition law and its reaction to private regulatory power in the EU. So I have three main points to make. First, I wanted to discuss very briefly how EU competition law approaches a very specific expression of market power, which is private regulatory power. And I will give you two, I think, and hope, interesting examples where we can observe that. The one being digital ecosystems, the other one being professional sports and sports federations. And the second point I will be making is that, as it seems for now, EU competition law approaches private regulatory power in those two areas of ecosystems and sports in a similar manner. A conclusion that is a bit puzzling to me, and I hope to explore this with you. And finally, the final point, that maybe, just maybe, EU competition law and its reaction to private regulatory power in ecosystems, maybe it should be different. So let me start with explaining very briefly what we can understand as private regulatory power in the context of EU competition law. We talk here about a very specific expression of market power, where an undertaking has the ability to impose non-negotiable rules on their business partners, on their customers, and eventually on the consumers or end users. And what is probably the most interesting thing about private regulatory power in this context is that it comes very often with a structural conflict of interests. To use a metaphor, we're looking at undertakings that are at the same time setting the rules of the game and then playing in that game. So if we think about more specific examples where we can find those conflicts of interest, I mentioned the digital ecosystems. If we think about app distribution, how it is organized, we have large players who are defining the rules of app distribution on mobile phones, and then at the same time are also participating in those markets. So they are defining the rules for smaller app developers, but then they also act as app developers themselves. So we're talking about a problem of temptation, where the rule maker is tempted to set the rules in a way that it's profiting them the most. The same goes for self-preferencing conduct that we know, for example, from Google Shopping. The second area where we can find those types of structural conflicts of interest is another completely different corner of EU competition law, namely cases concerning professional sports and sports federations. If we look at the judgments of the Court of Justice in European Super League or International Skating Union, we see that what is looming in the background of all of those cases is the same problem. Oh, let me just switch the slides. So it's the same problem. In the context of the sports federations, we have entities which are at the same time making the rules and then monetizing those rules through how they are controlling the clubs, they are controlling the athletes. So one thing that I find similar in how European competition law approaches private regulatory power is that we can identify similar structural conflicts of interest in cases concerning digital gatekeepers and in cases concerning sports federations. And probably the most important observation, that the most important similarity between those two areas is that in neither one of those, competition law puts into question the mere fact of holding a regulatory power by the undertaking. What we see instead, and what I wanted to show on the slide, is the introduction of the so-called good governance requirements. So instead of putting into question that a specific undertaking has so much regulatory power, we are talking about ensuring that the rules they introduce are fair, that they are non-discriminatory, that they are not an example of self-preferencing, that they are objectively justified, necessary, and so on. But we are not touching upon the source of the problem, which is the conflict of interest that comes from this double role of both ecosystem orchestrators and sports federations. And I find this very puzzling that we see ecosystems, let me go back to the previous slide, we also see that digital ecosystems fall into the same category of sports as sports federations, because there is one significant difference between those two. There is, and we find this in the Treaty on the Functioning of the EU, societal value that is being brought to the table by the organizers of professional sports. And regardless of what we think of some of the sports federations, there is a clear legal basis of why competition law should tolerate those peculiar legal monopolies that are characterized by private regulatory power. And that it justifies why, in the context of sports, instead of putting the regulatory power into question, we try to adapt it through the imposition of good governance requirements. And that's something that's completely missing in the context of ecosystems. One thing maybe I could conclude with and leave us as a starting point for the discussion is that maybe, just maybe, in the context of digital ecosystems, maybe we should take a step back and instead of introducing in a manner similar to what's going on in the sports cases, the good governance requirements, maybe we should think about whether we want to tolerate private undertakings holding so much regulatory power without anything of added societal value that they bring to the table. And maybe if we see structural measures, structural conflicts of interest, maybe we should respond to them with structural remedies. And that's a full stop. Thank you very much.
I think that we will suspend for a while the questions posed by Antoni. I find it very interesting, this comparison between private regulatory power in sports and private regulatory power of platforms nowadays. I don't know. At the end of the day, everything started with societal values. Maybe just this concept of social media was very misleading at the very beginning because a lot of people thought that social media can somehow contribute to enhancing social welfare and interhuman relationship. Thank you, Antoni, once again. I would like to invite you to the presentation by Kati about regulatory responses. We are going back to institutional issues and independency of regulatory authorities.
Yes, thank you very much. And indeed, last-minute change is what I could do best because we have so many great experts on the content. So I will shift a little bit to more the enforcement and institutional side. But before I do that, really thank you for inviting me, both for the foundation and the organization. Yeah, this is a kind of, I have already 2 homes, so maybe the 3rd home, and I hope so. These type of foundations and support for also for academic work and policy work could bring us from different perspectives together. I think other countries need that type of space where we can meet and discuss these issues. I didn't collude with Mark. How does this work? Yeah? The other way around. Yes. But I also thought we need to set the discussion against what is going on in the world. And indeed, this week, these statistics came out. So discussing how to regulate, what to do, what are the regulatory responses to gatekeeper power or this complex ecosystem that we see in front of us created by the big tech. We need to acknowledge that there are increasing number of countries or even more that are not democratic countries anymore. Autocracy is really on the rise. There is a great reversal, as you can see here, and I think it has very important implications when we talk about not just the substance, but also on the side of, who is going to do this and how, who are the enforcers, the institutions that are going to, that are supposed to do and take into account all these regulations and all these valuable ideas and democratic values. So I leave that here. I would like really to shift a little bit the picture to indeed institutions and to a different dimension of gatekeeper power or platform power, digital presence, to also to the idea that has been voiced by now also quite often, the problem that what is happening in front of our eyes is not just, you know, a move from what is happening with indeed the epistemic rights that we have as citizens, but also how these platforms fill in a space displacing actually state institutions in many respects. So there is a kind of new trias politica emerging where these platforms, through the control of technologies, so the baseline is this global economic power, also manage to and present in rulemaking, in education, in complaint or dispute resolution. Think about Meta, who set up an oversight board. So they are also present in very critical areas of our social, economic, and political life, as we discussed, surveillance, privacy, freedom of expression, but also on the enforcement side, right? So they set the rules, terms and conditions, take it or leave it. Whether we have consumer codes or civil codes, that's another question. They educate on that and decide about disputes. So I think it's important to keep in mind, again, discussing regulatory responses and institutions, that we are not just seeing an entanglement with not just economic dimension of our lives, but also and our constitutional values, but also really this bigger picture of entanglement with our legal and constitutional orders. So for a long time, I have been working also with OR, so it's a great double presentation, looking at what is the role of independent regulatory authorities in this space, and especially looking at competition authorities. And it was great to start with Giuliano Amato, because I have been also rereading his work and applying it to this question of what is the role of these type of organizations, authorities in liberal democracies today. And the big question is, can they really defend democracy? Can they defend markets? Can they defend democracy in a space where we see all these emerging power relations in the digital markets? Do they contribute to the survival of democracy, or do they contribute to the decline of democracy? We have heard also in the US, we see a threat to independent regulatory authorities. I would like to do, take a sort of a double lens and look at what this role is or could be, and what I see as concerns in democratic legal systems, but also to raise some concerns, as I started with, not every country is living in a liberal democracy or democratic political system. So I think it's important to look at this. That's a slide that came in between. So I have been thinking about their role quite a long time, and I have this, it's just black and white, but there are big words on it, how I think competition authorities as a type of non-majoritarian institutions, I will come back to this technical word, as an independent regulatory authority, how they are really can defend democracy. I already mentioned intervening in the first panel that I see them really as defenders of fundamental economic rights. So when they protect the competitive, well-functioning market, they actually protect our economic freedoms, the economic freedoms of undertakings, but also the very beneficial effect of that for broader society. And especially there are things that you have seen and heard already for a long time. We are especially concerned, and they are especially well placed to prevent the rise of excessive economic concentration. So here and there where I read about these types, I have also picked up some words that I like to use, like how they defend the market's equivalent of separation of power, how they really make sure that there is an accountability mechanism for both the market mechanism but also market actors, and how they are also there to guarantee the rule of law in economic activities. And that has made me also to write a paper, as I have said, whether we can talk about competition authorities as courts. Well, I had a discussion with constitutional lawyers, but I think it's just for the reasons I explained. When you look at their independence, the crucial work that they do, I don't think we can make a difference, of course, on institutional level, but the type of work, what they, the beneficial work comes quite close to what we expect from an independent judiciary. But these are how constitutional lawyers refer to them. They are constitutional anomalies. Competition authorities and a broader category of non-majoritarian institutions where independent regulators belong to, they are based on something that we often call a democratic deficit. They are unelected and unrepresentative. They have been put up exactly for the reason to be at distance from both from the politics and the market. Their legitimization comes from technical expertise, so technical expert decision making. But we also see, as in the case of competition authorities, that they can have quite far-reaching and broad powers. So we often talk about quasi-judicial powers. They have mandate across all sectors of the economy, and I don't have to explain in this audience how far-reaching their enforcement powers are. Primarily, they are looking at the economic dimension of problems that we have, let's say it in this way. But we also see, and what we discuss here, is that they are invited and challenged more and more to elaborate and make decisions which have also distributive effects beyond this first level of what we would call consumers, so that when it's about a labor market, when it's about a media market, they will have to look at people more than just consumers, as workers, as citizens, as customers, etc. Moreover, they operate in a space which is being today politically very contested, right? So the knowledge, the technocracy, democracy, what is the value of knowledge, whether what they produce as independent decision makers, whether that has been very much contested and also attacked by populist forces. I'm happy to talk about that a little bit longer. I think that the fact that independence have been, and I'm sure there might be questions about that, independence of regulatory authorities and competition authorities have been, to my mind, a little bit overshoot. Also creates this space that they became so technocratic, so technical in the language, using economics, that there is really a distance created from the rest of society, and that's where this political contestation comes in. Just the last slide before I would like to show you a few cases where I see these problems emerging. So I think where these institutions operate today, it's, I call it the heat stress test for competition authorities, but I think there is enormous pressure on them, right? So this complex and overlapping crisis around us with the climate, with the decline of democracy, the geopolitical layer, there is a lot of pressure on them to do a lot, to do it in a fast way, shorter procedures, more structured procedures. We have heard a little bit. At the same time, there is also the lobbying power of concentrated economic power around them, which they also have to deal with and address. So all kind of risks of capture. And at the same time, we have to realize it and always put it to the bottom line that their responsibilities are originally in the narrow protection of competition. And what we see now is that their mandate seems to be expanding beyond that, and their mandate is being questioned or challenged to deal with also more complex and conflictive objectives. So I would like to briefly just talk about my other two homes, so two cases from the Netherlands and one case or issues from Hungary. This is a recent media merger case, and maybe Gosha will talk about it at much length. This was not really about platform power, but it's an illustration of how a competition authority has to stand up, what is the kind of work they have to do when it's not, media services are both, have a strong economic dimension because there are markets, that's very much for a competition authority, but at the same time, you cannot disentangle that when you look at consumers and what will happen after the merger with consumers, you are actually looking at what will happen to media pluralism, media freedom of citizens. So these two are very difficult to take apart. For that reason, this was an extremely long merger decision in the Netherlands. I think there has been also enormous pressure on the competition authority to come up with there has been also in the newspapers paid advertisement by one of the biggest media owner of, this is taking a lot of time and it's completely unnecessary because everybody knows what the decision should be. But you see how carefully a competition authority has to address a question which is about economic power, whether the merger will create a more dominant position, concentration of economic power in the market, but at the same time, also how the merger, and this was immense, creates bigger opinion power. So the way to influence citizens' access to news, especially what will be the effect of that on editorial independence, and a few other questions. Surprisingly, there hasn't been a really big discussion, but maybe you will contradict me, in the Netherlands, at least not in the academia. I recently had, luckily, a discussion with an economist who also said, and I think that's the gist of it, this is great, we all feel good about it, right, that the competition authority came up with, and we can fill in our consumer and citizen lens, but you can question whether this is really the mandate of the competition authority, whether this shouldn't be another authority doing that. And I give you a more extreme case, which is very recent. It's a merger between, I'm going to try not to mix them up. So an acquisition of Solvinity, who runs and owns our, basically our our data, public services, and connects to us as public sector users. Our health data runs through that, our tax data, etc. was acquired by Kyndryl, a US firm. And yeah, the Dutch Competition Authority approved the merger. There was immense social political unrest in the Netherlands about that. How on earth could it happen that the Competition Authority did not take into account the threat that this merger could create to the citizens of the Netherlands, foreign interference, so our, or the Netherlands' digital autonomy, digital independence. And I think it was very difficult to explain, there was an online discussion on LinkedIn with a Dutch journalist, that this is not the task of the Competition Authority. They look at competition problems. They don't look at acknowledging there is a problem and there is an issue that has to be dealt with, but it's not the task of the Competition Authority to look at digital autonomy, digital independence of the Netherlands. And I think it illustrates very well yeah, the kind of space that competition authorities operate in. I have one more. Okay. And from here, I would like to make a switch also to, yeah, closer, after all, I said closer to home. So which home is always a question. But I think we cannot really talk about liberal laws, the type of regulations. Of course, the DMA is at the EU level, but many other digital regulations are at the member state level or dependent on the member state, without also acknowledging what I started with, that not all countries, and even not all countries within the EU, are liberal democracies anymore. And what happens, what is the picture then? And what we see is that some of these governments have been strategically using the EU digital regulation, again, not the DMA, but the DSA and EMFA, to the extent we can call it part of the digital regulation, to basically mobilize their own narrative, their own strategy, their own national sovereignty. In the case of Hungary, it's a very clear-cut case how the government has actually been using or misusing it for its own purposes, continuing the already completely captured media. But I have just recently learned that the Czech Republic, perhaps less out there in the expressive, openly contesting it, but quietly also reframing it to their own national sovereignty and building their own open strategic autonomy. How it happens on practical terms, in Hungary, the local national enforcer for the DSA, which had to be which had to be appointed is not the right word, is the media regulator, which has been approved by the Commission. And if you know a little bit about the Hungarian situation concerning the media regulator, that has been one of the first independent regulators captured, and if that's the right word, completely politically aligned with the government. So we have here a piece of digital regulation with a lot of promises, I also agree, which sort of on the ground will be probably hardly used. And let me close with, yeah, with this last piece, which I think makes the drama even perhaps more tangible. Yeah, Mark again already mentioned within a month we have elections in Hungary. One of the, I think, the fears of many Hungarians how this will go is also whether the elections, the quality of the elections will be really free. It hasn't been fair for a long time. And we see now, and I think this is again a very important illustration, the Commission this week activated this rapid response system in Hungary on the basis of the DSA and putting forth its fight against disinformation. This basically means that now the large platforms, so those platforms that we talked about here, which are also a threat to our democracy and the rule of law, are now kindly requested to work along fact checkers and independent organizations and report misinformation, disinformation, and manipulation of information in EU law countries. So I think that closes the circle, but also provides, again, a different lens of what are regulatory responses to platforms. Is not just a question of substantive law and substantive liberal laws, but we need to think about, and maybe that's where the digital commons again come back, of how that space where our information, our knowledge, our culture is developing, can be protected. But we see that the platforms are not a solution. The state is not in every case a solution. So I think this is where we will need to come up with a digital commons approach, perhaps. Thank you very much.
Thank you very much, Kati, for a very broad view upon independence of competition authority, independence that quite often nowadays means being under a great pressure, coming not only from private actors but also from governments, even foreign governments. Digital sovereignty, this is the concept that certainly needs to be raised while talking about digital commons and regulation of markets for a defense of democracy. Małgorzata, I would like to invite you to the presentation by Małgorzata Kozak. Małgosia will focus on media pluralism and competition law.
Thank you, Agata. Maybe now. Thank you very much, Agata. Thank you very much, Maciej, Lavinia, Rory, for organizing, and Wisniewski Foundation for having me today. So I'm going to take you to the other side of the mirror, so to discuss a bit legacy media, quality journalism, and competition law. And I will continue to zooming into power, but also into authorities, their competences. And as Kati mentioned, DPG Media and RTL merger, together with Professor Anna Herbrandi from Utrecht University, we wrote a year ago an opinion within the procedure of this merger. So I will not talk about the case today, I will talk about the opinion only. Of course, also, I will not walk you through every detail of the opinion because it's very detailed, but I would like to show you our line of reasoning, because we were arguing why actually the ACM could take into account media pluralism in that specific merger transaction that they were looking at. So this is a bit of a condensated overview. Starting with media pluralism as a concept, I mean, of course we know this is a cornerstone of democratic societies, but it has no definition at the EU level. And there was a moment when such definition was introduced in the European Media Freedom Act, then it was included and it dropped out from the draft. However, still, the European Media Freedom Act includes something what is called media pluralism test. So it imposes an obligation on member states to assess market concentrations that may affect media plurality. And in recital 64 of the EMFA preamble, there is a tiny, tiny definition of media pluralism, which is defined as the possibility to have access to a variety of media services and media content, which reflect diverse opinions, voices, and analysis. For the opinion, we created a condensated also definition based on longer discussion, including different levels of media pluralism, including different approaches to media pluralism. And with Anna, we came up with a definition which comprises of access of citizens to a heterogeneity of opinions, voices, through different media services and content. So we left the distinction between legacy media and new media as well. EMFA includes, as I said, media pluralism test. You can see there are 5 elements of this test, so it looks like a bit of a puzzle. What should be taken into account in the assessment of a merger in the media market? So there should be an assessment of impact on media pluralism, meant as effects on public opinion formation, the rule of law reports findings, editorial independence safeguards, commitments, but also economic sustainability of the parties in the absence of the specific transaction in place. So it is a very complex test. I think it will be longly debated, and still we see how difficult it is for many member states to actually put into national systems instruments to enact it. When we were writing the opinion, EMFA was already in force, but still its term to enact it nationally had not expired, so we were arguing for conform interpretation of ACM obligations under already pending EMFA and being into force. And our lines of arguments consist of 4 arguments. What is important to understand that each of those arguments is independent and self-standing, and then still together, that was our aim, that they form a mutually reinforcing structure. So we argued that each of them could be argued independently, however, still all together create an even stronger line of reasoning. They all start from a premise of concentrated market power that activates or triggers all those arguments. And so it makes the overall case even more robust than any single argument alone. So as I said, the starting point is a concentrated market power. We also discussed EMFA obligations and the opinion power. I will get there in a moment, already Claudia mentioned. We also discussed, of course, the role of the competition law and the system of competition law in respect to democracy and to support of democracy, taking into consideration that media pluralism is an important building block of a democratic society. We then discussed consumer welfare nested theories of harm, so some unorthodox theories of harm that already were applied by some national competition authorities and are still related to media pluralism. And we also discussed that alone, a lessening of media pluralism could be considered as a theory of harm itself. And then the conclusion was that protection of media pluralism is legally enforceable, and we are not claiming that competition law is a panacea, as this morning President Van der Woude said, that it is a panacea for all the problems. However, we tried to argue and to show that actually competition law could be used as a support for legacy media, which as already was discussed by Claudia, but also by Kati, are struggling right now in the presence of the digital intermediaries. So if we look at opinion power and how could competition law be actually applied to opinion power? We have, of course, opinion power, it's not the same thing as market power. As Claudia mentioned, opinion power is discussed with many different perspectives as epistemic power, but there is also Anna Hebrandy's team called it discursive power. Maciej wrote in his book that we can have a network of restaurants that has market power. We can have an entity which has an opinion power, is able to influence opinions of many people. But restaurant has the network of restaurants has no opinion power. So the problem really starts when we have, and I think we can name one of the gentlemen that were on the photo that you showed. So the issue really starts when we have an entity or an individual with a market power, but who also possesses an opinion power possibilities. So once they overlap, and this is what we argue in this opinion, is once they overlap, this is the moment when actually competition law becomes concerned and can be triggered to also look at the opinion power related issues. And this is a bit like, I mean, you see the Venn diagram in my slide, but this is like a bit of a free body problem. So you remember the film when the moons started to be in one line, then people thought, okay, we have one moon in fact. So that was one of the first of our arguments. Then we tried to operationalize pluralism within consumer welfare, looking at different levels of productions of news, of production of content. So from the viewpoint diversity, for instance, that reduction in editorial independence constitutes a direct harm to consumers of news because there is less diversified news. The same applies for source plurality or access and distribution to news. These are all the factors that competition law is able to deal with. I'm sorry, I skipped one slide. Then we also looked at, we looked at media pluralism as a competition law concern. Of course, media mergers suppress innovation competition between editorial models. They could reduce incentives to produce diverse investigative news. They could lead to homogenization of content. And there are cases from Belgium, there are cases from France, from the UK, where actually the quality of news was taken into account during merger control. And it was addressed through commitment relations. The same actually happened also in the Netherlands with the PJ merger. There are significant structural commitments put in place which were not appealed by the parties. So this is another line of our argument. We have traditional, I would say, analysis of competition law, traditional theories of harm that could be applied to media pluralism related issues. But altogether, they also bring us to the point where actually listening of media pluralism in quality journalism, so where the quality news in terms of the case law of the Court of Justice, which are researched, verified, checked, where those news become protected through all those different, through all those theories of harm, and they can be protected actually because if we look at how the news are being produced. This is also the output-input relation, also depending on the question which media pluralism level we take into consideration. Another point that we discussed, and this is something that was mentioned by Claudia, but also I think by Kati, whom are we talking about? Are we still talking about consumers or about citizens or about both? So we know that in media markets, what happens is that the ultimate users or the ultimate recipients of specific media products are not the only recipients of those products. Because what happens when news start to spread, the range of individuals who are affected, who get those news, is much broader than those direct users, recipients, however we call them. So this is also an important factor to take into consideration while looking at specific aspects of assessment and the specific factors for assessment of mergers. And then the final point is about competence. So we also argued that, and it is nothing we made up, it is in the EU merger regulation, recital 23, The Commission should situate its appraisal within the general framework of the achievement of fundamental objectives, which are referred to in Article 2 TEU. Then also member states under EU merger regulation, under Article 21, paragraph 4, may take appropriate measures to protect legitimate interest beyond the EUMR's scope, and then plurality of media is expressively included. And then the question that was asked considered also competence. So to what extent, and this is also what Kati mentioned, that what brings some controversies. We looked at a number of cases. Some of them were mentioned today, also including Google Android, especially Meta case versus Bundeskartellamt, where the court actually emphasized that the identification of GDPR violation by the National Competition Authority does not replace a role of supervisory authority. However, if it is needed to prove the abuse of a dominant position, then such a national competition authority can and even should follow the existing authority decision, which results from the sincere cooperation principle. And we don't see obstacles why the same reasoning cannot be applied to media pluralism-related issues. So that was a very concise overview of the document. It's on the ACM website, so, and if you have any questions, I'm of course very happy to answer. Thank you very much.
Thank you very much, Małgorzata. Yes, we would like to ask for the applause for all panelists. They really deserve that. And now I would like to open the floor for the discussion. As I can see some of you ready to pose the question or to share your views. Maybe we will collect a few questions and then the panelists will answer them.
Since I already have a microphone, can I ask my question? In January, I was reviewing for publication a special issue of the European Law Journal on competition law in times of transformation. And one of the things that really struck me from reading these articles, they were focused on South Africa and Central and Eastern Europe. And the really interesting thing I found was in some of those competition law regimes, particularly South Africa, there were public policy considerations which were allowed to be included, which when I read them, it made me worried from this discussion about, especially when Kati says about maybe we've gone too far with the independence of competition authorities. And then also Claudia made the comment earlier about sort of merging competition law with constitutional law. And it got me worried and thinking about that particular type of clause, a public interest consideration for a non-majoritarian institution which is designed to enforce competition law could very easily be captured and be used to allow for economic power to be utilized by a government which may want to use that to undermine democracy and also the markets themselves. And that made me wonder about whether it really should be the job of competition authorities to be taking into account these considerations, because the more open-ended the policy objectives for them are, then the easier it would be for them to be captured. And then I was wondering about that from the rule of law perspective, because like everybody's been talking about the rule of law today, and I think that's important. But but is the independence of competition authorities in the context of the rule of law really a solution, never mind the solution, to the problem of the backsliding of the rule of law when it comes to judicial independence? And is that really the way that we can solve that particular problem, or could it be used to solve that problem without creating problems of its own?
regarding the epistemic power, and I am wondering, taking into account. Okay.
It was on when I gave it to you.
Oh, sorry. We can hear you.
We can hear you.
Yeah, okay. So I have a question to Professor Meijer, especially regarding the epistemic power, and taking into consideration all the regulatory landscape we have nowadays in the EU. I can imagine that there are also, I don't know, other acts that probably were not mentioned here exactly, but can also lead to prevention of abusing of epistemic power, such as AI Act. And I have a question whether you find it useful to introduce new old concepts into EU law that are present already in the legislation of some member states, such as Germany or France. I have in mind abuse of economic dependency. So I have a question whether you find it useful to consider introducing of such tools also at EU level, or it is not necessary taking into consideration that we already have DMA and subsequent legislation. Thank you.
Okay, there is a person 2 rows behind Monica.
A short comment / question triggered by the example mentioned by Professor Meijer in the end with this public initiative of establishing publicly owned social media by the European Commission. I instantly see a problem which relates to the economic constitution of the European Union, which is explicitly stated as the social market economy. And if we look at the founding fathers of this model, Walter Eucken and Franz Böhm were mentioned in the initial lecture, they explicitly rejected this kind of direct intervention and establishing public entities which would compete with private ones and counter private power in this way. So my question is how such solutions could fit within the framework of the social market economy as the economic constitution.
Marta, could we, okay, one more question from Marta, because we'll be lost with answers, so.
Thanks. I think my common question also relates to some of the points already mentioned, but I wanted to ask you maybe to elaborate a bit more what you think about the question of independence of media regulatory authorities. And of course, Hungary is a great example here. And to the points mentioned, I think as Gosia was explaining, following EMFA, once it's actually introduced with national legal systems, this division on who will be carrying out this test of media plurality and editorial independence will be moved to that media regulatory authority, even though I think the arguments that you made in the DPG case are very interesting. So maybe a question if you think that is a good solution, that we're dividing this responsibility, and how that will be working with cooperation within the regulatory authorities and competition authorities. And also a question that came to my mind when I was reading the judgment in the Klub Radio case recently, that there is a bit where the court is kind of commenting on the situation in Hungary with the regulatory authority, and maybe that I was thinking that it could perhaps be seen as a lost opportunity to build a test, maybe like Spetbrod for regulatory authorities, and how should we actually understand the obligation for the authorities to be independent and competent, as the directive and EMFA also oblige those authorities to be. So an institutional...
That's enough, that's
yes,
enough.
Thank you.
That's enough, definitely. 5% but 55 questions. Claudia, could you start answering some of the questions were directed to you, so maybe we will start with them.
Sure, it works, right? So Mark, when it comes to systemic risk assessments, so the platforms right now are obviously, we know, entrusted with the identification, analysis, and assessment of systemic risks, including their severity and probability. And that is a highly normative task, right? I mean, what constitutes a systemic risk is a highly normative, in a way, task. And so what constitutes systemic risk, but also then, determining an acceptable level of risk, because then they have to react with mitigating measures if they define the risk, but what is an acceptable level of risk? Interpreting rights such as freedom of expression, it requires, balancing between different rights, right? So an interest, so protecting free speech versus mitigating harmful content. This kind of task of balancing is highly normative. So the whole exercise is value-laden, really. And I'm not sure how comfortable you feel with kind of entrusting this type of task to platforms. I mean, I don't feel so comfortable with kind of platforms having this task. I mean, obviously they have an obligation right now, so that's good that they're doing something. But I'm not sure interpreting fundamental rights and determining the acceptable level of risk is something that should be in the hands of platforms. But I'd be happy to hear your views on that. I mean, as a representative of civil society. Yeah.
I mean, I think the way the Commission viewed was they were leaving it to the platforms to conceptualize.
Yeah.
And then it was up to the Commission to evaluate what was deemed a legitimate source of assistance, or what are defined what
Yeah, sure.
is. And I still think they're in that process. But I still don't quite see how it reinforces their market power position. I see that as slightly separate.
Okay.
That's just my own opinion.
Okay, thank you. Then just a couple of questions, other questions. So, merging competition law and constitutional law, the risk of capture that I think you asked, Ray, right? I mean, that's a very difficult balance, right? So we have a competition law instrument that is kind of embedded into the broader constitutional law, right? And then we have, for example, Article 7 of the TFU that talks about ensuring consistency and coherence with other values, other fields of law. Which kind of, in my mind, mandates us to kind of, or competition authorities to think also a little bit about other, in a way, values. But I see where you're coming from, right? And I think Kati already talked quite extensively about that risk of capture. But I think it's, Ariel Ezrachi from Oxford wrote this article, Sponge, like that competition law is kind of, this type of instrument that can absorb different types of values. Obviously, there has to be a limit, right, to what competition law can do. But I think being completely insulated is also not a solution, I think. Then the social media platform question. I don't have a ready answer, I'm sorry, but I just feel that, when it comes to the digital platforms, the kind of genie is out of the bottle, like we cannot put it back. But I think it does not mean that we should not be striving for creating alternatives. And obviously, privately owned alternatives, like European businesses, and creating an enabling environment for creating European alternatives is one solution. But I think it should not mean, not being able to create public digital infrastructure that can, I think, contribute a great deal to strengthening the kind of interests and values of Europeans. And then Monica, I think, so the other concepts, abuse of economic dependence. I think we can talk a little bit later about this. I think it's just, but yeah, I mean, in my paper, I argue that this could also be a way to go as in a way, a different method of capturing the power, right? Because market power, as we know it, is a or the issues we look at may not be able to fully capture the type of power that we see. So I think that this could be alternatives. I mean, obviously it's discussed in a couple of more member states, and it's not yet discussed seriously, I think, at the EU level. But I think that could be an interesting alternative. Thanks.
to the public interest and the independence, but my answer might be a bit long, because I feel that we also have to acknowledge when we look at this Dutch case, what is the sort of the political economy or simply the legal system. The fact that the Dutch Competition Authority looked at this is that they didn't, that in the Netherlands, there has been for a long time a political decision that media mergers can be very well addressed just by the sole tool of competition law, and that they did not need a media pluralism test and a media regulator to look at it. So I think we need to add that when we talk about public interest. Yes, it's great, this case is wonderful, and I think we always enjoy to talk about it, but I think if you look at, and I went back even to 98 when the first Modern Competition Act of the Netherlands was made and it was drafted, and there is a very strong underlying argument always about effectively working markets. And I'm sorry, but there is nothing about democracy or whatsoever, and I think it's also that it ended up with only the competition authority and that the media regulator, by the way, who was against the merger. I think we also have to say that. So on the media pluralism side, there were really, really serious issues. So I think we need to talk about that. Somehow competition authorities, and I think I also know the reasons, grew out into these very prestigious, big voice authorities in many countries doing many things. But I think we should go back, and I don't have a solution to you, and I know about South Africa, but I think it's a rediscussion how this public interest, because we see that it comes on the plate of a competition authority, right? Look at the UK. I mean, what is happening there? That's also very worth discussing, and we see that this will come. It will be on the plate. So how do we do that? What is the role of the political actors? What is the mandate of a competition authority? And we will always have more active and more passive ones, but also what is the constitutional and legal framework, because I think we also need to add that when it comes to merger control, there is the EU level, but that's not connected in any way to any of the national systems. I think it's a very deeply political and constitutional issue, but I will finish here. To the independence, I think somewhere in the, what was this verification and cooperation mechanism with Bulgaria and Romania, I know I go back a lot, there was something dropped about how also the effective functioning of administrative authorities is kind of a safeguard, and I think it links to democracy, but I have to double check. So what we see is, and maybe I forgot to mention that, but that's the main point, is that competition authorities have cases like the Spetpro, where I think the court even names Article 19, right? So linking it to effective enforcement of EU law, which can depend very much on the independence of the courts. But I think we should think about it, how enforcement of EU law, competition rules, but also others, are also, what I have said, a constitutional safeguard when the competition authorities enforce that. So that's number one. I am not against independence. The only issue that I want to raise is that I have seen Hungary with an independent competition authority. It's more independent on paper than the ACM in the Netherlands. I'm sorry, that's how it is. And still, we do see that in one country, you can criticize it, of course, but it's effectively and transparently working. In another country, it fulfills all the conditions of independence. I cannot give you more. I mean, look at the audiovisual, directive, which is a very elaborative one. But I think we need to think about it in a bigger context, just like with public interest, and maybe revisit this no-go. I know this comes to the politicization, but also how independence can be balanced with maybe some accountability mechanisms. And then I think that civil society organizations, structured, not overly broad complaint mechanisms could come in. I think this is a discussion we need to have, because we see that it comes back each and every time. And
yeah, everybody is trying to figure it out on its own. But I think the UK, that could be not in the EU anymore, but also a discussion which is very worth following now. There was no other. No.
Okay, any other comments from other panelists to the questions so far? Any other questions?
Ariel Slaviński, University of Warsaw. I would like to thank you, Professor Ceres, for your last comment, because now I feel allowed to ask the question I was about to ask during the last panel, because of just what you said. I want to point out that under the Financial Services Law, with the European supervision authorities, there is a mechanism that allows the ESMA or EBA to take over the competence of the national competent authority to issue the decision on the purely national matter when the national competent authority does not comply. And what's my question to you, or maybe like just open question, do you see like any other reason than the lack of the political willingness to perhaps replicate the same mechanism to the competition law? So once we find that the national competition authority does not comply, the European, for example, like the network of the competition authorities could, of course with the relevant change of the legislation, take over the competence to issue the decision in this given matter. Thank you.
Thank you. Katarzyna Klawkowska, Adam Mickiewicz University in Poznań. I would like to thank the panelists for introducing two very important perspectives. One is that countries like Poland and Hungary work on it sometimes on a different way, so things become uncomparable. And the other is to bring the broader regulatory perspective, including EMFA, DSA, and data acts. And based on that, I would like to refer the question to Laura, which goes a little beyond your presentation. So in your research, I read your presentations that you are more optimistic about this regulatory approach that the EU has developed so far to solve the problems that also relate to competition and infrastructure. So in your research, or based on your research, do you observe inconsistencies, substantial inconsistencies between those acts, because we have a number of them and they are really complex and difficult to read? Thank you.
I have a question. By the way, I think I disagree with Ruri, but yeah, we can discuss this later on. Particularly, I don't see really the connection that we can just talk about the rule of law, independence of competition authority when it promotes kind of, so the link with the courts is necessary for kind of thinking about the rule of law framework and independence of agencies. But yeah, we will discuss it. I have a question to Antoni. Could you, because you somehow stopped, and about the structural remedies, if you could follow on a little bit, so then what would be the answer, how far you want to go? And I was also thinking, since how they operate today. Like even in the context of, democratic backsliding, I'm not, defending digital media, but I think when you have authoritarian regimes, sometimes, this sphere, if it's still there, can provide a source of a check on the authoritarian government. So maybe this is the perspective that is.
There was not much time to prepare. Okay, so the first one about structural remedies. Well, I just think that the enforcement that we've seen so far under 102, both from the Commission and from some of the NCAs, if we look at cases concerning Apple, like App Store practices, or the national, for example, the French ATT case, Or if we look at the very recent Google AdTech case that is being done by the Commission, we see that they recognize, especially in the Google AdTech case, they recognize there might be a structural conflict of interests, but we don't know. I mean, I keep my fingers crossed for the Commission in that last example, but it does not seem that they're willing to go as far to resolve those structural conflicts of interest. And I just don't think that if we have those conflicts of interest, and instead, when defining remedies, we focus on financial fines, which we've seen over the last 20 years, they don't really change the conduct of those companies, especially for Google. Or we focus on behavioral remedies, it probably will not solve the underlying problem that we see. So I think in the context of Google, one of the remedies that was considered on the other side of the pond, but it was not really successful, was the idea of divesting Google Chrome, right? So one of the primary sources of Google's market power. And I think if we want to effectively solve those structural conflicts of interest, we need to pinpoint where's the origin of that power. As for Google might be Google Chrome, for Apple it might be the iOS operating system, and we'll be a bit more courageous in dealing with those. Second question, that got me puzzled really about we can discuss it maybe later. But initially, I mean, my answer would be very maybe formalistic, that we have certain values and axiological choices reflected in the treaties, and I think that suffices to distinguish between how sports federations operate and how ecosystems operate. Thank you.
Thank you, Kasia, for the question. Yes, I try to present myself as a supporter of this approach, but I can see the weaknesses, particularly this fragmented approach that reveal inconsistency. I was trying to think about the main clusters. I think we have conceptual misalignment, so some of these data package and digital markets act do not speak one to another. Then we have the logic of the regulation sometimes is also contradictory. On the top of this, we have an incredibly fragmented enforcement. So yes, at the end of the day, there are many weaknesses, and I see this piecemeal approach as maybe not the perfect way to go, but just to make a statement to prevent questions. This does not mean that simplification is the answer, right? So without opening a parenthesis on the digital omnibus, but still simplification might not be the way to go, but I very much see inconsistency. And as we know, there are many clashes with intellectual property as well, right? So for example, the Data Act is arguing for this data access obligation. Trade secrets are an obstacle there. So it's true that there are many, weaknesses. So I very much see your point.
Okay, I will take the question about independence. So I mean, there were many, but what I think is important to understand in this whole discussion about independence is what do we need it for really? So what is the function of independent authority? And this is not the aim itself, right, to create another ivory tower and that can, reign and decide as they wish. So, if we look at the research about institutions, initially these were only central banks. Why? Because of the need to maintain the independence of financial systems. And then the whole theory or the whole idea of independent authority a bit spread or creeped out and started to become a standard also for regulatory authorities or competition authorities. In the European context, there is a very strong factor of internal market. So if you look at ECN Plus directive, this is 114 instrument. So there is this element of creation of level playing field within all the 27 member states in different markets. And of course, the big, and so in this context also, is not only to check the boxes. Okay, we have a formal independence being guaranteed in a national law, because then the less independent institution or the less independent authority will be the Dutch authority, actually, on paper, which in fact is one of the strongest in terms of their policy making. So this is also about creating a culture of independence. And I'm not sure if there is a system that would allow to replace the decisions. But for instance, we don't discuss accountability mechanism, and I think Kati will take over about it. We don't see also the Commission influencing national competition authorities, for instance, through ECN mechanism. There is a network where actually those kind of issues could be addressed. Softly maybe, but sometimes those soft mechanisms are very powerful, because also there are very, the participation is prestigious and so on and so on. During the first panel, there was a discussion, I think Christina mentioned preliminary reference procedure. So in the Polish context, we have no preliminary reference control right now in case of competition law cases, which, I mean, I haven't checked recently how many decisions of the Polish Competition Authority is adopted on the basis of one of the treaty provisions. There are very few already about abuses of dominant position, but the authority doesn't use the treaty at all. And the Commission is really not, looking very, I would say, liberally at those. So there are other mechanisms than really using those very, very strong one, and I think Kati will follow up on accountability.
I thought actually you would answer to this question, so I will answer him on the sincere cooperation, or whether the Commission can take it over.
Maybe Commission, or maybe some other national authority, or maybe 20, because in case of financial market, there's like 27 financial authorities acting in corpora to replace the one which is not complying.
Okay, I will look into it. There is a mechanism for Article 101 and 102, so cartels and abuse of a dominant position, that the Commission can take it over. What is it, Article 11, paragraph 6, and I know it by heart because I was told when we tried to reach the same solution, but with regard to mergers, that this is indeed a possibility, and I was told by an official in the Commission that they have never used it, but they were apparently very close to it. So the possibility is there. I don't know what it takes for the Commission to decide to do that. Obviously, that would be politically in that ECN network. Also an acknowledgement that it doesn't work as nicely as it is supposed to do. With mergers, it's different. Once again, I think, and that's what I also want to work on, I see it as completely disattached. The Commission can reach out, or there are mechanisms to take up cases from the member states through the so-called Dutch clause, which was implemented when the Netherlands didn't have merger control. But there are a lot of layers of discretion how that could go. I have tried it once, it didn't work. But there are possibilities, and I will look into what you mentioned. Thank you.
So, time is over. Our task, the task of this panel, was to explore the regulatory and societal responses needed to reclaim our common digital future. I'm really afraid that we haven't fulfilled this task. We just touched the problem of reclaiming our common digital future. But we all need to remember that at the turn of years, at the end of 2029 and the beginning of 2026, the Commission stood up with proposals for digital omnibus that was mentioned yesterday, a big program for legislative review of existing regulation. There is also the new cybersecurity package on the table, so it's pretty sure that we will have in the nearest future we will have a lot of occasion to discuss this issue within our academic community. I would like to thank to all my panelists and to the excellent audience. Thank you very much. It was pretty easy job for me. Thank you.
No, not really. I mean, I came for conferences with Marco.
Okay,
Yeah, many times.
Thank you so much for coming after the break. And I'm really happy that we still have the audience after the lunch. My name is Lavinia Brancusi. I'm from Polish Academy of Science. And this is the last panel, the panel on AI. And the idea behind this panel was to take a multifaceted perspective on AI implication on public life. We have AI pervasive in our discourse every day. And I'm just, how to say, I'm sorry for giving you today a patchwork panel, because we have, of course, extraordinary speakers, and you'll see different perspectives. Some of them will take points on law, like copyright law, or even more specific press publisher law or trademark law, but we'll have also presentation which discuss the AI systems, the way they operate, and how can we introduce some solution to make the AI decision making more fair and how to say predictable, to enhance the trust. So I'm also very sad that for reasons which are independent of us, we have two speakers online for various reasons you will see in a moment. And I'm also grateful to those speakers that they accepted this modus operandi. You'll see Eleonora Orosati, she's now she's live, so you can say hello. I'm also, due to time constraints, I'll not be able to give you a full silhouette of their CVs, so I recommend you to read their website and affiliation at the Institute, because they have very rich curriculum vitae. For the logistics question, there is also for logistics that after the first presentation, we'll make a short Q&A session, and then we'll continue the other one. And this is because the first presentation comes from Professor Orit Fishman-Afori. She's a law professor at the College of Management Academic Studies in Israel, Tel Aviv. Orit is a dear friend of mine, and also currently she is the president of ATRIP. ATRIP is for the intellectual property lawyers, I don't know, the most important organization. This is the acronym for what we called the International Association for the Advancement of Teaching and Research in Intellectual Property. And one of the past presidents was Professor Annette Kur. So this year, these are the times from Orit Fishman-Afori. And unfortunately, she couldn't come to Poland. And also because of the shelters issues and this what's going on there, we will give you first the video, which was recorded, and then the session on Q&As with Orit online. So Orit, these are her stage.
Hello, everyone. First, I would like to thank the organizers and especially Professor Lavinia Brancusi for inviting me to participate in this special and exciting event. I'm also very sorry that I could not attend in person and enjoy the company of so many dear friends and colleagues. Unfortunately, as you all know, the circumstances in my region prevented me from traveling. So my sincere apologies for that. Today, I would like to speak about due process by design and the role of procedural justice in AI-based decision-making systems. My paper looks at AI systems used for decision-making. These systems are operating in many institutional settings, both in the public sector and the private sector. My focus is on the private sector, where the legal framework governing decision-making is quite different from that applied to public authorities. The advantages of these systems are known and clear: efficiency, reduced human labor, decision produced within seconds, and greater consistency in decision-making. Kahanan, Siboni, and Sunstein discussed these many advantages in their well-known book, Noise. At the same time, the risks are also well documented. Biases in training data may lead to discriminatory outcomes, and concerns about fairness and trust in these systems are increasingly raised. Empirical evidence on these challenges is rapidly accumulating, including studies published in journals such as Science and Nature discussing the discriminatory outcomes of AI systems. When discussing fairness in AI systems, it is useful to distinguish between two dimensions. First, fairness of outcomes, and second, fairness of the decision-making process itself. Most of the existing literature focuses on outcomes, asking whether algorithmic decisions produce discriminatory results. My research, however, focuses instead on the decision-making process. More specifically, I examine how the structure and design of AI systems affect procedural fairness. The key theoretical framework here is, of course, procedural justice. Procedural justice examines the elements required for decision-making processes to be perceived as legitimate and trustworthy. In law, we encounter these frameworks in civil procedure law, criminal procedure law, and also in administrative law. Procedural justice is usually described through four elements: transparency, impartiality, flexibility, and hearing, the right to be heard. Transparency refers to providing explanations and reasons for decisions. Impartiality means decisions are based on objective criteria applied consistently. Flexibility means that decisions should be adapted to the specific facts of each case on a case-by-case basis. And finally, the right to be heard gives individuals the opportunity to present relevant information before a decision is made. So let me focus briefly on this last element of hearings. The right to be heard matters not only because it improves decisions accuracy. A long line of interdisciplinary research since the 1990s, combining law and behavioral sciences, show that participation affects perceptions of fairness. When individuals feel that their voice is heard, they perceive the process as more legitimate. This perception is crucial for building trust in institutions. Empirical studies show that when individuals are given a voice, they are more willing to accept decisions, even unfavorable ones, as fair and legitimate. One of the pioneers in this field is Tom Tyler, whose research demonstrated how procedural participation strengthened the legitimacy of the rule of law. If we return to an AI decision-making system, we encountered serious challenges with all four elements of procedural justice. First, transparency. We face the well-known black box problem. Often there is simply no explanation for the decisions made by AI systems. Second, impartiality. Much of the literature emphasizes the importance of appeal mechanisms, raising the question of whether humans should be involved, at least at the stage of appeal, the human in the loop position. Third, flexibility. AI systems typically produce statistical outputs, yet procedural fairness requires the ability to deviate from statistical patterns when the circumstances demand it. And finally, perhaps most importantly, hearings. Most AI systems do not provide meaningful hearings. A customer feedback form after a decision is not a hearing. A hearing means that individuals can provide information that may actually influence the decision itself. In response to these challenges, a growing movement calls for incorporating procedural guarantees and safeguards into digital decision-making systems. This approach is not only relevant for public sector systems, but perhaps even more for private systems, ranging from banking decisions to content moderation, online content moderation. This movement forms part of a broader framework known as digital constitutionalism. Digital constitutionalism refers to efforts to introduce constitutional values such as equality, fairness, and due process into the private digital sphere. So, digital and procedural fairness is already beginning to appear in practice. In Europe, as you all know, these ideas increasingly appear in regulation and legislation such as the GDPR, DSA, and the AI Act. In the US, the situation is somewhat different. While federal regulation has been limited in recent years, important developments are emerging at state level. For example, the proposed Colorado AI Act, which it remains to be seen whether it will be approved. There is another layer, a very important one, which is voluntary adoption by companies. Businesses often adopt procedural safeguards for pragmatic reasons, improving customer trust, strengthening reputation, and aligning with broader corporate responsibility frameworks. This raises a central question. How can procedural justice be implemented in AI systems? And here we can notice there are two complementary strategies emerging. The first one is adapting procedural justice principles to technological realities, and the second one is adapting technology to procedural justice principles. The first strategy involves adjusting legal principles pragmatically to technological constraints. For example, it may not always be possible to provide a full explanation for every machine-generated decision. There is a well-known British sitcom called The Computer Says No, which describes the rigid computerized bureaucracy with humor. One possible response to this challenge is to compensate the lack of explanation by creating an appeal stage involving a human decision maker who can review the case and provide reasons for the decisions. The second strategy moves in the opposite direction. Instead of adapting legal principles to technology, we adapt technology to legal principles. And this is what I call due process by design. The idea is similar to the concept we all know from privacy law, which is privacy by design, where systems are built from the outset to comply with normative principles. For example, systems could include automated hearing mechanisms. Instead of collecting feedback after a decision has been made, such systems could allow individuals, before the decision is finalized, to provide relevant information that may influence the outcome. Technologically, this is entirely feasible. Such systems already exist, although they are not yet widely implemented. Despite the importance of hearings, the literature on this topic remains quite surprisingly limited. On the legal side, there is almost nothing. In the social sciences, only a few empirical studies examined how hearings affect perceptions of fairness in AI systems. For example, a 2019 study by Lee and colleagues found that when individuals are given a voice, they perceive AI decisions as more fair and trustworthy, even when the outcome is unfavorable. A later 2022 study examining the perceptions of an AI judge reached a similar conclusion. Hearings significantly improve perceptions of fairness. Implementing hearing mechanisms by design has both advantages and challenges. The advantages are clear: greater personalizations, greater accuracy, stronger perceptions of fairness and trust, and better alignment with public norms. However, there are also clear challenges: costs, possible effects on profitability, and concerns about privacy and data security. There is also still limited empirical evidence about whether such investments are justified. Nevertheless, in my own view, it seems almost self-evident that such investment is both justified and necessary. So let me conclude. Embedding procedural justice mechanism within AI decision-making systems can promote perceptions of fairness and trust. The new concept of due process by design offer a way to connect social normative theory, particularly the literature on hearings, with the design of AI systems. And if AI systems increasingly make decisions about people, procedural justice must become part of their architecture. Thank you very much for your attention. and I would love to hear any comment or feedback. Thank you.
Thank you, Orit. I would like to also to ask for an applause. I would like to take now the questions for Orit. She's online and she's still not in the shelter. So. Okay, please, Mike. Mike is coming, so wait. And I would kindly ask you to introduce yourself just. No, not yet. You have to.
No, it is. Okay. Hi, Orit. My name is Bartosz Pilitowski. I'm running CourtWatch Poland Foundation, and I'm also a researcher, and I have published 2 papers in Law and Society inquiry about procedural justice in Polish courts. So I find your presentation very interesting, widening the scope of application of this theory onto AI courts and using AI technology to decision making. And I'm quite surprised that there is no so many research done yet. So I'm really looking forward for your papers and research. What we are observing here in Poland is a strive for efficiency in our courts. And though we don't apply AI yet, I expect that it will be well welcomed wherever it will be made possible. But what we see is a trend to basically deliver verdicts without hearing the parties. Quite commonly, in more and more type of cases, the legislature brings the possibility for the judges to basically give verdicts without providing a day in the court. So
could you please ask your question?
Yeah, sure.
Thank you so much.
I would like to hear your comment on that and what we can learn from this kind of practice, and then applying it to the sphere that you are analyzing. Maybe jurisdictions like Poland, where this is widely practiced, can provide you some data that might be then used for your research on decisions by AI.
So thank you very much. Lavinia, should I reply? Everybody hears me?
Yes, you are on. Yes.
Okay,
yes.
so thank you so much. First, I would like to take the opportunity to thank Professor Lavinia for inviting me, and I sincerely apologize once more for my complicated situation and not being able to be with you, and really I'm sorry for that. So thank you for your question, and my paper addresses the private sector, not the public sector. And if I understand correctly, your question refers to procedural justice in court systems, so it refers obviously to the public sector. I think that the question whether incorporating AI systems within procedural mechanisms in courts is, of course, raising a different set of questions. And there are some studies on this matter. Some of them are, I think, stressing that it might run against the rule of law. Skipping or preventing parties to have hearings in court. There are some, I think, experimental incorporation of AI judges in some small claims courts or this kind of judicial systems, but I'm not sure that eliminating a party's ability to voice their point of view is legal. And it's as I opened my presentation, I'm addressing the private system in which there's no there's no obligation to provide parties with a right to be heard. So in case of the private sector, of course, the situation is much more complicated. I think the point I was trying to raise in my paper is very simple, that AI system can incorporate automated hearings and therefore overcome the question of efficiency. Of course, you know, everyone is trading efficiency with other elements, and I think that automated hearings can meet both goals, both efficiency and providing people or individuals with the right to present their voice and to be heard. And the social normative literature is stressing that providing individuals with a voice, with a right to be heard, serves various public and private sector goals, such as fairness, trust, empathy, and so forth. And this is the idea of my paper. I'm not familiar with systems that, as such, are using currently AI judges, you know, in the regular courts, but I share your estimation that it seems that this situation is really fast approaching, and I think, you know, that the legal scholarship should address this point of view or the challenges that might come from this kind of procedural mechanisms in court systems.
Thank you, Orit. Just to wrap up, and I will ask you a short question. Did you identify already in Israel legal obstacles and to implement this solution you suggest, private or public sector? And let's assume that there are these legal obstacles identified. Are there any steps taken just to overpass this? Or is something that, I don't know, in 10 years you will be able to do it? So I wanted to see how feasible is what you are suggesting. Thank you.
So I think it's entirely feasible. So as far as it takes to Israel, there's no, of course, AI judges yet. And in the private sector, the idea is to have a real-time automated hearings. And this is technologically is entirely feasible. For example, in the health system, if you want to have, you know, a kind of X-ray or a kind of a procedure today, this kind of system is already using AI systems. And the hearing is just not being operated yet. So you have a form, you can fill in all the details, and at the end of the decision, you get kind of a feedback, a customer feedback. Are you satisfied with this system, yes or no? But you know, a post-factum customer feedback is not a hearing. It's just, you know, it's for future purposes to improve the system. Hearing means a very concrete form that can affect and influence the final decision taken. And as far as I'm familiar, there is no such system yet operating, not in the banking system, the finance system, insurance, health, which of course are the most important private sector systems for individuals. And hearings are not conducted, online hearings are not conducted yet in these systems, as far as I'm familiar with. And this is the idea of my paper of due process by design. As we have in privacy by design, I think time is ripe to incorporate the due process by design and initiate this kind of movement of calling all these private sector systems which are affecting our lives, health system, hospitals, bank, insurance, to incorporate this kind of AI automated systems that will give the opportunity to individuals to fill in a form with the relevant data before a decision has taken place.
Thank you so much. One more question, or can... Okay. So Professor Maciej Bernat, he will.
So I was wondering when you are saying that the fairness as a value plays a role, and the hearing actually is something that is positive. But to what extent is digital sphere different from, you know, traditional one? Because the fact that you have hearing, this is something, even if you look at roles and, you know, the idea about process values, this is not new, that the hearing is something that is generally considered as building greater legitimacy, basically, of the process. I was wondering, is there anything different in the digital sphere than if you compare it, you know, with what was before? Is this hearing a different hearing? I don't know. I'm just curious.
So thank you. I think it's a great question, how the digital sphere is different from the life we had before. So first, I think that before the AI age, this system took decisions. For example, the bank, the hospitals took decisions, and you're asking whether in the era before the AI, people could be heard. Was there a right of a hearing beforehand? And of course, the answer is more complex. It's not yes or no. It's somewhere in between, because before the age of AI, if you wanted to apply for insurance or, you know, or a kind of a procedure, there was a person to talk to. There was an officer, someone you can submit your application and discuss your specific considerations. So there was a person behind, you know, the bureaucracy. And as I showed, you know, this sitcom humoristic show in the UK, the computer says no. The difference is now that we are suffering from the rule of algorithms. There is no one to talk to. If you want a service, you apply a form and the computers just generate the outcome, either yes or no. And there's no persons, there's no mechanism for individual to give his specific circumstances, his personalized facts, and so on and so forth. So I think there is a difference in the AI or the digital sphere in comparison to the world before the rule of computers taking all these decisions. And I think the second answer to this question is the scale. I think once, you know, we use the AI systems are kind of ruling all our life, whether, you know, you go to the municipality, to the court, to the bank, to the hospital. So all the services are ruled today with this digital system. So I think it's also a question of scale. And the scale at a certain, the amount of decision taken by AI systems, I think at a certain point turns the entire, I would say, social or the societal environment we live in. And therefore, I think there is a difference between today's, you know, private sphere life and the life we had before the rule of all these computers running our lives.
Thank you, Orit. So now I think we can pass to our second speaker, and I invite you to remain online, and I hope you will be able to stay online. So
thank you so much.
I will take on the point that Ori said that in fact the machine is deciding for us, and we are influenced by it, and people, they don't even know that they are profiled, and they don't know why they take some decision. And our next speaker just will change this perspective with an insight into trademark law. After yesterday's celebration, I don't need to introduce you Joanna Wiśniewska from Nottingham University. But let me refresh your memories that Joanna's book, which was recently published by Elgar International, which is an independent UK publisher, very serious one, dealt with patent law. And today Joanna is already digging into the area of trademark law. This tells you something about her capacity and her curiosity and the quality of the research, because she cannot stand 2 days in the same place. So Joanna, the floor is yours.
Thank you very much, Lavinia. Thank you very much for this kind introduction. And while we are waiting for this to work, I just wanted to say, recalling yesterday's welcome by Vera Jourova, this is completely coincidental in terms of color. When I packed 2 days ago, I really didn't expect that we'll hear it. I definitely don't want to overpower everyone, show strength, maybe a little bit, but definitely not overpower everyone. But yes, like Lavinia kindly introduced, today I would like to talk about AI and trademarks. I would like to invite you for a ride into the world of e-commerce and online shopping in these very interesting times when a lot of those aspects are actually either enhanced or even, I can say, powered by AI tools. And the presentation is titled Average Artificial Consumer. However, basically the purpose of today's talk is mostly to set the scene, show you where we are with those technologies, what potential risks we can identify, and I'm sure that I will identify only some of them. Antitrust, contract lawyers, privacy lawyers in the room would probably be able to identify even more. But I would like to ask today the question where trademark law sits in all of this. So where are we technologically in our AI-powered shopping experience? Well, I'm pretty sure that all of us used it to some extent. So for example, when you have this AI assistants popping up at every website that you basically visit, or even on your phone when you interact with Siri, Gemini, when you use these big online marketplaces like Amazon and its AI that is called Rufus, we consciously get into this kind of interaction with AI. We want it to give us some recommendations, some practical perspective that might be useful, but this is not all of it. First of all, the more traditional tools that we knew, like simple Google search that has this shopping tab that you probably are familiar with. In the past, it was mostly showing you the price or where you can obtain the product. Now we are far more into the advancement of AI. Because this tool is now AI enhanced, it can trace the price fluctuation, it can give you some kind of the overview, it can summarize reviews, you can also at some extent interact with Google to ask a little bit more questions. We are far, far away from this traditional model of normal search. The big thing also nowadays, one of the biggest apparently, according to the industry in the rise, is so-called shoppable TV. Especially those big platforms, giants like Amazon, that combine the shopping experience with entertainment. So imagine you want to watch some movie on Amazon Prime, you try to put it on, there's something wrong with your remote, you tell out loud and your Alexa speaker picks it up that actually you are running low on batteries. Then your movie is on, 15 minutes in, this is the ad that you see, one click, and it's ordered because your payment details are already on Amazon, right? So this is what a lot of companies are now investing in. And the most advanced of all, AI agents. So those that are supposed to replace us at every stage of shopping experience. Not only recommendations, not only search, but actually searching, choosing, and completing transaction. And already Google and Amazon are trying this so-called AI buy for me initiatives that are working exactly like this. So as you can see, there are like 3 different levels of sophistication of this tool. But of course, we have to remember that to some extent, we are here always talking about large language models, meaning that machine learning technologies enabling them to constantly become better and better in what they are doing. And like I hinted in this kind of the overview, it's not always true that we consciously engage with AI at the stage of online shopping. Very often, those tools are hidden behind the curtain through advertising, profiling, and suggesting something, and we don't even realize that it's really happening and changing our decisions. So the question that it all raises for trademark law is, first of all, do we still need it? And some of those comments, though the topic is relatively new, has appearing in the literature. Like, when you think about this, what trademarks do, right? Their essential function is to be a badge of origin, the essential origin function of trademarks. So somehow the question here appears, do we need it in the time of omnipresent, know-it-all AI? Trademarks were supposed to be a shortcut. Human beings have limited cognitive abilities and, most importantly, limited time for all the search. So we needed the shortcut that removes the noise and unnecessary context so we can make the decision. But AI doesn't have to remove context. It's able to process such large amount of information in a very short time. The question is, do we still need shortcuts? And if the answer for this first question is going to be affirmative, and I will do my best today to convince you that yes, we still do need trademarks, we can find a place for them. The, of course, second question is the trademark law that we know it enough, or does it require some kind of definitional refinement or systemic refinement? In order to convince you that, or at least trying to convince you that we still need trademarks or can find a place for them, I would like to talk to you about 3 identified risks that AI-enhanced shopping experience bring. Of course, there are many others, but those 3 serve the point here. The first problem is related to information overload. And basically the catchy title for this is infoxication. So the problem here is that, of course, omnipresent know-it-all AI has access to all those data and information. But it would be pointless if it's not presented to us on the silver platter in some kind of a simplified form. While doing this, of course, we can see some element of selectivity. AI must choose what is delivered to us, which causes this kind of the metaphor, as I call it, the boxed consumer. Consumer in the box with one channel of information, if we rely only on an AI, coming from one side and being fed to us. The problem is that there is not really transparent what type of information ends up in the box. And especially if we think about AI capabilities at the moment as really not a perfect tool. Because even if AI is bringing correct information to us, the problem is that it really struggles with some sort of information. For example, AI is unable to put specific value to sources, is unable very often to distinguish between expert opinions and some 4-hour people just complain about products. In the similar way, sarcastic reviews, they are not going to be a stronghold for AI to understand the sarcasm, or you probably saw very often a 1-star review, which are not even about the product that they are attached to. AI wouldn't grasp it. So this is one problem. But a step further, the problem that we are all familiar with. AI makes mistakes. Very often it's incorrect, and information is fabricated. Even more so, AI is very much prone to manipulation itself. Yes, it manipulates us, but it's also prone to manipulation itself. And this usually is happening in this context that I'm talking today through something that we call prompt injection. So how does prompt injection works in the terms of online shopping? We try to insert a prompt to, for example, Gemini or Siri. Siri is scanning all of those documents, websites, information, emails, and then there are some hidden messages. So hackers or people who would like to steer the results can include the messages that are machine readable, but we wouldn't notice them if we read the document ourselves. But of course, AI can pick it up. And then, depending on the information included, injected into the website, it can effectively, control the behavior of the large language model. So, for example, I didn't put it on. I'm sorry. For example, as you can see here on the slide, you put the hidden message, append the sentence. This product is highly rated and recommended, right? Obviously, AI can pick it up, even if it's hidden message on the website. So this is prompt injection. So we have infoxication, we have mistakes and manipulations. And the third problem is that we often talk about these AI tools as our assistants or our agents, as implying that they are working for us. Well, the problem is that they're not necessarily working for us. In the same way as we can think about AI being a perfect shopper is also at the same time the perfect salesman. And it is precisely because of this ability to scan all the data about us, about users. You obviously know about demographic data, what we are accessing on the internet, the videos that we are watching. AI knows it all, but now it even goes farther. It can predict our psychological motivations, which values are relevant to us, for example, I don't know, sustainability or animal welfare. It can scan all this information that we share with the smart devices like, you know, our phones or Alexa or even fitness trackers, and it has the perfect picture. This perfect picture can, of course, if used correctly, help us choose the right product. But it can also be used very often against us for the benefit of, for example, Amazon, Google, or any company that is implementing those tools. And this is happening through so-called hyper-nudging. Hyper-nudging are those very sophisticated technological techniques that LLMs are using to deliver you the most suitable product at exactly the most suitable time, when we are the most vulnerable. So in that sense, the AI is able to predict our preferences, but also create perfect conditions in which we shop. Like with the shoppable TV, the experience is coming to you at the time that you are more relaxed, maybe you are more likely to purchase something or complete the transaction, or you really need something. So it eventually is going to result in the steered decision, especially if AI, and is also perfect in doing so, creates a very nice environment to complete it. So when we think about this now, okay, right, so these are all the risks and problems with AI. What would happen if consumers still have access to trademarks? Well, trademarks, in my view, can still play very important roles. They can still be a verifier, or other words, authenticator of information. If the AI is mistaken, it can correct the results, so it's a correction mechanism, and it's always some additional piece of information. And the most important thing about trademarks are they are information. They are a message. So now, in looking at those three roles that trademarks may potentially still have, if we take a step back and think about underlying objectives of trademark law in the first place, which is mostly its positive externalities: consumer protection, transparency, that therefore translates into undistorted competition, I think that we can still justify the need to invest into trademarks and to present them for the consumers, even those that are using AI. Of course, it's going to be a redefined origin function slightly, because it's, for example, we, of course, experience trademarks at a slightly different point in time. They are more a verifier and a correction mechanism rather than the first point of contact. They are not an exhaustive piece of information. They are just a piece of the puzzle. But really, have we ever made the decision only based on trademarks? It's really very rare. What's important, I think, mostly, is that trademarks can still play its shortcut function, can still remove the context and the noise. But this time, additionally, the context that is created artificially by AI. So this is an extra benefit of trademarks in this respect. And when we think about this piece of information, in my view, this can still work. The question, the question, of course, is now, maybe we actually need trademarks even more than ever in this infoxicated world powered by AI. Because even though this whole discussion starts with saying AI is a perfect tool, so therefore we don't need a shortcut, we always have to understand that at the end of the day, the recipient of the product with the trademark attached is going to be a consumer, an irrational being that AI is not able to fully replicate, because AI is trying to be logical and not irrational. The consumers definitely now work differently, right? They interact with brands differently at the later stage through a limited channel of communications.
But to be fair, because of all this risk caused by AI, they might even feel more disoriented because they are subjected to constant information stimuli, including fake information. If we see AI everywhere, we are become very trustworthy towards it, and therefore maybe we are even less attentive than ever. But of course, this is all not the question whether we have an artificial average consumer, but the realization that we now have artificially influenced artificial consumer. And my last slide is a conclusion. Can we have some predictions about trademarks? Because I would like to still see them, but what can AI developers do and brands about it, knowing all of this, knowing that the times have changed, and knowing that the consumer might potentially now be different? In my view, it should be or it might be in an interest of AI companies to actually include information about trademarks in the search results. Because if they're a verifier, correction mechanism, then they might increase consumer trust to the tools themselves. But it's also an important information from the brand owners, because brand owners, seeing this new redefined role of trademarks, might be willing to invest in new marketing strategies to make trademarks even visible. But the question is, what does it mean for trademarks? And I'm thinking, maybe we will see at this point a comeback of traditional marks, those that are actually more machine readable. So after all these times that we're extending 3D marks, holograms, smells, tastes, and all those discussions, maybe we'll actually see a big comeback. I would definitely like to see them for the sake of the consumers, and by translation for the sake of our markets. Thank you very much.
Thank you so much. It was my weakness, because I'm also a trademark specialist and I wanted to listen to the whole, so that's why I didn't want to cut you short. Now we'll move to a more specific area of law, and this is the press publisher rights. And I think it's really rewarding for the audience that our speaker today, Victoria Crețy, she's both a professor of law and a journalist. Victoria, she just had her habilitation at Goethe University, and she's a private docent there. But what is most important for this topic today, she was for many years the main legal counsel at the Frankfurter Allgemeine Zeitung, so she was an in-house lawyer, and she's still an independent journalist there. So today she will make a compelling argument about press publishers and AI. It's about property or fairness, and I'll give you a welcome.
Thank you very much. Thank you very much for the kind introduction and for the invitation. It's truly an honor to speak here today. And yes, to address the conflict between press publishers and AI. So, media technology revolutions are handled in the same way since ancient times. The reaction to media revolutions has always been everything was better in the past. In Plato's dialogue Phaedrus, Socrates reports on concerns about the written recording of knowledge. He tells the story of an Egyptian, of an Egyptian king who argues to the god of invention that the invention of writing will cause forgetfulness in the souls of those who learn it, because they will no longer exercise their memory. In addition to this kind of cultural pessimism, media revolutions are accompanied by one thing above all else: concern for the public sphere. This concern has been expressed during every media revolution, with the rise of the mass press in the mid-19th century, with the transition from the press to the radio, and with the transition from the radio to film. Not long ago, in the second half of the 20th century, the mass media were seen as a danger to the public sphere. They were believed to have weakened it by taking away the individual's ability to express dissent. In our times, another media revolution is happening yet again. New media intermediaries have been entering the information market. First search engines and social networks, now AI-powered answering machines. Their growing importance for the public sphere goes hand in hand with the loss of importance of the players of the old media world, namely the mass media, with press publishers being especially affected. With this latest media technology, the typical everything was better in the past reaction is happening yet again. Just like the mass media in the past, the new intermediaries are now carefully observed as private actors with too much power. Suddenly, the players of the old media world, the mass media, are the good guys. I believe that in our days, there is a strange romantic glorification of the old media world and of the analog versus the digital public sphere. It goes without saying that the new intermediaries create new risks. However, the typical everything was better in the past reaction is still wrong, in any case from a regulatory perspective. A backward-looking media regulation that seeks to preserve an old media world that is vanishing will neither eliminate the new risks nor contribute to the new public sphere. EU media regulation still thinks that press and journalism go hand in hand. In the age of the digital public sphere, however, the assumption that there can be no journalism without press publishers no longer holds true. The subject matter to be regulated has changed. I will speak about this in the first part of my presentation. Because the old unity of press and journalism is falling apart as a result of the digital structural change, a concept of the public sphere that considers the press still necessary for journalism is becoming an epistemic obstacle for media regulation. This is why European media regulation for ensuring high-quality journalism is failing. The neighboring right for press publishers in Article 15 DSM Directive fails to achieve its goals of providing EU citizens with high-quality journalism. I will speak about this in the second part of my presentation and propose how the conflict should be regulated instead. Thank you. Not via an IP right, but with unfair competition law. So this brings me to the first part, the structural change in journalism. Why do press publishers exist? Because they were necessary for the production and distribution of journalism for economic and technical reasons. However, in our times, they are no longer necessary. The old unity of press and journalism is falling apart. Today, journalism, and let me add very good journalism, can exist without press publishers. The new intermediaries empower individuals to have a voice and monetize it, thereby making contributions to the public sphere. Thanks to technological progress, anyone can now produce and publish journalism. For journalists, this means only one thing, which is freedom. They no longer have to be employed by press publishers, but can work as one-person company. Think of Derek Thompson, who left The Atlantic after almost 17 years for Substack. Also, small units become possible. Allow me to refer to an example from my hometown, Berlin. Some years ago, just a handful of people with no money have set up a blog in a small office in Kreuzberg. Today, Verfassungsblog is read all over the EU and even beyond. My point is, journalists are doing fine without press publishers. Their freedom can even benefit the product. The larger press publishing houses become, the more they are influenced by commercial factors. Journalism by individuals will often be better journalism in the sense of being less influenced because it is less subject to external control. This development, that journalists can exist without press publishers, is therefore a good thing for media pluralism. Because if journalists can become self-employed and must no longer rely on media outlets to get their articles published, they no longer have to follow an editorial line, which leads to a plurality of opinions. Furthermore, smaller units also contribute to a diversity of opinions in the information market. These structural changes mean that we need to rethink what constitutes the public sphere. I think we should work with a model of content and distribution that deconstructs the old unity of press and journalism. Journalism provides the content, press publishers provide for distribution. It is journalism that provides information that contributes to the public sphere. In our times, press publishers are no longer essential for its distribution. According to this model, there can be no public sphere without journalism, but there can be a public sphere without the press. Because of this new public sphere, we also need to rethink the concept of journalism, which is linked to certain legal privileges, but also to obligations. In our times, the concept of journalism can no longer be based on the assumption that journalists must be part of the institution of the press. Defining journalism via the press, an institutional concept of journalism, may be out of date, but it is quite simple. It is much more difficult to define journalists functionally in terms of their activities. Which writing is specific journalistic, and which writing truly serves the public sphere? Perhaps it helps to remember that a public sphere shaped by employed journalists is not a historical given. The Republic of Letters of the early modern period is an example of it. Perhaps in the future, the public sphere will no longer depend on the employed journalists, but once again on the figure of the publicist. Now, I cannot provide a new definition of journalism with about 10 minutes left, but I want to at least illustrate that media regulation should no longer be tailored solely to journalism provided by the press or other mass media. Because the press is no longer the basic condition for a democratic public sphere, it should no longer be given privileges over other private actors who produce journalism. The Court of Justice seems to realize that a structural change in journalism is happening because it addresses journalists or press publishers as private actors that contribute to the public sphere. I think the EU media regulation, however, is following the wrong approach, at least with its neighboring right for press publishers. And with that, I come to the second part of my presentation. European media regulation favors the press over other private actors so that it can produce high-quality journalism. To this end, the EU legislator has tailor-made a neighboring right for press publishers. It is based on the following assumption: if the press is doing well, we are all better off. The regulatory approach of the DSM directive can be summarized as follows. The public sphere needs the press for high-quality journalism. In order to monetize its content in the digital space, the press needs a property right for journalistic content. For many reasons, such protection of press publishers via an IP right is the wrong approach. Let me address one just briefly. Law that is tailored to the state of the art at a specific point in time, as in this case, the conflict press publishers versus AI, very quickly reaches its expiry date. So has the press publishers' right in times of AI. Article 15 DSM directive provides press publishers in the member state with the right of reproduction and the right of making available to the public towards the new intermediaries. These exploitation rights cannot help press publishers to fight the training of LLMs with their content in countries beyond the scope of EU copyright law, nor can it help against AI imitations based on it, as press publishers will most of the time not be able to prove that their news is recognizable in these. Yet the main reason why an exclusive right for press publishers is the wrong approach to safeguard high-quality journalism is the following. While the press still continues to contribute to the public sphere, it is no longer indispensable to the public due to the described structural change of journalism. Even if the neighboring right could secure the resources of press publishers, high-quality journalism of the press could only reach a very small part of citizens today. If we take a look at statistics from Poland, just as an example, other countries show very similar trends. We see that the vast majority of people now obtain their information in the digital sphere. With its neighboring right, the EU legislator is hence missing out on a large part of the digital public sphere. The focus on press publishers as holders of exclusive rights does not do justice to the defragmentation of press and journalism. Let me just add very briefly that due to the defragmentation of press and journalism, I think that also a market regulation protection of press publishers, as it is pursued in Anglo-American systems, is the wrong approach. The negotiation and mediation obligations provided for are also regulated in relation to just one private actor, namely only in favor of media companies. If the aim is to privilege one private actor, in order to ensure access to reliable information, it should no longer be press publishers, but journalists, due to the breakup of the old entity of press and journalism. However, legislation to secure the information infrastructure should conceptually not be aimed at improving the position of only one group of private actors. The most important requirement for good media content is that it does not contain any false information. This is regulated in the EU, at least to a certain extent, by the Digital Services Act. Beyond ensuring that content published on platforms is not illegal, a level playing field approach should be pursued in the information market. European media regulation should focus on the quality of the media content provided to its citizens, regardless of which private actor produces or distributes it. Instead of a regulatory approach that provides IP protection for only one private actor, a competition law approach is needed that benefits competition in the information market and thus the quality of the product media content. Such an approach would also benefit the media content published by press publishers, but not exclusively. Today, press publishers compete with fast food information provided free of charge and within seconds by the new intermediaries. More competition on the information market between old and new intermediaries can only be a good thing for the quality of journalistic content. If products from press publishers cannot compete on the information market due to the new offerings online, that is what Schumpeter called creative destruction. From a social perspective, it might be regretful that some press products are no longer able to compete in today's information market. Yet from a regulatory point of view, protecting private actors from technological progress via an IP right is the wrong approach. However, competition on the media market only benefits the product as long as it is fair. If the union legislator wants to intervene in the conflict between old and new intermediaries in the interest of quality of journalistic content, it should therefore regulate fair competition on the information market. In other words, address it under unfair competition law. With such regulation, not only press publishers, but anyone who contributes to the information market would have claims against competitors if they imitate journalistic content in a manner that is unfair. An unfair competition law approach at EU level should be based on the assumption that imitation as such is legitimate due to the principle of freedom of imitation. For unfair competition claims against competitors, the imitation of journalistic content would have to be unfair. The German regulation on protection against imitation between competitor states, for example, that the reputation of the imitated goods must be damaged. Such unfairness could cover cases in which AI chatbots misrepresent journalistic content in their text imitations or take it out of context, thereby damaging their good reputation. So I come to the end. Yes, I come to the end. So let me just say that an approach based on unfair competition law would also be more sustainable than IP protection. Neighboring rights provide actors with exclusive rights for contributions that are worthy of protections due to the investments made for them given the state of the art at a certain point in time. Therefore, the more technology-driven a market is, the more advisable it is to opt for a behavior-based regulation instead of IP regulation for certain actors. The information market is still undergoing a digital structural change, but even today, press publishers are no longer the only ones able to produce journalism. Therefore, I think they no longer need to be given an exclusive right to be privileged over other private actors who produce journalism. And with that, I come to my concluding remarks. The digital transformation has created a new public sphere. For this sphere, journalism is indispensable, but the press is no more. A forward-looking media regulation must realize that today good journalism can exist without press publishers. Legislation to ensure a reliable information infrastructure and media diversity should no longer be tailored to specific actors of the mass media who were needed to produce journalism in the past. Instead, it should regulate the good via behavior-based competition law approach, high quality and diverse content that benefits the public sphere, regardless of which private actor produces or distributes it. Thank you very much.
Thank you, Victoria. Thank you. Thank you so much. With the next presentation, we take a step back and we take a general perspective, but still within the copyright law. And I'm in a very difficult position because in order to introduce our next speaker, I would need at least 15 minutes and really gallop through her CV. I will just simply tell you that Eleonora Rosati, she's a full professor at Stockholm University. She's the author of really acknowledged books in copyrights and trademark law. But above all, this is my favorite role of Eleonora. She's the mother of all cats of the IPCat blog. The things we are reading it every day, even before reading Fuzz, we are reading the IPCat blog. At least this is what I'm doing. And it's my pleasure that Eleonora will speak today online. In a moment, we will put your presentation. I think you are mute, Eleonora. You have to check yourself. Okay. Now we can hear you now.
Very well. So let me start by thanking you, Lavinia, for the invite. It's an honor and a pleasure to be part of this terrific program. And I apologize for not being able, indeed, to be in Poland with you today. So I would like to keep my remarks rather short, also to allow time for the discussion if there is an interest on the side of the participants and the fellow panelists. And in the time at my disposal, I would like to touch upon just the tip of the iceberg that is in the relationship between copyright and artificial intelligence.
Sorry, Eleonora. Sorry, just can you just check that you will be that you are able to move the slides by yourself, or shall we do it? Sorry that we.
No,
yes, it's okay. It's perfect. You are doing it, so you are on. I will not interrupt you. Yes.
Not at all. Speaking about copyright and artificial intelligence might take years, and I would like to say that the pace of developments is incredibly fast. Indeed, Lavinia asked us to provide our slides by last Sunday, and that's what I did. But if I had to prepare the slides today, probably I would add new things that have occurred this week. So the pace is indeed hectic. And just to mention one important stepping stone, just yesterday there was the release by the UK government of a response to the public consultation that ran between late 2024 and 2025. And the conclusion on the side of the UK government was to backtrack on its original plan to introduce a new exception that is broader than the current one for text and data mining, and instead, for the moment, do nothing and study the issue more, given the backlash that indeed the public consultation did receive in this respect. There are other things in the response, including the potential introduction of an image right in the UK system, the repeal of the provision concerning protection of computer-generated works. So just about that, one could speak for months. So we have only a few minutes at our disposal, and I've decided to focus on the input phase that also encompasses the training phase. The reason why I've chosen that is because this is at the center of litigation in many countries around the world. There are several cases currently pending in the United States. There is a referral pending at the moment before the Court of Justice of the European Union, that is the Like Company and Google referral from Hungary, in which indeed the hearing was held just a few days ago, and the opinion of Advocate General Spunar is expected right after the summer in September. There has been a national case law, appeals are ongoing, etc., etc. And I've decided to approach that from a principle and a clause that finds its place in both international and EU law, but as such is indeed undefined and can be given different meanings. It is the requirement that a fair balance is struck between different rights and interests. And here, of course, the interests that are at stake are on the one hand protection of copyright, and on the other hand also freedom to conduct a business, innovate, and so on. So, in essence, the fair balance lens, insofar as the training phase of AI models is concerned, is about understanding how far the control of right holders should go, and where instead AI developers should be able to use content protected by inter alia, copyright and related rights, without the need for permission and therefore without the fear of liability. And to address this, I would like to take as a point of notice the relatively recent opinion of Advocate General Emilium in a case that nothing has to do with AI. It is the Pelham 2 referral, and it concerns the notion of pastiche. Nevertheless, what is interesting about the quote that you see on the slide is that the Advocate General also acknowledged that there might not be a single way to strike the fair balance. The fair balance can shift, and it can indeed be put in different places depending on the circumstances, what interests are deemed to be prevalent, and so on. So I think that is really interesting and a useful reality check. So all those that present themselves as AI evangelists, truth tellers, etc., the truth of the matter is another one, that it is possible to find different solutions, and not necessarily what is true today or what was true in the past is going to hold true also in the future. So to borrow indeed from Victoria's presentation, not necessarily things that were once in a certain way have to stay the same way, and vice versa. So, as I said, there are several things that could be discussed. Here on this slide, you can see the three main blocks that one can consider. I'm not focusing on output generation, so I'm not discussing protectability of these outputs, and I will not go into the details of potential liability risks stemming from the use of AI models. But I will not leave this final point completely out of my presentation, also because at the hearing in indeed the Like Company case, A.G. Spunar made an interesting point that it might be artificial to distinguish too bluntly the training phase and indeed the output generation phase. So I will return on that. What I would like to say at the outset is that one of the questions in this Like Company case is indeed whether, in a nutshell, AI training is even relevant under copyright. Of course, it is phrased more elegantly than what I've just put, but one of the questions, in essence, boils down to this very issue. And I would say that insofar as Europe and many other countries are concerned, the answer is in the affirmative. AI training engages exclusive rights under copyright and related rights. The Like Company case is not about copyright, it is about the press publisher's right. And by adopting exceptions for text and data mining, in a way the EU legislature did indicate that these activities are relevant under copyright. Now we can open a discussion whether TDM and AI training are the same thing. My position is that they are not, but there are commentators who hold different views. For the sake of our discussion, this slide shows indeed the scope of exceptions for text and data mining that have been adopted in different jurisdictions around the world. The first one to legislate was Japan in 2013. It subsequently broadened its exception in 2018. And the TDM exception in Japanese law is often presented as a very permissive one. I'm not sure on what grounds people who make these remarks feel so confident, because as far as I know, there is not much, if any at all, case law on AI training in which this exception has found application yet. So I think that the boundaries are still to be defined, and if one actually considers the official position of indeed relevant bodies within the Japanese government, the overall approach is one of, I would say, caution more than confidence. Then there has been legislation in other Asian jurisdictions. The most notable example is Singapore. The UK, as I mentioned, introduced a limited exception in 2014 by taking advantage of the then existing EU framework during its tenure, therefore, as a new member state. And just this week, the position of the UK government was, for the moment, not to extend the scope of, indeed, defenses under UK law. And then in the EU, we have indeed these two new exceptions that are found in the 2019 DSM directive, and which have started finding application at the level of national case law. I will not go into the details of either Article 3, which is a TDM for scientific research purposes, or Article 4, which is a more general TDM exception. What I care about emphasizing, if you look at indeed the fourth column of this slide, is the circumstance that, with the possible exception of the Japanese provision that is framed by using a language that is rather specific, and the US, for which there has been no legislative intervention, and all these cases that are currently pending will boil down to the application of the US fair use doctrine, all the other exceptions that you see are not exceptions, one, for AI training. They are exceptions for text and data mining. And second, they are exceptions to specified restricted acts under copyright and related rights. If we focus on the EU provisions in particular, we see that there are exceptions only applying to acts of extraction and reproduction. So let me take as an example this image that comes from one of these US cases currently pending, in which indeed the plaintiff has argued that Midjourney is a model that is often prone to what in technical jargon is known as training data regurgitation. As you can see, it is possible to input prompts that result in images, like the ones that you see, that are extremely similar to indeed well-known protected characters owned by famous film studios. So if we were to consider something like that from a new perspective, clearly an output of this kind will not be covered by either TDM exception, because it will go well beyond the scope of these restricted acts, and this will beg the question also of who may carry liability for generating an image of this kind. It is something on which I will return in a moment. In any event, this example that I've just shown is also relevant under another angle, which has become very much discussed, and it is the question of memorization. Now in this like company case, there is the discussion whether there is even reproduction of content for training purposes and storage of this content in the model. According to some technical experts and indeed AI developers, there is no copying, because it is all about probabilities, patterns, predictions, etc. And if there is a copying of training data, this training data is not stored in the model. So in other words, there is no memorization. However, there are other studies that suggest the contrary, and that memorization can be actually more relevant than what has been believed so far. So where does all this lead me? It leads me to say that yes, these cases are interesting and we shall see what the outcome will be, how far-reaching the relevant legal principles will be, or instead how fact-specific the holding of courts is going to be. But, and this diagram that you see is a representation of the activities that have occurred in indeed the German case Lion, which was probably one of the most discussed in Europe on TDM and AI training. And in essence, Lion, apart from its qualification, which I will leave on the side, undertook a series of activities that you see on the left-hand side: scraping of online content, creating a data set, publishing the data set on its website, and then allowing third parties to download the data set for training purposes and then subsequently use the resulting model. All these activities, from a copyright and related rights perspective, are in correspondence to specific rights. So sui generis database right of reproduction of different right holders, and potentially also right of communication making available to the public. Again, I repeat that these exceptions only cover specified acts which go less far than this example that I've provided, and certainly they do not extend to AI training as such, but they require these activities to be done for text and data mining purposes. So I would say that right now the law seems to be quite clear that in Europe this balance is set in the sense that some activities may be performed without permission, but the bulk of AI training may be in need of consent from concerned right holders. In any event, I will make three additional points before approaching the conclusion. The first one is that these discussions around memorization are interesting, technically relevant for sure, but from a legal standpoint, not as significant as they've been presented to be. And the reason is simple, that the right of reproduction is intended very broadly. And indeed, the case law of the Court of Justice itself consistently indicates that reproduction can be in any manner and in any form, and it doesn't exist bound or tied to a specific temporal dimension. So whether there is memorization or not is not indeed a discerning point to determine if there is a reproduction or not. Then another key aspect is that all exceptions to copyright, and that expressly is the case of the TDM exceptions in EU law, are subject to a lawful access requirement and are bound to comply with the steps of the three-step test. So, for example, if one scrapes the web in going against relevant terms of service that might prohibit this activity, already here we have something that is no longer lawfully accessed, and therefore it can be like a poisonous fruit that prevents the application of any TDM exceptions or other exceptions. Then, of course, there is the question of output generation, and I'm sure you've read that just during the Winter Olympics recently held in Milano Cortina, some ice skaters used AI-generated music that prompted an backlash due to the fact that indeed these songs sounded like well-known songs. So there might be issues of indeed copyright infringement at output generation. So I raised before the question, who will be liable for that? If you look at the terms of service of most AI developers, they are adamant that any potential liability from the use of these systems is with the users. So I'm sure that also opening to other areas of the law, in the years to come, we will also have a consumer law angle to explore in relation to these terms, but this is what they currently say. So it is not just a discussion that involves big tech and big right holders, but it can reverberate its effects also on users of AI models. And since AI use is becoming ubiquitous, it can affect indeed a vast group of persons and entities. So to conclude, where do we go from here? For sure, AI is here to stay. I don't think it is realistic to imagine a world in which this is going to stop. And it will lead to adjustments and also will have a displacement effect, as it has happened with other technological disruptions. For example, today, having the dream of working full-time as a calligrapher may be something reserved to very few people, while a few centuries ago might have been a more open type of profession to pursue. And so this might be the case also for some professions that indeed exist today. What we are seeing, however, both having regard to the already mentioned response of the UK government, the position that indeed has been presented also at the EU level, for example, in the recently adopted VOS report, as well as the discussion that is unfolding in other jurisdictions, it seems to me that at the moment there is a bit more of a balance being struck in favor of licensing rather than exceptions. So there is awareness of these displacement effects. There is awareness that indeed the allocation of this value that comes from a development may not be fairly allocated as things currently stand. So it seems to me that now we are entering a phase in which greater control is indeed looked at more favorably. This was also the position of the US Copyright Office in the pre-publication version of its part 3 of its AI and copyright report, before indeed there were events that led to the initial dismissal of the Register of Copyright and their subsequent reinstatement. So we shall see whether we come to a publication version or it will be only pre-publication. Then there is the question of what is protected by copyright. If an AI model imitates someone's style, is that actionable? This is too complex a discussion to have right now, but in short my answer is that yes, a style might be protected, and this was also the position of AG Emilio in his Pelham 2 opinion. The case will be decided next month, so we shall see if the Court of Justice agrees. Last but not least, when it comes to use of content for training purposes, since it is not fully clear what content is used to this purpose, we cannot speak about copyright without other governance mechanisms. And here in particular, I'm referring to the transparency obligations that are present or are being introduced in several laws around the world. For Europe, of course, the relevant provision is Article 53 of the AI Act, for which the relevant template was released last summer. It might be too early to say if this transparency obligation is being operationalized in a fruitful way, but indeed there are some stakeholders that have already expressed their disappointment. But in any event, as also acknowledged by the UK government, we cannot speak about copyright control or related rights control without also having robust transparency obligations that allow indeed right holders and interest stakeholders know about whether their content has been used for training purposes. This would be key for enforcement purposes, but also to ensure that one is able to control the use of their content in the first place and not only ex post when deciding whether to take indeed an enforcement initiative. And with that, I hope that I've not exceeded too much the time at my disposal. I would like to conclude. Thank you for your attention. This is taken from the recently adopted VOS report, and I look forward to the discussion at the end of indeed the individual presentations. Thank you very much.
Thank you, Eleonora. Thank you. I don't need a coffee after the lunch now. Thank you so much for your presentation. The last presentation also takes us back to operational issues, and I don't want you to see that we are doing some discrimination here. So we have a man here. So Dr. Peter Słowinski is really a multitasking person. Because he earned his PhD in Max Planck Institute under the supervision of the then chief of the Max Planck Institute, the IP, Professor Reto Hilty. And since then, he is in Poznan, Adam Mickiewicz University. He's an assistant professor there, but he also is a researcher with the Weizsäcker Institute. He has a grant and is also a researcher. You see, you have too many tests. I forgot. Who's the third one? It's Berlin.
Still MPI.
You're still MPI. Yes. So first love, it's always present. So yes, it's still Munich also. So Peter will tell us today how we should teach intellectual property law to AI. Go on, your floor.
Thank you very much, Lavinia. But my main job actually is Lili Poznan, Adam Mickiewicz University. Everything else.
Because your boss is here. I know it's
my boss is, yeah.
Yes.
And everything else is side gigs. But thank you very much for the invitation. Actually, the first time I was talking about AI and the law was in Warsaw in 2018, so a couple of years ago. Back then about patents, today about copyright. Back then I used a few norms and cases. Today I will not mention a single norm or case. I will mostly talk about the technology and how it interacts with copyright, and the main question whether we actually can teach AI copyright, intellectual property, or any kind of law for that matter, because we have heard a lot this past couple of hours about influences of the new technologies and ethics and all those questions. And so what I'm wondering is, okay, can we actually teach the tools what law is, make it understand the law, to make it easier from various perspectives? Why should we do it? Well, first of all, because AI is here to stay. Anyone knows this guy? By the way, I like asking questions during my presentations. There was a yes, somehow? I remember he's German. Yeah, okay, so this is Joseph Weizenbaum. Yes, he's the guy after whom the institute is named. And Joseph Weizenbaum introduced 60 years ago, in 1966, ELIZA. ELIZA is like the great-grandmother of all the chatbots we're using nowadays, 60 years ago. This is, by the way, when I look around in the room, longer than anyone or most of us are on this world. And ELIZA already provoked most of the questions that we are asking right now. Because ELIZA was supposed to be a psychotherapist. And people were telling this machine all their personal details, everything basically. And this raises questions of ethics, of regulation, and so on. It was a deterministic system. It was not like a machine learning model nowadays. It was not probabilistic. It was a little bit different. But the questions were the same, and this is still AI. So this is the first thing. The second reason why I think we should teach AI the law is the same reason why we teach our students to understand the law, why we teach our students the law, to understand it. Why? It was just mentioned in the previous presentations, because of liability reasons. And second, decision support. This is something that Orit mentioned in the very beginning. Can we somehow use AI to support us in our decisions? But if AI is supposed to support us in our decisions, it should understand the law.
Sorry, I just have to check that our guests are still here.
They're here?
Yes.
Okay, good. So here we are. Liability prevention and decision support. So let me give you one example and walk you through something that I played with last summer. So there is this AI tool called Sora. Sora is something like a cousin, brother, whatever, of OpenAI that is a cousin to ChatGPT, and it's meant for video creation mostly. In the free version, you can also have like a concept picture for a movie. And I used this prompt with Sora. I want to create a movie where a tall person wearing a black plastic-like armor and a helmet that resembles a gas mask, and a cape is boarding a spaceship surrounded by figures in white armor, and the spaceship is also white. Any kind of ideas what this might be? Okay, yes, it's Star Wars. But I'm not mentioning Star Wars, actually. Nowhere there. Based on this prompt, you could come up with different designs. What did Sora give me? This. By the way, I know the movies by heart, and those scenes I know of the movies. So they were created de novo. This is something completely new, but inspired by what we know from Star Wars. Okay. You can't really have a chat with Sora, which I found boring, so I used the same prompt and put it into ChatGPT. Last year, ChatGPT got the function that it can also now create images. This was not possible really before that. And so we started, and ChatGPT is sometimes a little bit annoying because it asks all those questions back. I just wanted to have this image. And so I told it, just do it. Let me be inspired. Let's not have a long discussion. Why did I do this? Because I didn't want to influence it. I just wanted my original prompt, and let's see what happens. What happened was basically it started calculating. I saw the image building up, and suddenly I got the message, well, it does not follow our content policy. A tool by the same company as Sora, by the way. Okay, so I was like, why? Yeah, okay, Darth Vader, Stormtroopers, trademarks, design. I'm a lawyer, I understand what it's about. So I thought like, okay, but it's not like I told you to give me Star Wars. I told you to give me something based on a description. So please give it to me without infringing. Quite clear. Started again, started, processed. After a while, I get again the image. It does not follow our content policy. I ask again, okay, why not? What's the issue? And it told me that basically every single aspect, apparently, of what I asked it to do would have been okay. But the accumulation of things that I requested would be coming too close to Darth Vader and Stormtroopers and so on, and therefore it triggers an automatic detection. By the way, shortly before I did this exercise, the first case was started again by Disney against one of those AI companies, and I guess this safety measure was introduced afterwards. But what does this mean? Okay, so does this mean that ChatGPT understands copyright or trademarks or design and is therefore not allowing me to infringe? Or what is it actually? And by the way, a few prompts later, we arrived at that. So we continued the discussion, and ChatGPT was quite helpful because it suggested how I should adjust my prompt not to infringe. And this actually still is in line with what I wanted in the very beginning, but I guess it, well, as lawyers we could discuss it, but I guess it's not really infringing on anything. So what does this example show us? Does AI understand IP law, law in general? It depends very much on what do we mean by understanding. And here we go into like theory of computer sciences, and everyone familiar with Alan Turing and the Turing test? By the way, he would not have been able to do much of his work without our university in Poznan, because it was our mathematicians who laid the groundwork for what he has done. Just mentioning. So Alan Turing had a Turing test, and the Turing test is quite simple. If I, from the outside, speaking to the machine, communicated with the machine, cannot distinguish whether the answer comes from a machine or a human being, then it's intelligent and understands on the same level as a human being. But there's another test. Anyone knows John Searle? Okay, he's less known. John Searle came up with something different in 1980, something like 30 years after Alan Turing. And he said, imagine someone sitting in a room, black box. We like black boxes when we talk about AI. And this person inside gets Chinese characters through a hole and has to respond with a corresponding Chinese character that they have inside the room. And the funny thing is, people outside are standing there, putting in the Chinese characters, and the right responses come out. The person inside has no clue of Chinese. How is this happening? It has a rule book. The person inside has a rule book exactly explaining it, which character corresponds with which. From the outside, it looks amazingly intelligent and understanding Chinese characters, but it does not. It just follows strict rules, what to do when what input comes in. This is everything. So AI may produce outputs and decisions that mimic understanding without it really being understanding the way we understand as human beings, because we understand context, we have experience. I read one example, for example. AI can tell you that the best way to protect against rain is an umbrella. Today in the morning it was raining, I didn't have one, I got one and bought one. AI does not understand what getting wet means because it can't get wet. It lacks this experience. So it cannot understand it. It can put together rain, I need an umbrella, but it will never understand really why. What can AI do and what cannot it do? So AI can provide pattern recognition and assess probability of infringement. And at this point, I'm speaking about AI as machine learning and AI as large language models. This is not AI in total. This is also symbolic AI, deterministic AI, generative adversarial networks, all other sort of stuff. But this is pattern recognition, probability, this is large language models, what we usually talk about. It cannot make judgment decisions because judgment requires some kind of experience and understanding also of values. This is something AI cannot do. And it may require hard rules for clear cases. I had a longer discussion that I did not depict here with ChatGPT. Okay, why exactly did you not allow me to produce this picture? It didn't want to explain to me exactly, but my assumption is there is a hard rule somewhere in there telling it, if it gets too close to very, very famous stuff, don't. But why in the previous presentations we have seen that it is possible to generate stuff out of used by AI that is infringing, because if I don't introduce this hard rule, it will happen based on probabilistics. This is all AI can do. I have one big issue with those hard rules, and this is limitation of creative freedom. Because what I have shown you, the last picture, I have produced something that is creative. I got inspired maybe by George Lucas and Star Wars and so on, but I'm pretty sure I was not infringing on anything. But if I had not gone for a lengthy discussion with ChatGPT, I would not have gotten something that is, in my opinion, not infringing and within my rights of creative freedom and creating something. Okay, I will use the last couple of minutes to jump to something different, away from liability and creating, and to decision-making support, which kind of will close the circle to what Orit was saying in the very beginning, how we can use AI in decision-making processes. And the big question that is right now being discussed is, can law be code? So can we introduce law into machines in a way that they understand it and interpret it as they do code that they have? And the question is also, what kind of AI do we need? And I want to put out 3 terms out here: determinism, probability, and judgment. The ELIZA system by Joseph Weizenbaum was a deterministic system. It had a clear set of rules. So it was not very free in how to formulate its answers, but based on certain input, it knew what answer to give. Probabilistics is what we have in large language models. It's just based on statistics. My favorite example that I also use with my students is, the sky is, and the next word could be blue, clear, whatever, and based on the context and statistics, AI will complete it. And it is not really appreciated that large language models cannot do more. They just complete, like autocomplete stuff based on large amounts of data and highly sophisticated algorithms. But they are just completing sentences in a way. And judgment is the third one, which may be somewhere between determinism and probability, but rather is somewhere outside of that. First of all, I believe that you can break down every law into sub-steps and you can code those. This is possible. But if we ever want AI to support us in decision making, we should think about how we write our laws for the purpose of being implemented as code at the moment when we write the laws. When I think back at my student times and the Bürgerliche Gesetzbuch in Germany from 1900, basically, those laws were quite simple. It was quite simple to follow a step-by-step process to arrive at a conclusion, basically. if I look, for example, into what is coming out of Brussels, then it's quite difficult to translate this into a step-by-step process that I can then code into a machine. It's already difficult for me to understand it as a lawyer, and then break it down in simple terms, it's close to impossible. So I think if we really want machines to support us in a predictable way, we need to go back to the drawing board, start writing simpler laws, and we can then translate into code. So elegant code and elegant lawmaking is basically the same thing. I highlighted the last one in blue, because I think at the very end, and this is also something I think that Orit mentioned in the beginning, in the end, judgment calls will always be human. So we can speed up some of the standardized tasks in applying laws. But in the end, it will be a human who will make the judgment call. And I want to show you also at the very end, this is the conclusion, really, the last slide. It's not really a conclusion. I want to show you the differences between us and machines. I asked Mistral Le Chat, another AI coming from Europe actually, can you make me an omelette? Mistral is a French machine, so I thought an omelette would be nice. Of course, it told me, no, it can't because it's physical. So I came up with another question. Can you make the woman of my dreams fall in love with me? Well, it's French. It's supposed to be able to do this. And what I liked in the answer, that things like love, interhuman relationships, depend very much on shared values. And shared values are my connection back to judgment calls. And this is something that the machine cannot replace us. And so I think they can, if we train them right and we use the right tool for the right task, we can have machines help us in many ways, but judgment calls are still ours. Sorry for going over the time, and thank you.
Wonderful. Thank you so much, Peter. And let's applaud all of them, because you saw what means the line of extraordinary speakers. Now I open the floor for questions, and we'll take all the questions just at once. Yes, please.
My name is Łukasz Żelechowski. I know it's late in the afternoon. Just actually two questions to Joanna. Yes, it's very true, this dilemma, will there be a death of trademarks, right? Looking at the rationale, I mean, you pointed it brilliantly that it's the question whether the consumer search cost reduction is still the valid rationale. But what about, I mean, because I think the trademarks will survive. But I think an aspect that you probably did not mention, or I missed it, is the brand protection, right? When trademarks become products of their own. So I think that our human, let's say, weakness and our attachment to brands is something that will survive AI, just because we think something is cool and we are buying it. So what do you think about this shift? Because I understand you tried to sort of save the rationale for trademark protection and, you know, cutting the search costs and the way from the consumer to the product. And I sort of agree with you, because I think that once, let's say an AI assistant orders a product for us, we just say, I want to buy a white detergent that washes white textile, for example, right? We get it once, we like it, and then we know the name. So I think that this, there is more about the quality function here, but I think we will still, let's say, even with verbal messages addressed to our assistant, whatever, or some typing, we will use trademarks, and I think the algorithms will still be ready to recognize that kind of message when we use the trademark. But the brand protection, I think, you know, there is a lot of discussion right now with the brand protection. I mean, trademark as an insignium of brand, as a manifestation, one of several. Trademark is, you know, like the face, let's say, one of the faces of something that is the personality of the entrepreneur. That here, this shift in the rationale for trademark protection will take place. I think it is already taking place. Maybe it's another type of property right. And I think that this will be saved from any AI threats. What's your take on that? That's the first question. The second question is, you mentioned something in your slides, I think, that we need the comeback, or we can anticipate the comeback of traditional trademarks. I sort of feel that they have always been there with us. They don't need to come back, because I don't remember the exact data, but when you look at the statistics of the EU IPO, the non-conventional trademarks, this is like it's a niche thing, really, right? It's very nice for conferences, and so, you know, and also when you look at case law, it's mostly about the registration stage. The infringement is not really such a big thing. So, but then my question is, have you come across this problem? If we really develop the use of AI assistants, and it is very helpful to consumers, what is the future, maybe not just of non-conventional trademarks, but even figurative trademarks? Because I can imagine asking my AI assistant, please get me the detergent with the name so on and so and so, right? Or typing it. Well, it's also doable with figurative trademarks. You can take a picture, right? What about sound trademarks? That's doable as well. We even have, you know, software to recognize music in the restaurant that is playing if we don't know the song, right? But then when we think about motion marks, multimedia marks, you know, hologram marks, and all those other gadget marks, as I like to call them, do you think that the probably increasing use of AI assistants will reduce the role of other marks than word marks, really? So among traditional marks, these would be also 2D marks. Have you come across the problem how algorithms are ready to recognize this form of communicating the message? Like, please buy me food from the restaurant, and then we play the jingle of the restaurant, and we expect the AI to recognize that, yeah.
Yes, so Professor Annette Kur, another question. I'm collecting questions. Erwari, how much time do we have for questions? Please tell me, and for answering.
Yeah. Okay.
15 minutes, okay.
I mean, Lukáš has more or less said exactly what I wanted to say. But, let me first address Victoria, because again, I mean, we had this, I had the pleasure to listen to your presentation some weeks ago in Berlin, in German, and then we had already a big discussion, so let me just repeat two things. First of all, the definition of journalism, if you want to get away from the classical privilege given to the press. And of course, nobody is really happy about the press publishers' rights, that's for sure. But if you want to expand this, and then the first thing is that you have to come up with a definition of what journalism is, or whether you want really anything which is then somewhere on the internet to figure under that title. And the second thing is that, I mean, this was a discussion in Germany, and with people who are very experienced with applying unfair competition law in Germany, it's really a little bit precarious to think that with notions such as imitation and taking unfair advantage, what could actually preserve or secure the quality of the press, because now we have press media laws and ethical standards and so on that apply to press organs, which I think can hardly be emulated by simply applying unfair competition concepts. But then, Joanna, very powerful statement, so your jacket was fantastically chosen. But I also agree that, I'm not concerned about the future of trademarks. In addition to what Lukáš said, I mean, we will probably always be living in an analog world, so it will probably be a parallelism between the analog world and the digital world. So, and when we go shopping, then probably we need trademarks anyhow. And the second thing, but then I think I echo something that Lukáš already said. There is this, the essential origin function, but then also the trademarks as a sumptuary code, like Baden-Biebe has called it. So it's signaling my status vis-a-vis others. Of course, the AI will know me very well. They will probably know what kind of status I want to symbolize, but then they still need to put a name on it. That's the first thing. And the second thing is that also I need a little name tag somewhere in order to for this signaling function to work. So I think there are additional reasons why trademarks and trademark law will continue to exist.
I use also my privilege, so I will just ask Eleonora. a disclaimer, I'm coming from this design perspective, and I notice at the end you show this kind of images that were just generated, and you said they are looking very well similar to many things. So I wanted to ask you about this recognizability as a criterion. What do you think? Do you think that CGU is able to devise a test or a sort of algorithm of applying it somehow and to do it with predictability? Because if even today, or I don't know, in the last 10 years, we're not able to do things with this kind of industrial work protected by copyright, and now we'll have, I don't know, a deluge of cases which can involve this AI generated by self-image. So I would like to listen to your ideas about this recognizability or this, substantial infringement. Let's call it like this. Thanks so much. Oh, and we have also Kasia. Okay, sorry, I didn't. I was just.
Thank you so much. That will be a quite short question. My name is Miglė Džiusbrė. I'm from Vilnius, Lithuania. And I'm a practicing lawyer, but back in the days, I also had my time doing a PhD in justice and specifically on procedural aspects of justice and decision making. The question I have is mostly coming back to Orit's presentations, if that's okay. I basically heard AI decision-making challenges in terms of transparency, impartiality, etc. But from my understanding and what are usually the basic principles of procedural justice, there's also this one concept of the fact that judges need to be of a certain qualification. They need to have a certain experience in decision-making, or at least some kind of legal background, etc. My question to you is, and maybe to everybody for a discussion, if we are talking about this due process by design, how do we implement that decision-making qualification aspect in the AI process? How do we? What's the equivalent of experience of AI in this respect in due process?
Okay, and I will take a last question from.
Yes.
Yes.
Thank you. I have 3 questions. I'm not sure if I managed to ask all 3 of them. But firstly, I would like to...
Would you kindly introduce, because I cannot...
Yes, sorry. Again, Katarzyna Klawkowska, Mickiewicz University in Poznań. My first question goes to Eleonora in combination with Piotr's presentation. So, Eleonora, based on your presentation, although you were not decisive in saying that in plain words, but one might be very cautious about using AI tools because of their legal compliance and potential infringements of copyright and related rights or sui generis rights. That leads me to the question, would you advise using AI tools, for example, in research or education? In research, I would say Piotr is a great example that one can dare to use it, even being a lawyer, and some answers were also offered. So in the sense that there is some policy, content policy built in, at least some of them, or maybe it's so dynamic that some of the lawsuits didn't address the question. But in your eyes, when can we be safely expecting to use those tools and presume that they are legally compliant? And that relates also to Piotr's presentation. So would you think, how would you judge these safeguards that you already observe as sufficient, or do we need much more to use them without any IP-related concerns? Thank you.
Okay, so we go to the answer. Joanna, will you answer all the questions? Can I give you maximum 4 minutes or 5? Will you manage?
I will do my best, especially since 2 questions. Like,
I mean, if Ruari, there's the last instance because he's dealing with the conclusion. So.
Thank you for those questions. And if I make first, combine the second, sorry, it was actually the first question, Łukasz and Professor Kur, about this other, let's call them accessory functions of trademark, broader communication, signaling, advertising quality. I didn't have them in my presentation. Initially, I actually did, because this is a topic that already was to some extent covered in some other literature. But I completely agree with the fact that there are basically no objections to saying that trademarks can still perfectly well serve this accessory functions, not to mention, of course, the parallel normal shopping world. Absolutely, there will be, it will be possible. The thing that I want to focus in this presentation is that some authors say, yeah, they can do this, but they can no longer, they might not want to be this badge of origin. And I was trying to prove that maybe we still can find this rationale, somehow like, grasp this perspective of the badge of origin still, because I was a little bit afraid that if we only preserve accessory functions, there may be not enough justification. Basically, we are maybe not ready for this kind of rationale. But I would like to see, and that's why in my presentation, I also went back to the basically this positive externalities, consumer protection mechanism and pro-competitive mechanism of trademarks. Because I think I would like to see at some extent that we go away in this modern world from putting labels on functions as such, and maybe try to think about trademarks. Yes, we can still protect them because of this consumer and market rationale, without saying origin function, advertising function, signaling function. And maybe that would be a step to argue for, but I focus on this kind of a middle step. Maybe we can still preserve them based on the basics and try to argue this longer pro-competition rationale on the side. And in terms of the second question, Łukasz, in terms of the comeback, I had to rush to the last slide. I wouldn't necessarily say that comeback in the sense that we'll see even more of them in terms of proportions, because I completely agree with you. In terms of proportions, they are still the dominant ones. But comeback in the sense of investment put by companies into making them visible for AI agents, AI assistants, and also in the sense of try to use the machine learning capabilities of AI to change the marketing strategy slightly in the way that like we educated, like brand owners educated consumers for so many years, maybe now they can find a more sustainable, better, quicker way to actually educate AI thanks to this machine learning capabilities. But where we will see that, that's definitely an open question, and whether this other marks will be useful. Maybe if shoppable TV will become even more important, maybe the sounds trademarks would still be, on the rise. But this is still probably the question for the future to see where this advertising, which channels will become more and more popular.
Thank you so much. So let's keep the order. It was then Victoria and the question of Annette.
Thank you. So I will be very quick and say you are right about the concept of journalism. So I'm still thinking about it. I cannot give the perfect answer what journalism is today. For me, it was important to make the point that we should think about it, because I think at least in Germany, it is not really contested at the moment that journalism is what the mass media is producing. And so yeah, I wanted to make the point that we must start to think about it, also in terms of diversity regulation. In Germany, we have a regulation about diversity on platforms and against discrimination of content, but it's only against discrimination of content of the mass media, for example, and I would say it should also be against discrimination of journalism, which is not from mass media, so that is an example. But you are right, I think this is maybe one of the big tasks of media regulation, to think of a new concept of journalism. And yeah, with that, I leave it to it. Thank you.
Thank you so much. Eleonora, would you like to jump in now? Thanks.
Yes, I will respond quickly. So let's start with the Mio recognizability approach. In answer to your question, whether we will come to a clear test, I don't have much hope. So I don't think that the Court of Justice will clarify this unless specifically prompted by a new referral asking what the benchmark for recognizability should be. Since indeed you, Lavinia, have a strong design background, I don't know if you've seen that very recently there has been an application of Mio Connectra in Belgium. It was reported in a blog, and I don't know if it was a matter of translation since it was written in Dutch, But it
Yes, yes.
seems that this Belgian court considered that recognizability should be in accordance with the relevant professional circle. Now, I think that this does not go in the direction that the Court of Justice intended, and it is, I think, symptomatic of some confusion for years to come. And so MioConnectra has by no means settled issues relating to the treatment of works of applied art, and more generally the copyright infringement test, which I think was fairly clear and relatively workable just by sticking to originality.
Okay,
Then regarding the question whether it is ever safe to use an AI model, right now I would say it is not safe no matter what the type of use intended is, considering that there is indeed uncertainty regarding the lawfulness of unlicensed training, and it is not clear what is in the training data. In essence, a lot will depend on whether these terms of service that shift all liability on users will be deemed valid and enforceable. And that, I think, is a question mark that will require a number of years to indeed unfold. These are matters of consumer protection, but also I would say copyright law, because indeed the CJEU itself has deemed the content of the terms of use relevant also to determine the direct liability of platform operators. So I imagine that this might come in handy also to assess this other angle, which so far remains rather unclear in its borders.
Thanks so much, Leonora. So, Orit, can you answer the question about, all right, please,
Yeah,
about the
thank you.
judge?
Thank you. So, as I stressed already at the outset, the legal framework governing AI decision-making in the public sector is completely different, of course, from that of the private sector. And my study is addressing only the private sector. And the question of AI judge, of course, is a very severe and a heavy issue. And yes, I agree that I think that by definition, AI system is impartial. All the decisions are impartial because it is a statistical result. So of course it's impartial. It reflects only statistics. It's not a decision that is taking into account, a specific facts or data. So I think the AI judge issue should be treated separately. And my entire proposal refers to the private sector AI systems, which I should emulate to a certain extent public sector procedural justice elements, which of course cannot be met completely, but at least some elements should be implemented, such as hearings. So this is my very short answer.
Thanks so much, Orit. So, Peter, the last man standing.
Also, thanks for the question. Short answer, no. It's not enough to prevent any copyright infringement. But does anyone care? This is a much more important question. Because the interesting thing is when you look at all the cases we have right now, they are not like Napster or Pirate Bay or whatever we had in the past. It's not someone infringing somewhere and the copyright holder is going after them. No, the copyright holders themselves are using the machines to create infringing content to prove that somewhere in the machine is copyright infringing content, that it was trained based on their content, basically. This is what they are trying to prove. So I'm not sure whether they really care about the output right now so much. They care about the input, and they want money for the use of the input for the training. So this is what we are seeing right now. The second thing is most of those copies are not one-to-one copies replacing anything. So it's not like Napster, and now I ask ChatGPT to provide me a Taylor Swift song and sing for me to replace Taylor Swift, or some kind of movie. This is not what's going to happen. I have something that is similar, something that I can use. Maybe it will infringe something, but that is not replacing the original in such a way, in most of the cases. So I think right now, it doesn't really matter so much whether the safeguards are enough. The discussion that we will have once the cases have been decided also by the CJEU will go on the question, how do we get money for the use of the training content? And once we solve this, we really don't care about the output because someone will get the money, and this is all everyone cares about. With one reservation, I think some content creators, some artists, some musicians will really not want it to be used at all and come out. But I think this is not like the majority of the big studios and the music labels and so on. They just want money for the use.
Thank you so much. So I think we really need an applause for the whole, this kind for our panel. And thank you so much for our resilient ladies online. I really hope one day to see you in person. And thank you for being with us until the end. So now I'll just pass the mic to our other organizer. Yes? Okay. Yes, so now we start to shift the responsibility. I think we'll pass it, I know to whom we'll pass it.
I think we should be like, everyone should be here. It's just like a collaborative effort. Yeah, so
okay, go.
No, yeah. Okay, so I think if I am supposed to say something, I would just say that based on my experiences where I organized other conferences that were maybe equally good, but that, collaborative spirit that driven us, and I would very much, I would like to thank Ruri and Lavinia. I think it was really a pleasure that we could work together. And I think what we achieved is maybe kind of, we connected the bubbles, so to say. I think if you think about how the law is also studied today, so you have competition scholars, rule of law, democracy people, IP scholars, they are not necessarily interacting. And I think that was a high asset of this conference. But I really have nothing really more to say. And yeah, please come over. Yeah.
Like I would just add, thank you to everybody for coming. Normally this would be the time when somebody would summarize all of the conclusions of the conference, but I'm not even remotely brave enough to attempt a conclusion of the last conference, so I'm not going to do it. And it also kind of feels like an Irish goodbye, where you're saying goodbye for about 1 hour until someone's brave enough to actually leave. Most of them, but there's still coffee outside for another 20 minutes and some sugary products. So I'll be just very, very quick. Like on a personal level, it is really nice as a feeling to be working with such a great group of people like Lavinia and Maciej and Tomasz Wadyński. Thank you very much, and everybody who helped to make the conference a success, and then for it to be over, and to realize that it was a success, and to feel give ourselves a pat on the back and go like, we did that, it worked. Our speakers were absolutely fantastic. Thank you to everybody who came to Warsaw and joined us, and to our speakers who joined us. I know they had some difficulties and they weren't able to, and thank you as well. We still have our keynote speaker from yesterday, Madam Vera Jourova is still here. Thank you very much, and to all of our keynote speakers and other speakers. It was really fantastic. And I would just make one maybe final comment, because I'm not going to give any summaries on the conference, but I will make a correction. Yesterday in the opening, I said that if this conference had taken place 20 years ago when Irena Wiśniewska-Białecka was on the court, and if she had participated in a conference, that we would have been asking similar questions but having different discussions. And after hearing all of the panels for the last 2 days, I'm not entirely sure that it would be all that different. And maybe it's simply that the internet has provided a different lens through which to discuss the same kinds of issues that we've been talking about as a society forever. Like, that's what I took from it. And I thought that was a really interesting kind of revelation. So thank you, everybody. I don't know, would you like to continue the Irish goodbyes, Tomasz? While we're here,
I just wanted to reiterate one more message from the foundation, that we are very eager to support all people of good faith and goodwill with a view to build up this part of the civil society, which is based upon two realms of law, dear to Irena Wiśniewska. And also, I think that if ever this conference, in fact, was possible to be organized, it is certainly thanks to Lavinia, Professor Bernard and Rudy. And working with them, to me, it was only a pleasure. And I think that we shall continue. And I think that we shall somehow build up a name for the foundation. That was the very first event we have organized. And it wasn't easy. It took some time to first collect the works, to be prized by the jury, then to organize this conference, which in fact we did. You know, sometimes you build something with pliers and a hammer and then it flies. And so I have exactly the same sort of feeling today, that we have achieved something with quite, so to say, little means. And to me it was of a value. I do hope that it was of a value for you. And we shall see how we shall be able to somehow make it wider, more popular, and in fact common sort of a task, because I mean what we have in front of us is a problem which concerns all of us, and I think that given the circumstances around, this is the last moment that we can really get still mobilized and maybe produce some sort of a force to strike back the empire. Thank you.
So that concludes everything. One final point. Make sure, if you haven't already, to follow the Irena Wiśniewska Foundation LinkedIn profile to keep up to date on initiatives. And the very, very last thing, congratulations to the winners of the very first Irena Wiśniewska Prize. Joanna Wiśniewska here, or Brooke. Is Claudia still here? I think she's not, but can we give them one more round of applause? Because they're now the spokespeople for the foundation for the next 12 months. And do follow the profile, because the next edition of the competition will be announced later this year, and this is open to academics who have published works in IP law and competition law. So this is relevant for lots of people. So, you know, keep in mind yourselves, your students, people who in the future are planning to do these things. So thank you very much once again. There's still some coffee left. Enjoy the rest of your weekend.
I would just say that Warsaw is a fascinating city, particularly at night. So if you need any tips, approach us. So yeah.